All right, I believe that we are ready at this time. And I'm going to start by announcing myself and asking council to place your name on the record. Good morning. It is November 13th, 2020. I am Betty R. Widgeon, and by the September 17th, 2020 order of the Michigan Supreme Court, I was appointed master to hear the JTC formal complaint number 102. Council, please place your name on the record.
Good morning, Your Honor. My name is Laura Weingarten. I am one of 2 disciplinary counsels.
Thank you.
Good morning, Your Honor. Donald Campbell on behalf of Judge Bruce Morrow. My co-counsel is Liz Jacobs, who is also on the Zoom.
All right, thank you.
And I am Lynn Helland. I am disciplinary co-counsel with Ms. Weingarten.
Thank you. All right, at this time, my understanding is that there will be an opening statement by the disciplinary counsel, but I believe beforehand, is there something that needs to be placed on the record? Ms.
Yes.
Weingarten?
Yes, I would like to move to admit exhibits before I begin my opening statement. May I begin?
Yes, you may.
By stipulation, we are agreeing to introduce exhibits 2 and 4. Exhibit 2 is the request for comments, questions, and Judge Morrow's answers. And exhibit 4 is the 28-day letter statements and Judge Morrow's responses. Is that correct, counsel?
That is correct, and I believe Exhibit 2 is partially redacted by agreement.
That's correct.
I have no objection.
All right, thank you. They are admitted.
The disciplinary counsel also moves to introduce exhibits 10 and 11, subject to Your Honor's decision yesterday. The exhibits would be admitted only for the limited purpose of demonstrating guidance regarding inappropriate sexual language that respondent had previously received.
Thank you. Any comment from respondent?
Your Honor, obviously we have made our objections previous and they've been ruled on. I appreciate that, but I'm not in a place to stipulate, obviously, but I understand
Certainly.
the ruling of this
All right.
amendment.
Thank you. Disciplinary counsel's exhibits 10 and 11 are also admitted. Subject to the limitations that I listed in the decision that counsel have.
I have no other preliminary matters.
All right, thank you. At this time, then, Ms. Weingarten will go ahead and hear your opening statement. I did hear that your first witness is in the waiting room, and once you are done with that, I will admit that witness. Go ahead.
Thank you.
One moment.
And I apologize. 2 other items very briefly. Number 1,
Certainly.
I'm going to sit down. When I do that, I'll leave the viewing area of the owl. When I stand up, I will be in view. You will hear me, obviously, whether I'm sitting or standing, and trust me, I will be standing if there's a reason to be heard. So I hope that's okay with Your Honor.
That's fine with me. Thank you.
Thank you. And then lastly, there was an amended complaint filed in this matter.
Mm-hmm.
There is not an answer to the amended complaint. The amendments were chronological. They were time related only.
Right.
And counsel for the JTC, the disciplinary counsel, and I discussed that and found there was no need to amend the answer because no substantive changes were made. I just wanted to make that record.
Thank you for saying that. I did see the amended answer. The amended complaint. I did note that there was not another answer, and I understood because of the amendments that was probably the reason. We had a conference, must have been Thursday or Friday of last week, and that was not brought up. So that was still my assumption, but thank you for clarifying that, Mr. Campbell.
Thank you very much. I'm going to put my thing on mute here. Thank you.
All right. Thank you. Ms. Weingarten, anytime you're ready.
Thank you, Your Honor. Good morning, Your Honor. My name is Laura Weingarten, and I am one of 2 disciplinary counsel who may appear during this hearing. We are here today because Judge Morrow violated the Michigan Code of Judicial Conduct and the Michigan Court Rules. Here is what we expect the evidence to show. Between June 10th and June 13th of 2019, the Wayne County Prosecutor's Office was prosecuting a serious homicide case People versus James Matthews. This was a stressful, high-stakes case because it is likely that Matthews was a serial murderer. The case was assigned to Judge Bruce Morrow. The prosecutors on the case were two females. Ashley Chiffone was 33 years old at the time and had been a prosecutor for about 7 years. Ms. Chiffone had participated in a trial almost 10 years earlier when she was an intern as second chair before Judge Morrow. But other than that, she had no prior relationship with Judge Morrow until the Matthews case. The second chair of this trial was Assistant Prosecutor Anna Bickerstaff. She was 27 years old at the time this trial was commenced, and she was a prosecutor for only a year and a half. She had never met Judge Morrow prior to her involvement in the Matthews trial. Both of the assistant prosecutors are hardworking and diligent people and prosecutors. They asked Judge Morrow at the beginning of the trial if he would be willing to give them feedback on their performance so that they could improve their skills. I want to give you a timeline of how the trial transpired. On June 10th, they did jury selection, opening statements, and some testimony was taken. On June 11th, more testimony was taken. On June 12th, the rest of the testimony was taken, closing arguments were completed, jury instructions were given, and the deliberations had begun. On June 13th, the jury deliberated and eventually hung. A mistrial was declared, and it is set for trial sometime after the pandemic is over. Judge Morrow committed the misconduct that is charged in the complaint on June 11th and June 12th. During the trial, Judge Morrow did not treat Ms. Chiffone very well. His mistreatment of her is not charged misconduct, but I'm mentioning it because it is a very relevant to part of his defense to the misconduct that is charged. He criticized her in front of the jury and unreasonably limited her freedom to try the case. At one point, outside the presence of the jury, he told Ms. Bickerstaff that she should find another assistant prosecutor to mentor her because Ms. Chiffone wasn't very good. And he said that while Ms. Chiffone was present and listening. On the other hand, Judge Morrow treated APA Bickerstaff very well during the trial, at least until the afternoon of June 11th, and he provided feedback. APA Bickerstaff did the direct examination of an evidence technician, and as many young new trial attorneys do, she started many questions with the word and or okay. Judge Morrow, on his own, brought that to her attention privately, and she appreciated his feedback. Later in the day, Ms. Bickerstaff did the direct examination of the medical examiner. After the medical examiner testified, the defense attorney, whose name is William Noakes, asked for a break so that he could talk to his client about whether or not his client should testify. During the break, which was 5 minutes long, Ms. Chiffone went to the restroom. During the break, Ms. Bickerstaff stayed at the prosecution's table. And she asked Judge Morrow whether she had done better with the medical examiner than with the evidence technician. At the time she asked the question, she was seated behind the prosecutor's table. There were 3 chairs in a row. All the arms of the chairs were touching, and it was pretty crowded. To her left was now Lieutenant, he was a sergeant then, Derek Griffin. He was the officer in charge of the homicide case. To her right was the empty chair that Ms. Chiffone had just vacated. From the bench, Judge Morrow said words to the effect of, "I'm going to come down there to talk to you because what I have to say could make you blush." He then came down from the bench, sat in the chair that APA Chiffone had been sitting in, and sat right next to Ms. Bickerstaff. He didn't move the chair away. He didn't move it to the other side of the table. He sat right next to her. The arms of their chairs were touching, and his head was very close to her head, and he began to have what he said would be a private conversation. While right next to her, Judge Morrow looked Ms. Bickerstaff in the eye and said the following things to her, which he admits to saying. When a man and a woman are romantically close, what does that lead to? So when a man and women are close, they start holding hands, rubbing elbows, kissing, foreplay, and then that leads to sex? The cause and manner of death should be the climax of the medical examiner's testimony. You start with all the information from the report, all the testimony crescendos to the cause and manner of death, which is the sex of the testimony. You want to tease the jury with the details of the examination. The climax of the testimony from the medical examiner should be the cause and manner of death. Ms. Bickerstaff felt very uncomfortable as Judge Morrow said these things to her. She felt frozen and powerless. And although she knew it was wrong for him to talk that way to her, she did not feel she could object or stand up and walk away from the discussion because he's a judge and she's a new prosecutor. We know Judge Morrow said these things for several reasons. First, Ms. Bickerstaff reported that he did, and she reported it that very day. Second, Judge Morrow admitted that he said them. Also, there was a courtroom prosecutor named Joseph Curley. He was regularly assigned to Judge Morrow's courtroom, and he was in and out during the trial. He heard Judge Morrow tell Ms. Bickerstaff that he would say something to her that would make her blush. And then he saw Judge Morrow sitting in the chair next to Ms. Bickerstaff with the arms of the chair touching and their heads very close together as they talked. Lieutenant Derek Griffin, who was the officer in charge and sitting in the chair to the left of Ms. Bickerstaff, also heard some of what went on. His memory of the conversation isn't very good, but he does remember that the conversation was about sex. He was interviewed after the conversation, and he reported that he heard Judge Morrow say something like about a man and woman getting together and to building a crescendo. He thought the judge was very unprofessional and that the conversation was embarrassing to Ms. Bickerstaff. As I said, Ms. Chaffone during this conversation had gone to the restroom, and when she returned, the conversation was still going on. She saw Judge Morrow sitting in her chair. He did not get up when she approached, and so she sat behind him and Ms. Bickerstaff. She noticed there was not much space between Judge Morrow and Ms. Bickerstaff. The arms of the chair were touching, and Judge Morrow's eyes were locked into eye contact with Ms. Bickerstaff. She overheard Judge Morrow say, "The cause and manner of death is like the climax." Judge Morrow's statements to Ms. Bickerstaff are the reason we have count one. Your Honor will have to decide whether in Judge Morrow's words in context and in the way he delivered them were respectful and courteous as required by Canon 2B and 3A14, whether they were dignified as required by Canon 3A3, and whether he observed high standards of conduct as required by Canon 1. The day after Judge Morrow explained the climax of testimony to Ms. Bickerstaff, so now we're on June 12th, while the jury was deliberating, Judge Morrow invited Ms. Bickerstaff, Ms. Chaffone, and defense counsel Mr. Noakes into his chambers. They were there for about 2 hours and had a very lengthy conversation, during which Ms. Bickerstaff and Mr. Noakes said very little. The conversation was really between Judge Morrow and Ms. Chaffone. During that conversation, Judge Morrow talked about Ms. Chaffone's presentation of the evidence, and they disagreed about a few issues, including whether the evidence had established non-consensual sex with the now deceased victim. During that conversation, Judge Morrow talked about Ms. Chaffone's own personal biases and experiences with non-traditional sex. He laughed or joked about the defendant's testimony and the size of the defendant's penis, which Judge Morrow called a dick. He used the word fuck during the conversation to describe what the defendant had done to the victim. Judge Morrow also criticized Ms. Chaffone's voir dire, and to illustrate his point, he explained this. If I want to have sex with a woman on the first date, how would I figure that out? I wouldn't ask if she wants a family or children or what she does. I would ask her, have you had sex on a first date before? Would you sleep with me on a first date? Again, we know that Judge Morrow said these things for multiple reasons. Ms. Chaffone and Ms. Bickerstaff heard him say that. Also, Judge Morrow admitted that he said or probably said some of them, such as the word fucked and his philosophy of voir dire. Just as Ms. Bickerstaff felt offended but powerless in the courtroom the day before, both Ms. Chaffone and Ms. Bickerstaff felt offended and powerless in the chambers. They felt they were unable to object. They were well aware that Judge Morrow had held a defense motion for directed verdict in abeyance, and they didn't want to make Judge Morrow angry such that he granted that motion, which would have dismissed their case. They were protective of their case. And they both felt uncomfortable confronting a judge about his use of inappropriate words. Your Honor, the questions you will have to answer in count 2 are the same as those raised by count 1. Whether Judge Morrow's words were respectful and courteous as required by Canon 2B and 3A14, dignified as required by Canon 3A3, and whether he observed high standards of conduct as required by Canon 1. Count 3 is based on Judge Morrow's words and actions during a third conversation later in the day on June 12th in the courtroom as the jurors were either entering or leaving the jury box. Judge Morrow came down toward the prosecutor's table and overtly eyed the bodies of both of the women. While there, he asked Assistant Prosecutor Chiffone how tall she was and how much she weighed. He asked Ms. Bickerstaff whether she weighed 115 pounds. And when Ms. Bickerstaff responded, he said, "Well, I haven't assessed your muscle mass yet." Judge Morrow denies that he eyed the women's bodies, but he acknowledges that he spoke the words. In addition to resolving the factual dispute created by Judge Morrow's denial, Your Honor, the questions you will have to answer in count 3 are similar to those raised in counts 1 or 2, with some additional conclusions of law that must be made. Whether Judge Morrow's words in this case, his actions, were respectful and courteous as required by Canon 2B and 3A14, whether they were dignified as required by Canon 3A3, and did they create the appearance of impropriety as forbidden by Canon 2A. Furthermore, you will decide if he violated Michigan Court Rule 9.202B1D, which forbids treating a person discourteously because of a person's gender. You will also have to determine if Judge Morrow's conducts in count 1 through 3 were a persistent failure to treat Ms. Bickerstaff and Ms. Chiffone fairly and courteously in violation of MCR 9.202B1C. Your Honor, the burden of proof in a judicial disciplinary proceeding is preponderance of the evidence. We are certain at the end of the case, you will find that the evidence shows by more than a preponderance that Judge Morrow's words and actions during the Matthews trial violated the canons and court rules as charged in the complaint. Thank you.
Thank you. At this time, you are ready to call your first witness, is that correct?
Yes, Miss Ashley Chiffone.
All right, I will have her come in just one moment. Let me ask you with respect to, we've already addressed the issue of the sequestration and the protocol amended order that I sent to counsel. I am going to read some of that information into the record and have the witness, as a part of the oath that is given, that the witness state that all of the witnesses, that they are aware of that and that they are willing to abide by those orders. So just to let counsel know, that's the plan. All right, if we're ready, then we will bring in Ms. Chiffone. I'm admitting her at this time. Good morning. I see the video. Please unmute your video, Ms. Chiffone.
Thank you.
Thank you. All right. So, Ms. Chiffone, my name is Betty Widgeon. I am the appointed master in this particular case, and we will start with me swearing you in. I am going to give you the oath, and then I'm going to give you information about the sequestration order and the hearing and witness protocol, just to make sure that you have seen those and you are agreeing to abide by those also. At this time, I will ask you to raise your right hand, please, to be sworn in. Do you swear or affirm that your testimony today will be the truth, the whole truth, and nothing but the truth? So help you.
I do.
Thank you. I'm going to also ask you with respect to the sequestration order. I will read that. By stipulation of the parties, the master ordered that witnesses who may be called by either party at the formal hearing are subject to this sequestration order and are hereby ordered to be sequestered during the proceedings once they begin on today's date. This order and sequestration will remain in effect until witnesses are released from it by the master or until the proceedings before the master conclude. To be clear, this means that the order remains in effect even after a witness testifies, unless the witness is released by the master. Sequestration includes a prohibition on any witness, except while testifying via Zoom during the proceedings, from discussing his or her testimony in any format or by any means with another witness, from viewing the proceedings on any device, from listening to the proceedings on any device, and from assessing or viewing any information about the proceedings via any social media or news outlets. Potential witnesses may discuss the pending formal complaint with counsel for the parties and may be shown exhibits by counsel prior to their testimony. A failure to Let me go back. The next paragraph was, it is the duty of counsel for the parties to serve a copy of this order on all potential witnesses to the proceedings on or before 9 a.m. November 13th, 2020. A failure to serve the order by any party or violation of the order by a witness is grounds to exclude a witness or to exclude testimony given by the witness prior to discovery of the failure or violation. So, Ms. Chaffone, are you aware of the sequestration order?
I am.
All right. And do you swear or affirm that you will abide by that order?
I do.
All right. Thank you. There was another order with respect to hearing and witness protocol. And that order was signed on November 11th. Counsel shall conduct a pretrial test of the Zoom platform with their witnesses to ensure that witnesses will have a sufficient internet connection to minimize any technical issues during the trial. For witnesses, witnesses shall certify that they are alone in the room where they testify or identify all individuals present during an examination. No witness shall have access or review off-screen any documents or other materials beyond the relevant trial exhibits, pleadings, or transcripts before, during, or after their testimony until the trial is over. Counsel will have access to Zoom's platform to share screen and function. Counsel shall use that function for any witness who does not have a hard copy of the exhibits required during their testimony. Witnesses shall certify under oath that no one has given them information by any means that counsel and the master cannot observe to assist in testifying. Devices that witnesses use to testify, for instance, laptops or iPads, must have all notifications, including emails and text, turned off until the testimony is finished. Witnesses shall not have access to other devices such as cell phones, other laptops, iPads, smartwatches, or similar devices during their examination. Counsel must disclose, well, this is to counsel specifically, but to disclose whether they intend to examine a witness remotely or if the attorney will be in the same room with the witness during the examination and present during opposing counsel's cross-examination. So with respect to those items that are referring to the witness, are you aware of this order, Ms. Chaffone?
I am.
All right, thank you. And do you swear or affirm that you have abided by this order and will continue to abide by this order until otherwise released by the master?
Yes.
All right. With respect to your room right now where you are, is there anyone else in the room with you?
No.
All right, thank you. At this time, counsel, I believe we are ready for the direct examination of this witness.
Good morning, Ms. Chaffone.
Honor, if I may, briefly
All
apologize.
right,
Campbell.
one moment.
We
Mr.
are-
Campbell, if you will stand so I can see you.
Yeah, if I
Oh,
talk.
there you are. I see you. I see you now. Go ahead.
Thank you. I stand and I talk because I think we're having some technical difficulties here. Judge Morrow's computer, you were freezing on his screen. I'm going to have him leave the computer open and hopefully he's not freezing on your screen. So you'll still be able to see him. But if for any reason he falls out of view, it's only because we're trying to fix the screen.
All right, thank you. Let me ask the question before we continue. Was I freezing on anyone else's screen? Ms. Weingarten, on your screen?
No.
For the court reporter?
No, Your Honor.
All right, thank you. Thank you for making me aware of that, Mr. Campbell. And the judge was not freezing on my screen, so we will pause if there is a problem. Thank you. Ms.
Thank you.
Weingarten?
May I begin my direct examination?
Yes, please.
Good morning, Ms. Chaffone.
Good morning.
Tell the judge your whole name and your occupation.
Ashley Elizabeth Chaffone. I am an assistant prosecuting attorney at the Wayne County Prosecutor's Office.
And were you employed there in June of 2019?
Yes.
How long had you been a Wayne County prosecutor?
I interned there starting in August of 2009, and then I was hired on a contract there as a prosecutor in May of 2012.
So back in June of 2019, how long had you been a hired prosecutor, an APA?
My math is awful, but I would say that that would have been in 2019. I would have started in 2012, so 8 years.
Okay. And may I ask how old you were in June of 2019?
I would have been 33.
Okay. Were you assigned to a special unit in the prosecutor's office?
I was.
What unit was that?
The homicide unit?
Before your involvement in the homicide unit, did you know Judge Morrow?
Yes. Professional.
How did you, go ahead, how did you know him?
Just from having worked at the building, I had done actually my first jury trial in front of him as an intern. And then I had a couple of cases pending in front of him at the time.
Did you and he seem to have a good relationship up until the Matthews trial?
Yes.
Okay. What is the name of the case you were trying in front of Judge Morrow in June of 2019?
People versus James Matthews.
And was that a homicide?
Yes.
Can you tell the judge very briefly what the case was about?
It was a cold case from 2003 in which the allegations were that the defendant had murdered a woman that was a known prostitute drug user. There was evidence that the body had been drugged from a house associated with the defendant down the porch and left at the front lawn of that residence, essentially.
Did the case involve any sort of sexual activity?
There, not in the charges itself, but the circumstances surrounding her death. There was a rape kit done, and there was some evidence of DNA with regards to a possible sexual encounter.
Did you have a co-counsel?
Yes, Anna Bickerstaff was second chairing at the time.
And was she a more junior prosecutor than you?
Yes, very much so.
Did you have an officer in charge?
We did.
What was his name?
Sergeant Derek Griffin, excuse me.
And do you know from what department he was?
Detroit Police Homicide.
Did you have motions prior to the start of the trial?
Yes.
And did you argue some of those motions?
Yes.
Who was the defense attorney?
Mr. William Noakes at the trial stage. Prior to that, at the exam stage, it was Mr. Wyatt Harris. And then after the exam, but I think prior to possibly the arraignment on the information, I believe that Mr. Noakes came into the case.
Okay. Was this trial held in the Frank Murphy Hall of Justice?
Yes.
And was it held before Judge Morrow as the presiding judge?
Yes.
Do you know what date the trial started?
On June the 10th of 2019.
And do you know when the trial ended?
The verdict came in on June the 13th of 2019.
Now, was there a court reporter present in the courtroom?
Yes,
Do you know his name?
Sean Allen.
And do you know whether or not he had been Judge Morrow's long-term court reporter?
For all of the occasions that I had been in there, that was what my understanding was. Yes, I'd seen him in there several times.
Have you reviewed the trial transcript in the case of People versus James Matthews?
I have.
Did the court reporter take down everything that was said?
No.
Tell the judge how you know that.
There were points in time during the trial where, and I'm not exactly sure what it's called, but Mr. Allen is the type of court reporter that puts it up by his face instead of typing it out as he goes. And you could see at points during the trial where I thought we were on the record that he'd have his mask down. So I wasn't certain if he was still transcribing. And then when I read the trial, there were things in there that I recalled happening that I did not see in the transcript itself.
Now, before the trial started, you said you had some limited contact with Judge Morrow. Is that right?
Yes.
Did you have any sort of personal relationship with him or friendship?
I wouldn't say that, no.
Do you know his wife, who is a criminal defense attorney?
I know of her from just having worked in the building, but I've never had any cases with her. No.
Did you have any sort of personal friendship with her?
No, I don't have any issues with her, though. She seemed very nice in all the times I've dealt with her.
Okay. So during your pretrial matters and the prior cases that you've had in front of Judge Morrow, how did you and he get along?
Well.
Okay, no problem at all?
No, professional.
Okay. During the trial, how did you and Judge Morrow get along?
I would say that we got along fine. It seemed as though it seemed as though something had changed.
And what made you conclude that?
His attitude towards me, I would say.
Describe what his attitude was like.
He seemed, I would say, more, what would be a good way to describe it? Less patient, I would say, potentially, and seemed very critical.
Was he critical of you in front of the jury?
There was a point in time that I recall in the transcript, but I'm not certain if the jury was there, so I'm not sure.
Was he critical of you in the open courtroom, whether or not it was on the record?
Yes.
And in what ways was he critical of you in the open courtroom?
There were some, there was at one point early in the kind of trial, and I'm not entirely certain which day, it may have been on the 10th, I had asked for some feedback from him, and there was kind of a discussion surrounding that.
Why did you ask him for feedback?
I do that with most of my cases that I do. I'll talk to the judge. I'll ask the judge in advance for feedback after the case isn't resolved, just to kind of figure out what I can do better, how I could improve. And
so you do that routinely?
Yes.
Did Judge Morrow, was he willing to give you feedback?
I wasn't certain based on the conversation. I had approached the bench or the kind of the clerk's area in front of the bench, and I had asked if at the end of trial, at the conclusion of the case, if he could give us, meaning myself and Ms. Bickerstaff, some feedback or some tips about things we could have improved on, or things of that nature.
And what did he say to you?
He said that I wasn't tough enough for feedback. And I responded back and I said, "I'm tough enough, Judge." And he said, "You're not tough enough for feedback." And then he directed the question to Ms. Bickerstaff. And he said, "Ms. Bickerstaff, do you think that she's tough enough for feedback?" And Ms. Bickerstaff responded, and she said, "Yes, Judge, I think she's pretty tough." And he said, "I don't know." And I said, "Judge, is it going to be like really ruthless?" And he shrugged his shoulders and said, "Maybe." And I said, are you going to say I'm like the worst prosecutor you had in your courtroom?" And he just shrugged his shoulders. And I said, "Well, I would still appreciate the feedback." And that was the end of the conversation. And I thought at that point that he wasn't going to give any feedback.
Okay. Were you in a position to observe his relationship with Miss Bickerstaff?
Yes.
What did you observe?
He seemed, I would say, very pleasant to her. I think very, I would say very interested in maybe trying to help her learn.
And what was it about his behavior that made you think that?
He had brought up at one point, I don't know if I was in the courtroom or not, but it had been brought to my attention that he had kind of corrected her, kind of wanted to point out to her that she was saying and okay a lot.
Did Miss Bickerstaff appear to appreciate the feedback from Judge Morrow?
At the beginning, yes.
Okay. Now, who questioned the evidence technician by the name of Stinson?
Deborah Stinson, that would have been Anna Bickerstaff.
Can you describe for us the courtroom? Describe the prosecutor's table and who was sitting where.
So we had myself, Miss Bickerstaff, and then our officer in charge of the case. So typically, if you have a case where you have 3 people, you kind of have to creatively set up where everyone is going to sit, because the defense and the defendant sit on the opposite table. And so the way that we were seated on this occasion was, so if the podium is in the center, then the prosecutor's table, if I'm looking at the judge, would be to the right-hand side. And the first seat next to the podium would have been our officer in charge, Sergeant Griffin. Then the middle seat would have been Miss Bickerstaff. And then I was on the seat at the end closest to where the jury box would have been.
Did that leave much room for anything else at the table?
No, we were jam-packed. And some courtrooms allow, most courtrooms would allow the officer in charge to sit sometimes on like the other end of the table. But the judge wanted us kind of all in a row.
Do you know if the arms of the chairs were touching?
They were. They had to fit inside of the table area.
Okay. And now describe what would be on the other side of the podium.
The other side would have been the defense table. So to the left of the podium, the first chair, I don't recall if Mr. Noakes was sitting in the first chair next to the podium or if he was in the second chair next to that one. He was seated in one of those 2 chairs, and then across from him would have been the defendant, Mr. Matthews.
Okay. During the trial, did you and Miss Bickerstaff share the duties of direct examination?
I did the majority of the witnesses. Miss Bickerstaff did do some officer witnesses, and the identification witness, the victim's sister. So I don't know if it was not a 50-50 split, no.
Who questioned the medical examiner?
Miss Bickerstaff.
And were you present while that occurred?
I was not, actually, no. I was present. I was in and out, I would say.
Can you explain to us why you were in and out?
So we had initially, when we had scheduled the trial, it was scheduled for a bit longer. So some of the witnesses, specifically the medical examiner, was traveling from out of state. We were kind of planning on putting him on the next day, but we were moving much more quickly through the trial than we had anticipated. And so during my witnesses, some of the time, Anna was out in the hall making sure we were lining up other witnesses because we didn't have all the people there at all the times necessarily that we needed. And then at some points during Anna's testimony, or a lot of the times during Anna's witnesses, I ran out and I was in the witness room trying to coordinate getting people there. So there was, at the very beginning of when she started the testimony of the medical examiner, I was in the room, and then I left partway through, and then I came back at the very end of it.
Did Judge Morrow give you any trouble about the fact that you didn't have your witnesses lined up and ready to go?
Yes.
Tell the judge what happened.
Judge Morrow had said at one point, there was some off the record conversation about it, some on the record conversation about it. Judge Morrow had indicated that if we didn't have our witnesses there, that he would dismiss the case.
Did the trial move fast?
It did. It moved very fast. There was also a point in time where the jury was present and I asked for 5 minutes to go out in the hall and see, or in the witness room to see who I had present. And the judge had kind of posed the question to the jury, like, do you all think we should give her 5 minutes? What do you think? Do you, she's going to keep you here waiting. What do you want to do?
Have you ever seen another judge ask the jury whether or not a prosecutor could have 5 minutes?
No,
Did the jury respond to him?
I don't remember. I don't believe so.
All right. After the medical examiner testified, did you call other witnesses if you recall, or did you rest your case?
No, we called other witnesses. We put in, I want to say we put up 12 witnesses on the 11th, which is a lot of witnesses.
So you moved fast.
We moved very fast, yes.
Did there come a time when there was a break because Mr. Noakes wanted to talk to his client about whether to testify?
That would have been towards the very tail end on the 12th. Yes.
Okay. So on the 11th, did you take a break in the afternoon and did you leave the courtroom to use the restroom?
Yes.
Do you know what time of day that happened?
I don't.
Okay. When you left the courtroom, where was Miss Bickerstaff?
She was either standing or seated. She had just finished questioning the medical examiner.
And where was now Lieutenant, formerly Sergeant Griffin?
He was seated at the prosecutor table in his same seat closest to the podium.
Do you know where Mr. Noakes was?
I don't know if Mr. Noakes also went to the bathroom when I went. I can't say.
Do you know for how long the break was?
Not long.
Can you estimate how long?
5 or 10 minutes, maybe.
When
Or
you
supposed
returned,
to be 5 or 10 minutes. I'm not sorry to cut you off. It was supposed to be a 5-minute break. And I don't know if it went over it definitely went over 5 minutes. It may have been 10 minutes or so.
okay, when you returned to the courtroom, what did you see?
When I returned into the courtroom, I saw Judge Morrow seated in the seat that I was sitting in at the prosecutor's table. And he was seated very close to Miss Bickerstaff. The two chairs were touching. And they were both making eye contact with one another, talking very closely.
Have you ever seen a judge during a trial come down and sit at the prosecutor's table and talk to a prosecutor without the defense attorney being present?
No.
Do you know whether or not Judge Morrow invited the defense attorney into the conversation?
I have no idea.
When you saw that, what did you do?
I walked in and my thought was that they were going to end the conversation. We were going to get started because we were moving so quickly. So when I walked in, nobody had gotten up. Nobody turned around to look at me or anything like that. So I sat down in there's a bench right behind where the prosecutor and the defense table is. And it's where the attorneys typically will sit on just like a regular court day. And so I sat in the bench behind where the prosecutor's table was and waited for whatever was going on to end.
Can you describe how loud or how soft Judge Morrow's voice was as he was speaking?
I could only hear a little bit of what was happening. I don't recall his voice being raised.
How far were you from Judge Morrow?
I just as far as the bench was from the seat. So I would say a bit longer than maybe arm's length, maybe a couple of arm's lengths away.
And you couldn't hear him speak very well?
I could hear him make one comment, but I couldn't hear anything before that or anything that followed.
Can you describe how close his face was to Miss Bickerstaff's face?
I would say the two arms of the chairs were touching, and I would say that their faces were maybe like a foot away, a couple feet away.
Can you describe what their eyes were like?
They were making very close eye contact the whole time.
Did that strike you as odd?
Yes.
Why?
I'm going to object to the leading questions. There's been several in a row here, Judge.
Objection is sustained.
Can you describe what you were thinking when you came into the courtroom and saw what you saw?
At that point, I truthfully was thinking, we're rushing through this. So my thought was, what's going on? We're trying to move this trial along, and they're kind of just chatting or talking about, I didn't know what at the time.
Did you overhear anything that you could make out?
Yes, I heard Judge Morrow say that the cause and manner of death are like the climax.
At that time, did you have any idea what he meant by that?
No, I had no idea.
How did their conversation end?
I don't know if there was anything said after that. I couldn't specifically hear. There were a lot of people in the courtroom in general at that point in time. And at some point, the judge got up and walked back up to the bench, and Ms. Bickerstaff stood up. And I asked her, like, what was that all about?
You can't tell us what she said, but just answer this. Did she tell you anything about what it was all about?
Yes.
How quickly after she started talking to you about it did Judge Morrow start the trial?
We got right back into it once he got on the bench.
Did anything else unusual happen that day?
That day, I don't recall. There was a point in time, and I'm not entirely certain on the day. It might have been earlier on in the trial. On the first day, he did make a comment to Ms. Bickerstaff at one point off of the record saying something like, why are you doing this case with Ms. Chiffone? Like, you don't want to learn from her or something like that, something along the lines like that.
Did you hear that with your own ears?
Yes.
And why did he tell Ms. Bickerstaff that she shouldn't be doing this case with you?
I don't know.
Did he say anything about your performance or your skills?
Not up to, well, yes. I would say Mr. Noakes and it sounded to me as though it was directed at both Mr. Noakes and I. At one point during the trial, I want to say it was on the 11th, the judge, I think, was unhappy with the questioning that Mr. Noakes and I were doing of some of the witnesses. And he had made a comment that essentially that he didn't want to have to get involved, but that if Mr. Noakes and I essentially like couldn't get it together, that he was going to step in and I don't know what. So I knew there may not have been something directly said, but I could tell that he was not happy with my performance.
Okay. Now, on the 11th, let me go back. Do you know an assistant prosecutor by the name of Joseph Curley?
Yes.
Tell the judge who he is.
Professionally, I know him just through work. He's an assistant prosecuting attorney. He was the courtroom prosecutor assigned to Judge Morrow back in June of 2019.
What does it mean to be the courtroom prosecutor?
That is someone in the general trials unit is assigned to a judge on a daily basis. So any cases that are not specially assigned to prosecutors in different units are handled by the courtroom prosecutor. And that person usually stays in the courtroom from 9 until the docket will finish at whatever time. And they often will stay in the courtroom and observe during trials of special units sometimes because they have to always be there if things are happening in between trials.
Do you know if Mr. Curley watched any of your trial?
Yes. He did.
Yes, he did. Okay. And did he ever talk to Ms. Bickerstaff about what occurred when Judge Morrow was sitting at the prosecutor's table?
Yes.
Obviously, you can't tell us what he said because that's hearsay. Do you know was it the same day that Judge Morrow was sitting at the prosecutor's table or a different day?
The day Judge Morrow was sitting at the table and then also another day.
Okay. Now, at the end of the day, did you and Ms. Bickerstaff have any further conversation about what happened between her and Judge Morrow?
Yes.
Where did that conversation take place?
There was an initial conversation when Joe Curley approached her and I at the end of the court day, potentially even in the courtroom. I don't remember if it was inside the court, Judge Morrow's courtroom, or outside the doors, but before we had gotten onto the elevator. And then once we had gotten on the elevator, Anna and I, it was her and I alone, I said, like, what happened? And then she told me what had happened. She had told Joe Curley some of it in my presence based on a question he had asked her from some observations he had made. And I had her elaborate more when we got in the elevator.
Did the two of you discuss whether or not you should report this to anyone?
I told her that we just needed to get through the trial, that just like keep our heads down, like it's almost over, like just let's get through this.
Did you report it to anyone that day?
No,
Were you present when Ms. Bickerstaff reported it to anyone?
no, it was not my understanding that she had reported it to anybody as far as a supervisor, that she had reported it to a supervisor that day, but I don't know. Once her and I got off the elevators, she got off at the 11th floor and went to her office. I took the elevator up to 12. I went to my office, and that was that.
Okay. Did you then go home for the night?
Yes.
Did you return to court on June 12th?
Yes.
And did the jury eventually start deliberating on June 12th?
Yes.
During the deliberations, is it typical for prosecutors to stay in the courtroom or go to their offices and wait for the verdict?
It depends. A lot of times people will go back to their offices just because it can be a very lengthy process.
Did you and Ms. Bickerstaff stay in Judge Morrow's courtroom during deliberations?
When we could, yes.
And was there a time when Judge Morrow invited you all into chambers?
Yes.
Do you know what time of the day that was?
It would have been, it would have been the second part of the day. The jury had been deliberating because I know that when we left his chambers that day, it was to release the jury, which would have been at 4 or 4:30. So I would say this might have been 2 o'clock.
So when Judge Morrow invited people into chambers, who did he invite?
He didn't say by name. He said, "Come with me, little ones." And it was myself, Miss Bickerstaff, and Mr. Noakes.
How long were you in his chambers?
2 hours, probably.
During those 2 hours, did anyone interrupt or knock on the door?
At the end, I don't remember who, but one of the court staff or deputies knocked on the door, basically saying, like, we got to cut them loose for the day, the jury.
Okay. During the in-chambers meeting, you indicated it was yourself, Ms. Bickerstaff, and Mr. Noakes, and the judge. Was anyone else involved in that conversation?
No.
Who did most of the talking during the conversation?
The judge and I.
What was Ms. Bickerstaff doing?
Nothing.
What was Mr. Noakes doing?
Not much of anything either.
What were you and the judge talking about?
It started as he wanted to show me a court rule, or show Mr. Noakes and I, he had indicated a court rule. And then, in my opinion, it turned into a critique of how we put in the case, we being the prosecution.
Okay. So let me go back. During the trial, did Mr. Noakes make a motion for directed verdict?
He did.
Tell the judge what a motion for directed verdict is.
So a motion for a directed verdict is typically made by a defense attorney at the close of the people's proofs during a trial. They get up and argue that the evidence submitted or presented by the prosecutor up to that point is insufficient at this point for it to be given to a jury to even consider. So they ask the judge at that point, based on the insufficiency of the evidence, to dismiss the case.
Which prosecutor responded to that motion?
I did.
And did you cite the proper standard?
I thought that I did. I cited the standard that I had always cited, that I had always heard cited, which is that the court is to view the evidence in the light most favorable to the non-moving party, which in that case would be the prosecution, would be the non-moving party. And that was the standard. And then I had gone on to, argue what evidence was sufficient.
Did Judge Morrow rule on the defense motion?
He did not. He said he was holding his ruling in abeyance.
When you went into chambers and you said he was talking about the law, did he present to you a different rule?
Yes, he said to me when we got into chambers that he called us back there because he didn't want to dog me in front of other people, because he thought I would be embarrassed that I had misstated the rule.
What does it mean to dog someone?
To criticize or critique or...
All right. Now, before that, had he criticized or critiqued you or dogged you in the courtroom?
Yes.
But on this occasion, he said he didn't want to embarrass you.
Yes.
Did he show you a rule of law or a court rule?
Yes. When we walked in there, he, being Judge Morrow, had 2 books open. He handed one to Mr. Noakes and he handed one to me. And both of the books were opened to the same court rule, which was a Michigan court rule, regarding directed verdicts of acquittal.
Do you know the court rule number?
I want to say it's 6.419, I think.
And what does that rule say?
Essentially, it says that the judge has discretion to hold a directed verdict motion in abeyance and to issue his ruling at any time, even after the jury had rendered its verdict. And
at that time, how did you feel about the fact that he pointed that law out to you?
At that point, I had never seen that. So when I had read it, I didn't at that point have a response because I had never seen that rule cited. I was not familiar with it. And so then the judge had asked, like, do you know what that means? And I was kind of looking at it. He goes, that means I can dismiss your case at any time.
How did that make you feel?
Concerned.
Why were you concerned?
I felt as though, based on what occurred later on in the conversation, I felt as though I had to still convince him of our case.
Okay. How serious a case was this?
It was a first-degree murder. It was a cold case, so it had been one of the shelved rape kits. So in the rape kit project, where all of those kits were found in the storage that had been untested. So it was an old case, and the defendant was alleged to have not only committed this homicide, but to be linked to somewhere in the range of 10 other potential either murder, rapes, or murder, strangulation, CSC, or just criminal sexual conduct cases. So he was implicated in several very serious crimes.
So this was very serious to you?
Yes.
Okay.
All of my cases are very serious to me because they're all homicides.
Okay. So tell us about the conversation you and Judge Morrow had beyond the discussion about the motion for directed verdict.
After the motion for a directed verdict, the judge then brought up the issue of the DNA. So for most of the 2 hours that we were in the chambers, the conversation was directed towards me, and it was between Judge Morrow and I. So initially the conversation started with the DNA. The judge had said to me that he did not think that I should have put in the DNA, that the defendant wasn't charged with criminal sexual conduct, and so that it wasn't relevant. And that not only did I struggle my way through the testimony of the lab experts, but that it wasn't helpful. And so then at that point, there was an exchange between he and I. I had responded back to try and, I guess you could say, maybe convince him that the DNA was significant. And I had said to him at that point that, he had said, why did you put in that DNA evidence? It didn't matter. And my response back was, I thought that it was significant that there was DNA in the victim's oral swab and vaginal swab that was identified as the defendant, because it showed that they had close recent contact near in time to the homicide. So I thought that it was very significant evidence, despite the fact that there hadn't been a charge of criminal sexual conduct.
And did Judge Morrow disagree with you?
Yes, absolutely. It went back and forth. The judge would say kind of why he thought that it was not significant or important or a mistake to have put it in my case. And then I tried to, respond back and try to convince him, I guess, and say, well, Judge, what about this? Or, Judge, this. And it kind of went back and forth. And I could tell as the conversation continued on, he was getting more and more frustrated with me.
Okay. Did he raise his voice?
Yes. As the conversation went on.
Did he use any profanity?
After we had kind of gone back and forth about the issue of DNA, it seemed as though he wanted me to, in my opinion, it seemed as though he wanted me to agree with what his position was. And when I wasn't, he was getting more frustrated. And so at a point he said, do you want me to say what it was like really?
Yes, you're allowed to say the word. Yes.
Okay. So he had said, all it shows is that they fucked. That's all it shows, that they fucked.
Did he say the word fucked twice?
Yes.
Have you ever had a judge say that word in front of you before?
Not unless they were repeating testimony or no, not in that context, no.
Did you think it was an appropriate thing for a judge to say to an assistant prosecutor?
It surprised me or shocked me when he said it at that point.
Do you know whether Mr. Noakes or Ms. Bickerstaff had any reaction to it?
I don't know.
What else did you and Judge Morrow discuss in chambers?
There was some additional conversation about, and I think that this was maybe earlier on in the DNA conversation, but there was some conversation in one of my responses back to the judge. I had brought up some statements or some information that came out during the trial from the testimony of the defendant regarding the defendant's characterization of whether or not he had intercourse with the victim. One of my points when I had responded to the judge about why I thought that the DNA was significant was that we had written interview statements from the defendant where initially he indicated that he didn't know this woman, that she was nobody to him, and that the two had not had intercourse because she was a stranger. That statement eventually evolved into what he ended up testifying. He had made a second statement that evolved, and then he ultimately testified that this was the love of his life and etc. And so when I had said to the judge, one of my points was that the defendant denied that the two had intercourse, and that even when he had testified, he being the defendant, had said that what I thought when he and I were in chambers, I said that I thought the defendant had used the words non-traditional sex, which I since have read the transcript, and those were not the words the defendant used. He said not normal, I think was what the defendant said, not normal sex during his testimony. When we were in chambers, though, I think that I may have supplied the word, I'm not certain, brought up that he claimed it was non-traditional sex, but that the DNA was in very traditional areas for someone that claimed to not have had intercourse with the victim.
Did you and Judge Morrow then have a discussion about what non-traditional sex was?
Yes.
Tell us how that transpired.
So the judge had asked me what my definition of non-traditional sex was, and I said not intercourse. And the judge had said that my interpretation of non-traditional sex was shaped or formed by my own bias and inexperience. And he had said that what the defendant in his mind had meant by non-traditional sex was just not missionary, not in the typical way. And then he went on to kind of say he meant doggy style, and then he named some other stuff.
Did Judge Morrow use the words doggy style?
Yes.
Did you feel that that was an appropriate conversation in light of the subject matter you were talking about?
It just felt like everything kept, no. At that point, I don't know that at the point in time that this was happening, I hadn't thought about whether it was appropriate or not, truthfully. At that point, my focus was just trying to convince him that the DNA was significant.
With hindsight, now that you've had time to think about it, do you think it was appropriate for him to say things like that to you?
No.
I'm going to object. I don't know the relevancy of her hindsight here. And really, it's nothing more than giving the opinion of others who've since given her an opinion on what they think.
Is there a response?
Yes, Your Honor. One of the things Your Honor has to decide is whether the judge's words were respectful, courteous, and dignified. And her opinion of how it felt and sounded to her at the time after thinking about it is relevant to your interpretation.
No, her
Campbell.
opinion at the time is relevant, and she said she didn't think about it one way or the other. It's only afterwards that she has apparently given additional thought or consideration, and I'm going to posit prompted by others, that she's come to a different conclusion.
Well,
Thank
Judge,
you.
I object to him saying prompted by others. There's been absolutely no testimony that anyone prompted her.
Thank you, counsel. The objection is overruled. Continue, please.
Thank you.
Mr. Cohn? Okay, go ahead. You can answer the question.
What was the question again? I'm sorry.
With hindsight, do you think that his conduct, I mean, his words were appropriate and respectful and courteous to you?
No,
Explain to us why you feel that way.
because it felt like not just at that point in time specifically, but during the course of what felt like a very long time in his chambers, what turned out to be around 2 hours, it felt like every example that he gave always kept going back to sex or the way someone looked. It felt like they all kept every example or teaching moment he maybe tried to have about anything always went back to a sexual explanation.
Okay. Did he talk to you about your voir dire?
Yes. So there was a point in time, well, also, sorry, to go back, kind of the conversation that with regards to the positions and the non-traditional sex, there was also at the end of that, the judge had kind of said, I had responded back to what he had said about like the positions and whatnot. And I said, well, Judge, actually the defendant says in his statement that he couldn't penetrate her because she could have a miscarriage. And so then the judge at that point kind of like laughed and said, oh, so like what he said, like he's saying that like what he's working with or something along those lines was so big that it would cause a miscarriage. And I said, like, I don't know.
What was he referring to when he said what he was working with?
The defendant's penis.
Did Judge Morrow refer to his penis as any other word besides a penis?
I'm not certain, but it was the sentiment, yes.
Did he ever use the word dick?
He may have.
Your Honor, that's leading.
Objection is sustained.
Do you have in front of you a affidavit that you wrote as well as a memorandum of law that you wrote?
Yes.
Could you review it and tell us whether or not you wrote that Judge Morrow referred to it as a dick?
I'm going to object. There's no basis for that.
Your Honor, it's to refresh her recollection. She said she
But
doesn't remember.
said that she couldn't remember.
So she can use her notes and her affidavit to refresh her memory.
Again, she can refresh her memory when she says she can't remember. She hasn't testified to that.
Ms. Weingarten, do you have an additional question before? Would you rephrase your question, please?
Okay, Ms. Chaffone, do you remember whether or not Judge Morrow used the word dick referring to Mr. Matthews' penis?
I don't remember.
Do you know whether or not you wrote anything about that in your affidavit or in your memorandum?
I did.
Would it help if you refreshed your memory by reading those documents?
Yes.
Okay, Judge, could she have a moment to look at those?
Certainly.
And by the way, Ms. Chaffone, do you have those in front of you here today?
I do, Exhibit 7 and 9.
Okay.
The words I used were, he claimed that what he was working with would cause a miscarriage.
Okay. And you interpreted that to mean his penis?
Yes, he may have used another word, but the sentiment was, regardless of the word, was penis.
Was the conversation about causing a miscarriage done in a professional manner, or was it made fun of?
It didn't seem professional, no.
Why not?
Because the whole tone of everything that had gone on back there, in my opinion, in chambers did not, in hindsight, it was not professional.
Was there any discussion about the size of the defendant's penis?
Not past, not to my memory, not past what he had said about, oh, he thought that it was so big that it would cause a miscarriage.
Okay. And did he say that with a straight face, or was he laughing or joking?
He was laughing.
Okay. Did you also discuss, or did you and he discuss your voir dire?
Yes.
What did he say about your voir dire?
So Judge Morrow had said that he was not above learning from attorneys, that he still had things to learn, and that he doesn't normally allow prosecutors or defense attorneys to do voir dire. because it can be pretty useless, he had said, but that he let us do it on this occasion. And he said, and you know what, Ms. Chiffone? And I said, what? He goes, I didn't learn anything from your voir dire at all. And I said, okay. And he said, you know, if you want to be direct with a juror, just be direct with them. Just ask them something directly. And he said, you know, for example, and then he gave an example. He goes, if I want to have sex with someone on a first date, what do I ask them? And no one in the room responded. And he said, I would ask them, have you ever had sex on a first date? And he said, what's the second question I would ask them? And no one said anything. He said, I'd ask, would you have sex with me on a first date? No one responded. He goes, you don't ask questions like, do you want to get married or do you want to have kids? Like those things would come later, right? He's like, so just ask the question you want to know.
Okay. Was there anything else that occurred in chambers that you believe may have been inappropriate?
Can I take a minute to look at my report or my memo?
Yes, if that would refresh your memory, yes.
I would object to the open-ended question of, is there anything else you could remember? That's not really a point of refreshment. You're not refreshing a recollection. You're trying to create testimony.
Response.
I don't have a response.
Objection is sustained. Continue.
Ms. Bickerstaff, Ms. Chiffone, how did the conversation in chambers end?
The jury had to be released for the day.
And where did you go after you left the chambers?
To the back out front, back to the prosecutor table, or standing next to the prosecutor table, starting to get meaning myself and Ms. Bickerstaff's stuff together.
Where was Sergeant Derek Griffin at the time that this in-chambers conversation took place?
Oh, he was long gone for the day.
Was he there when you were packing up to leave for the day?
He might have been. I thought he may have been gone. I'm not sure. A lot of times the officer in charge will leave once your jury is deliberating.
And do you have any specific recollection on this occasion, whether he left or whether he was still present?
I don't remember him being there, but it's possible.
So did you have another discussion with Judge Morrow that same afternoon?
Just very shortly after we walked out of, right after we walked out of chambers and got back over to the prosecutor table.
Where was the jury at this time?
They were still in the witness room, or in the jury room, I'm sorry.
Had there been any discussion about releasing them for the day?
There wasn't like a discussion, but we all knew that was what was happening based on, I think, someone that had come to say it's 4 o'clock or something along those lines. Like we got to let them go.
So when Judge Morrow had another conversation with you, was it in the courtroom?
Yes.
Where were you standing?
I was standing next to Ms. Bickerstaff. We were both standing near the prosecutor table.
And what were you doing?
We were just getting packed up for the day.
Was Judge Morrow, where was he?
Judge Morrow was walking through. So when you come from the back, you can either go right up to the bench if you're the judge, or to get out to where we were, you have to go through a little area next to the witness seat and then down past the court reporter area to the main floor. And Judge Morrow had walked through to where we were onto the main floor.
Do you know whether or not he was wearing his robe?
I don't recall.
Did you have a conversation, or did he have a conversation with you at that point?
Yes, he walked up to kind of where we both were, and he asked how tall I was. And I think he offered, what do you 5'1" or 5'2"?
Did you respond to him?
I said something along the lines of so I may have said something like I'm not entirely certain on the words I used. Can I look at my statement?
Yes, if that would refresh your memory.
Yes. So the judge Judge Morrow had said that, what are you about, 5'1", 5'2"? And I said, no, but I accept that, Judge. And Miss Bickerstaff responded and said, well, Judge, I'm 5'3" for context. And so then the judge looked back over at me and said, so 410. And I said, well, 411 and a half. And he said, and what do you weigh? Like 105 pounds. And I said, Judge, you're not supposed to ask a girl her weight. And he looked at Ms. Bickerstaff and he said, what are you, like 117? And she said, that's very generous, but no, Judge. And he goes, well, I haven't assessed you for muscle mass yet.
When he did that, how far was he standing from the two of you?
A couple of feet.
Was he doing anything with his eyes?
Like kind of looking up and down to, I think, assess.
Up and down where?
Like us.
Okay. Can you imitate for us with your own eyes what you saw him do?
Just like kind of like looking at her, then like kind of looking at me, kind of, I don't know if it's hard to see my own eyes in the Zoom and do it, but.
Was he looking at your faces or something else?
No, I'm just our bodies, I would say, like ourselves.
And for the record, the witness moved her eyes up and down for the record.
Thank you.
Did you feel he was eyeing your body?
Honestly, at that point, I just wanted to get out of there. I just wanted to be, I felt like at that point that I just had like reached my max with it.
What was it about the situation that made you reach your max?
Because it had gone on for so long in chambers. And at that point, it had been a very long day. We had put on, a lot of witnesses. I was exhausted. I felt like back in chambers that it was completely a discussion between he and I. I felt like I had to defend the case for 2 hours. And it was just very draining. At that point, I didn't want to, I guess you could say, like play along and laugh along with him. I just wanted to leave.
When you were in chambers, did you feel like you were laughing along and playing along with him?
Yes.
What was the reason you feel that you had to play along with him?
Because I felt like he would dismiss our case if I didn't.
Now, in chambers, did you want to leave the conversation?
Yes, but I
Did
knew
you
that
ever? Wait, I'm sorry, say that again.
I said yes, but I knew that we couldn't.
Why couldn't you?
Because so you always have a choice. You always can, but it sometimes doesn't feel like you can just get up and walk out.
Was there anything about, let me go back. Were you personally offended by some of the things Judge Morrow said to you in chambers?
I'm going to have to object. Again, the leading is really bothersome at this point on what could be key parts of this case.
Objection is sustained. Would you reword, please?
Did you want to stay and talk to Judge Morrow in chambers?
At that point, no.
What? If you had been at your office or at a bar and someone was talking to you that way, what would you have done?
Walked away.
Is there a reason you didn't walk away from Judge Morrow?
Because I don't know if I've ever walked away from a judge. I don't think it was very, I don't know that would have been very, I wouldn't have, I guess.
What is it about him being a judge that made you act differently than you would have at work or at the bar?
There's a different level of like respect and formality that you show to someone that's a judge.
I'm going to ask you the same sort of questions when he was talking to you about your height and your weight in the courtroom. Did you enjoy having that conversation with him?
No.
Did you tell him that you didn't want to talk about these things?
No.
Well, you said earlier that you said you don't ask a woman her weight, right?
Yeah.
Okay. Besides that, did you in any way tell him you didn't want to be talking about this?
No.
Is there a reason you didn't tell him that?
I didn't feel like I could.
And why is that?
I didn't feel comfortable enough to say that. I thought that at that point that I I just didn't feel comfortable to say that.
Did you walk out on the conversation?
No.
Is there a reason you did not walk out on it?
Well, I didn't feel comfortable to walk out. I had a pending case in front of him. I didn't feel comfortable to just walk out.
Okay. How did that discussion end?
About the height and the weight stuff?
Yeah. Yes.
The jury came out. They knocked on the door and they came out.
Were they excused for the day?
Yes.
Where did you go after they exited?
We, being myself and Miss Bickerstaff, and I don't remember if Mr. Curley was there, because Mr. Curley had texted when I was back in chambers wanting to know if everything was okay, because we had been back there for so long. And so I don't remember if he was in the courtroom when we had been, or like outside the courtroom after we had packed up our stuff to leave. But after that conversation, we being myself and Miss Bickerstaff, got on the elevator to go upstairs.
When you got upstairs, did you tell anyone about what had happened?
Yes. Well, kind of.
Okay, explain your answer.
So we got up to, so the judge had wanted us to take out the tech cart, is what they're called, which is just like this really ancient, huge TV that the prosecutor's office has, that they put on these carts that you like wheel around, and they're like huge. And so we had used a tech cart, and the judge had wanted us to take it out of the courtroom. So we were wheeling this big tech cart up the stairs, and they have to be returned on the 11th floor at the prosecutor's office.
Did
So
you
we
mean
got
up this, wait, hold on. Did you mean you were wheeling it up the stairs or in the elevator?
up the elevator? I'm sorry. So you wheel it in the elevator, and we're taking it upstairs. And so we, being myself and Miss Bickerstaff, had to stop on the 11th floor, or her office was on the 11th floor, but I had to stop to help her wheel the cart back for the day. And so when we got onto the 11th floor, we ran into two other prosecutors. At this point in the day, it's like 4:30 or later p.m. And we run into two other prosecutors outside the elevator. One of which was David Champagne, another prosecutor. And he wanted to know how everything went, because he and I had worked on going through questions for my DNA experts. I had 3 different DNA experts. There was some pretty complicated DNA issues, and he had helped me prep for it. So when I ran into David, he had said, "How did it go? Like, how is everything?" And Anna, on the way up the elevator, had wanted to tell a boss about what had happened in chambers. And
How did you feel about reporting it?
I told her no. I told her not to tell anyone. I told her that the trial was almost done, that we needed to just keep it to ourselves and just keep going and just get through it.
What is the reason you didn't want to report it and you didn't want Miss Bickerstaff to report it?
I was very worried about our case. We didn't have a verdict. We still had a jury that was out deliberating, which that's, to me, something I take extremely seriously. There's almost nothing more serious. So I was worried about my case. I was worried that nobody would believe us. I was worried what impact that this would have on my career, on Anna's career, that these types of things can follow you your whole entire life, and that you can end up being associated with things like this forever. Excuse me, I'm sorry.
Right. And for the record, Miss Bickerstaff appears to be tearing up, and she wiped her face with a tissue. Go ahead. I'm sorry, Miss Chaffone.
That's okay. I was worried what people at Frank Murphy would think of me. I was worried that it was going to become gossip, because it's a very small place to work. I was worried that defense attorneys would look at me differently, that officers on my cases, wouldn't want to joke around with me, because they would think that I couldn't take a joke. I, excuse me, was worried that no judges would ever want to take me into chambers again to give me feedback. I had a million things that I was worried about, and I just didn't want her to ever tell anyone.
Did Ms. Bickerstaff seem to have the same reservations about telling people that you had?
No.
Were you present when she told people what happened in chambers?
Yes.
Were you present when she told people what happened at the prosecutor's table?
No. Other than with Joe Curley very quickly when he asked her what had happened.
Right.
Otherwise, no.
Did you express to Ms. Bickerstaff that you did not want her to tell anyone?
Multiple times.
How do you feel about the fact that she made the decision to tell everyone?
I completely understand why she did that. I was embarrassed with my own way that I handled this. And I think she did the right thing. Something that I was not brave enough to do.
Now, the next day, did you go back to the courtroom?
Yes.
Was that the day the jury rendered its verdict?
Yes.
What was the verdict?
A hung jury.
Was a mistrial declared?
Yes.
And was the case set for a new trial date?
Yes.
Now, after that, did you ever talk to supervisors about what had transpired with Judge Morrow during that trial?
Even before that we had, but yes.
Okay, explain what you mean when you say even before that.
So that night of the 12th, when we went upstairs and we had ran into David, and he told us to tell someone, and I said, no, absolutely not. We're not telling anyone. Bob Donaldson, who's a prosecutor, a senior prosecutor at my office, walked by. And Anna said, well, there's a supervisor, we can tell him. And I said, no, don't tell him. He was my office mate at the time's dad. So I was close to him, and I was embarrassed. I didn't want him to know. And so Anna told him what had happened. And Bob Donaldson took us to Jason Williams.
Who is Jason Williams?
Jason Williams, and I don't know if he was at the time, but I think he was the head of the appeals department in our office, because my first concern to Bob Donaldson was what's going to happen with our case. Like, we have a jury pending. We have a jury in the courtroom. Like, can't we just like look past this all and just keep going? And Bob said, like, I understand your concerns. Like, let's go to Jason Williams. Let's tell Jason what happened and see, like, maybe it will calm your mind a little bit, essentially, with the case, what's going to happen with your case. And so then when we left there, having told Jason, we went back up to the 12th floor, which is where my office is, because I needed to get stuff. And before we got off on 12, I looked at Anna and I said, don't tell Pat Muscat.
Who is Pat Muscat?
My boss at the time.
And is Pat a man or a woman?
A man.
Why did you not want to tell Pat Muscat?
Because I've known him my entire career. His daughter interned with me, so he sees me as a daughter, and I was embarrassed for him to know something like this. I didn't want to talk to him about it. I didn't want him to look at us differently. I was afraid of him wanting to pull me out of the courtroom, which he did. Anna told Pat, and Pat didn't want me to go to the courtroom to take the verdict the next day. And I completely melted down at the office. I freaked out, and I said that wasn't happening, that there was no way that they were going to keep me from going in and taking my verdict on this case.
Wait, hold on a minute. What does it mean to you to melt down and freak out?
Pat said we needed to tell Athena and report it. I said, absolutely not.
Hold on. Who is Athena?
Athena Syringas was the head of the chief of special prosecution. So she was like the boss.
Okay, how did you feel about Pat telling you you had to share this with Athena Syringas?
I knew at that point, if we told like Athena and all of that, that everything that I was worried about was going to happen.
So did you argue with your boss, Pat Muscat?
Yes.
And eventually did he concede and let you go into the courtroom the next day?
I don't even know if he conceded. I, at the time, was like insubordinate, I guess you could say. And I said I was going in no matter what, that they couldn't keep me out of the courtroom tomorrow.
And what was it? Why were you so insistent on going to the courtroom the next day?
Because this is like one of the highest, most important things you can do when you have a jury trial of this magnitude, is to see it out, see it through, and go back in go back in and finish it out and take the verdict regardless.
And did you in fact do that the next day?
Yes.
Okay. Now, after it was all over with, did anybody ask you to put into writing what occurred?
Yes.
Who asked you that?
Athena Syringas.
And she's, you said, the big boss of the Special Prosecutions Unit?
Yes.
So what did you put into writing?
A summary of what had occurred and what my knowledge of what had occurred with Anna and the judge in the courtroom, and then just a summary of the event.
Was it in memorandum form?
Yes.
And do you have a copy of it in front of you? And for the record, it's marked Exhibit 7.
Yes, I do.
Can you tell the judge when you wrote that memo?
It was June 13th, 2019.
Is that the same day the jury hung?
Yes.
How many pages long is your memo?
My memo is 2 pages.
And is it single or double spaced?
Single.
Is the font 12 point or smaller?
It's pretty small. I think smaller.
Okay. And what did you do with the memo once you wrote it?
We gave it to Athena.
Do you know what was done with it after you gave it to Ms. Syringas?
We had addressed it to Daryl Carson.
Who is Daryl Carson?
Daryl Carson is the chief of staff at the prosecutor's office. And my understanding was that Ms. Syringas was going to be forwarding on the memo to Ms. Carson, who eventually may forward it on to Prosecutor Worthy.
Okay. Did you have anything else to do with that memorandum after you wrote it?
In what way?
Well, besides reviewing it, were you told to change it in any way?
No.
Did anyone critique it?
No.
Do you know whether or not Ms. Bickerstaff wrote a memo?
Yes, she did, to my knowledge.
Did you review her memo?
No.
Did she review your memo?
I don't know.
Did you give it to her to review?
No.
Did anyone tell you what you should say in this memo?
No.
Is everything you put in the memo the truth?
Yes.
Did you also write an affidavit?
Yes.
And do you have a copy of it in front of you?
I do. Is it Exhibit 9?
Yeah, Exhibit 9. Is it entitled Affidavit B?
Yes.
How many pages long is it?
3.
And is your signature at the bottom?
Of page 3, yes.
And was it notarized?
Yes.
Who was it notarized by?
Sheila Johnson.
And who is Sheila Johnson?
Sheila Johnson is one of the support staff members at our office. Specifically, I think one of Kim's Prosecutor Worthy's support staff members, she's a notary.
What date was it notarized?
June the 27th of 2019.
Did anyone tell you what you should write in your affidavit?
No.
Did anyone review it before you finalized it?
No.
Did anyone critique what you wrote?
No.
Did Ms. Bickerstaff read your affidavit?
Not that I'm aware of. I don't know, though.
Did the two of you ever talk about what you should put in either your memos or your affidavits?
No.
Did you ever read Ms. Bickerstaff's affidavit?
No,
Do you know what was done with your affidavits once they were notarized?
I would assume the same thing as was done with the memo, that it was given to Ms. Carson and then sent up the chain. I'm not sure though.
You indicated your affidavit was 3 pages long.
Yes.
Do you know what, was it single or double spaced?
I think that one was double spaced. It's definitely large, or single spaced, but it's definitely larger font, and I formatted it a bit differently.
So it's single spaced, but larger font than your memorandum was?
Yes, and I used bullet points that in like numbers and to offset it and format it a bit.
Do you know whether or not the Wayne County Prosecutor's Office did an investigation of the situation?
Yes,
How do you know that?
because I was interviewed by investigator Joanne Kinney.
Who is she?
She is one of the, actually, I don't know if it's investigator or detective. I always get it wrong. I think it's detective. The Wayne County Prosecutor's Office employs investigators, oftentimes retired police officers from different places as investigators in our office. So Miss Joanne Kinney is one of those. I believe she's a retired Detroit police homicide investigator employed by the Wayne County Prosecutor's Office.
Do you know when she interviewed you?
I can't recall.
Do you know if it was before or after you wrote your affidavit?
I think it was after.
Do you know if it was a short time after or a long time after?
I'd say a short time after, not maybe a few days or weeks after.
When she interviewed you, where did the interview take place?
In her office on the 12th floor of the prosecutor's office.
Was anyone else present besides you and Detective Kinney?
I'm not sure if Chief Bivens was
Who is he?
present. So the chief of the investigators at our office is Chief James Bivens. He's oftentimes called JB. I'm not sure if JB was present in the room with Joanne at the time that I was interviewed. I don't recall.
Do you know if JB or James Bivens is Joanne Kinney's supervisor?
He is.
When Miss Kinney interviewed you, did she do it on video?
No,
Did she record it in any way?
not that I was made aware of.
Was she taking notes?
I'm not certain.
Did she take a witness statement like you, like they used to do before video?
Like a question and answer format?
Yes.
No.
At any time were you allowed to review whatever she wrote or had about your interview with her?
So I want to say that it was at the conclusion of her investigation, or the investigation from our office, being the prosecutor's office. I want to say maybe at the conclusion of that, she called into her office, Anna and I, and indicated that she had finished the investigation, that she had drafted a summary of our interviews, and she wanted us to check the accuracy of them.
What format was what you reviewed?
It appeared to be like a narrative paragraph authored from her point of view.
Was it in typewritten?
Yes.
And did you review that?
Yes.
Did Miss Kinney get it right?
For the most part, yes.
Was there anything incorrect that Miss Kinney wrote down?
Can I review it once more just to be certain?
Okay, so for the record, that's exhibit number 12, right?
Yes.
Okay, and if it would refresh your memory, please do review the paragraph relating to you.
Thank you. I would say that that's accurate, yes.
Who provided you with a copy of that paragraph?
Joanne Kinney showed it to me. I don't think she ever provided it to me, like gave me a copy, but you provided this to me.
Now, do you have the entire exhibit, which is, for the record, 9 pages long?
No, I have like a paragraph that's a couple inches thick.
How many lines are written on the copy of the summary of your interview with Ms. Kenny?
The 10 lines in the one paragraph and 3 lines in the smaller paragraph below.
Okay, would you say it is significantly shorter than your memorandum and your affidavit?
Yes, it's just, that's the length. Very small, very short.
Have you been privy to reading the rest of the investigation done by the Wayne County Prosecutor's Office?
No,
Did you read the paragraph relating to Ms. Bickerstaff's interview with Joanne Kinney?
I didn't read it, but I don't remember if Joanne Kinney read them out loud. All I know is that when we walked out, Anna said that there was a mistake in hers.
Did you give her any advice about what to do about the mistake?
I said she needed to go back and she needed to tell Joanne. And
Do
she
you
said
know whether or not Ms. Kinney, Ms. Bickerstaff went back and talked to Ms. Kinney?
I don't know. She said she was nervous. She didn't want to go back in there and tell her. And I said, you got to go back in there. But then at the same time, you know, at this point, I mean, I knew that I couldn't get involved in the sense that I was potentially a witness as well. So I never followed up with her. I'm not sure if she did or not.
Right. Did anyone, to your knowledge, report this situation to the Judicial Tenure Commission?
Yes.
Who reported it?
So what do you mean by reported it, I guess?
Okay, well, so let's go back. Were you asked to fill out a form called a request for investigation relating to this incident?
So yes, but that was in the works once. So Anna handed it to me.
Had Anna written on the document when she handed it to you?
Yes, it was already filled out at the time that I received it, except for there were some items missing that she had left blank that I said, well, this would be prosecutor to the case, or, you know, I directed her. I'm like this, I filled in some blank stuff, but it had already been filled out when I had received it.
Did you have to put your name and address on it?
Yes.
Now, did anyone push you into filling out that form?
No.
Did you understand that that was a form that was to go to the Judicial Tenure Commission?
Yes, but I don't know that I understood what would happen after that was submitted.
Did you want to report this to the Judicial Tenure Commission?
I don't know how to answer. So no, in the sense that I didn't want to report it. But yes, in the sense that I knew what happened was wrong.
Did anyone at the prosecutor's office force you to file charges?
No.
Or tell you what you should say when you were interviewed or pursued charges?
No.
Okay, now I'm going to ask you some general questions.
Okay.
Have you and Ms. Bickerstaff talked about this situation since this happened?
Yes.
When would have been the last time you talked about it?
About the facts of what had occurred?
Yes.
The 13th of June. After we had gone in to Athena's office, when Athena Ms. Syringas had said, when we had gone in to talk to her, one of the times Athena had called us back into her office and had said, I want you to go and write this memo out. You know, you need to be separate from one another when you write it. You can't discuss what's been said or what's occurred. You can't, you know, don't read one another's. And she had said, you know, because eventually you two are going to be witnesses in all of this, potentially.
Did you comply with her rules?
Yeah. And we walked out of there and Anna broke down crying and said,
Object to anything that Anna said, be hearsay.
Okay, I agree. Okay, so don't tell us what Anna said. Did you break down crying?
no. We went back to our offices and we each, I don't know what she did. I went to my office and I wrote a memo. Since
then, have you ever had to appear in Judge Morrow's courtroom?
No, Not after we took the verdict, no.
Okay, I'm going to ask you some general questions about yourself, okay?
Yes.
Do you believe that you are super sensitive to sexual innuendo?
No.
Do you believe you're super sensitive to men looking at your body and guessing your height and weight?
No.
Do you have any history of having been a victim of sexual assault?
No.
Have you ever falsely made a complaint of sexual assault against anyone?
No.
Have you ever misinterpreted comments made by others that were not meant to be sexual?
I can't think of an occasion.
Do you get offended easily?
No, I would say no.
Have other male judges ruled against you on cases and motions that you've had?
Yes, lots of times.
Have you ever complained about being sexually harassed by any of those judges that ruled against you?
No.
Your Honor, may I have a brief break so I can discuss with Mr. Helen whether I've missed anything?
Certainly.
No
Um,
objection.
We will have do you need 5 minutes, 10?
10 would be good.
All right. No objection, Mr. Campbell?
That's correct. No objection.
All right, we'll take a 10-minute break at this time. I would remind you to put your speakers on mute. And Ms. Weingarten and Mr. Helen, do you want me to send you into a breakout room together?
No, we can talk in our office.
All right. Mr. Campbell, does anyone need to go into a breakout room at this time on the respondent's side?
Yeah, Your Honor, because we have the camera that's on the whole room here, that would be appreciated.
All right, so you would like to be, who would you like to go into your breakout room?
Judge Morrow, myself, Ms. Jacobs, and Ms. Hagan.
All right, one moment. All right, I have the 4 of you assigned to that breakout room. I'm going to open it up, and then I will close that breakout room in 10 minutes. And if you get done before that, you certainly may come back into the main hearing room. But at this time, we will take a 10-minute break. Thank you. It appears that everyone is back. Are you able to hear me, counsel? Would you unmute and let me know?
I can hear you.
I can hear you.
Thank you. Are we ready to proceed?
I am ready.
All right.
I'm ready.
Thank you. Continue, Ms. Weingarten.
Judge, I have no other questions of this witness.
All right, thank you. Are there any questions on cross-examination?
Yes, Your Honor, may I proceed?
You may. Thank you.
Your Honor, I would ask first that you pin the witness during the cross-examination. You know what I mean by that?
The witness is pinned. Continue.
Could someone explain to me what that means?
By pinning the witness, I am able to see the witness's picture as the largest thing on my screen. Everyone else is in smaller blocks or
Okay,
rectangles. All right, continue.
Thank you. Ms. Chaffone, am I pronouncing your last name correctly?
Yes.
Or well enough, at least? Ms. Chaffone, you have been an attorney since when?
2012.
And you have been employed at the Wayne County Prosecutor's Office since 2009, correct?
Employed as an intern, so not paid, unpaid internship from 2009 to 2012.
All right, but I think I heard you say you were doing trials as an intern, correct?
Yes.
Okay, so you have, at the time of the trial, you had 10 years of experience at the Wayne County Prosecutor's Office, correct?
Give or take, yes.
And you had 7 years as an attorney, correct?
Correct.
How many trials had you conducted as of June of 2019? And I'm going to go through a list here. How many bench trials?
I couldn't say.
You couldn't say because there's a lot of them, right?
Decent amount. Less
Okay,
bench trials than jury trials, I would say.
You said more or less?
Less bench trials than jury.
Thank you. How many jury trials had you conducted?
I couldn't say.
Can you give me an estimate in the year of 2019 in June when you came to try this case? How many had you tried already?
I honestly couldn't even estimate. I'm not certain.
Would it be nearly 100 over the years that you had been there?
That may be a bit high, but somewhere in the numbers.
Have you ever done a? Thank you. They were all criminal, correct?
Yes.
How many of them, if only by percentage, were murder cases?
Only murder cases within the last 3 years.
And in those 3 years, can you give me a sense of how many you had tried going into June of 2019?
Less than 10, maybe.
And how many have you tried since June of 2019?
I couldn't say. Less than 10.
Fair to say that since the onset of the COVID pandemic, you have not tried a murder
Correct.
case.
Correct.
How many cases had you tried with Anna Bickerstaff as of June of 2019?
2, or 1 other one than this.
Okay. And which judge was that before?
Judge Lawrence Talon. Anna was an intern at the time.
Thank you. And
Sworn in during the trial.
thank you. Can you describe Anna Bickerstaff for the record, please?
Describe her what way?
Well, I'd like a description for the record. I'll let you decide how you want to give that description, but I'm looking so that the master will understand what she looks like, but more importantly, there will be members of the Judicial Tenure Commission who will review this transcript de novo. I'd like them to know what Anna looks like.
Judge, I object. Relevance.
Mr. Campbell, response.
Well, Judge, we're not doing these proceedings with blank screens. There must be relevance to what people look like when they're testifying, and I think it's fair to ask for a description of somebody she knows.
Is Ms. Bickerstaff going to testify today, counsel?
Yeah. Yes.
However, Your Honor, you won't see her except for the portions that are identified on the screen.
Why do you need to see anything more than her face?
again, I'm more interested in how she is described by this witness more than anything else. We're relying on this witness for a number of things in terms of descriptions. I think it's fair to have her describe a person that she knows and works with.
And I object relevance.
Mr. Campbell, given that the witness is going to be here today, I am not seeing the relevance at this time. So I am going to sustain the objection.
Thank you, Your Honor.
And also I will add that I know that I just see the current witness from the waist up. If there's some need for the other witness to stand, we can do that also as far as height, if that is a question. So I will, you may refresh that question later on if it is necessary, but my ruling at this time is that the objection is sustained. Continue.
Thank you. Was Anna Bickerstaff a new attorney, in your opinion, at the time that the Matthews case was tried?
She was.
Was she a young attorney, in your opinion, at the time that the Matthews case was tried?
Yes.
You prepared for your role as first chair in the murder case, is that correct?
Correct.
You helped Ms. Bickerstaff prepare for her role as
Yes.
second chair, is that correct?
Yes.
Is it fair to describe you as her mentor?
I guess that would be up to her, but yes.
Did you know that this was the first time that she was taking the testimony of a medical examiner in a case?
Yes.
Who took the medical examiner's testimony at the preliminary examination, or was that not taken?
It was not taken.
Thank you. Did you give her any advice on how to conduct the testimony of the medical examiner?
Objection relevance.
Response.
Your Honor, this case is about the circumstances and the setting. That was part of the opening by disciplinary counsel. Part of the setting and the circumstances is this testimony of the medical examiner. It's at the conclusion of that testimony that the first of the incidents that are described in the amended complaint are raised. So it's the setup to how it came to be conducted. And in fact, it is discussion about the conduct of that testimony that makes it relevant.
Counsel, I'm going to give you some leeway at this time and allow you to ask the question. If there is an additional objection, I will rule on that when it comes up, if it comes up. Thank you.
Thank you. Ms. Chaffone, did you give her any advice before she took the testimony of the medical examiner?
I'm not sure if it was advice. There's a standard list of questions, like predicate questions, that float around our office. I had Anna write out her questions, specifically question by question, and then I reviewed what they were in advance.
Do you know if she interviewed the medical examiner before he testified?
I believe she did, yes. They had contact several times.
Do you know if she prepared the medical examiner with the questions that had been drafted prior to the testimony?
Well, I object to the hearsay unless Ms. Chaffone was present when they had the conversation.
I would limit my question to that.
What was your question?
I'm going to ask the court reporter to please read it back.
Do you know if she prepared the medical examiner with the questions that had been drafted prior to the testimony?
Thank you, Ms. Jorgensen. I don't know. To my knowledge, no.
You had been in Judge Morrow's courtroom for the May 2009 argument on the 404B motion that was filed by the people pre-trial, correct?
Yes.
You had also been there for other pre-trials related to the Matthews case, or no?
Yes.
How many times in 2019 had you been to Judge Morrow's courtroom?
I would say less than 5, counting any pre-trials or motion hearings that may have occurred in another case that I had pending before him at the same time.
Did you familiarize yourself with the courtroom?
In what sense?
Well, did you make any trips special just to check out the courtroom itself to understand where everything was, whether it be tables, chairs, where you anticipated the defendant to be, things like that?
I had been in there before, so I was familiar.
It's fair to say the courtrooms in Wayne County Criminal Division are not cookie cutter.
They actually mostly are. It just depends on where the jury box is typically. So it's the layout of the jury box is kind of what's different among, or the number of jury boxes in a particular courtroom. But typically they are pretty standard in their layout.
On what side of the table did the defendant sit during the trial in People versus Matthews?
On the opposite side of Mr. Noakes.
Is that standard in Wayne County criminal court cases?
It goes judge by judge. I would say a lot of times in capital cases, the defendants are seated there. Sometimes in non-capital cases, the defendants are seated next to their attorneys at the table, to the right or the left of their attorney, depending. It depends on what the judge's procedure is.
Thank you. You had tried a case as an intern before Judge Morrow?
A bench trial, yes.
And had the courtroom changed in the time between you were first there and when you came to do the People versus Matthews matter?
Maybe decoratively, I would say, but not substantively. They added these TVs to all the courtrooms.
Did you do any research on Judge Morrow before coming in to try the case of People versus Matthews?
Research in what sense?
You understand the word research, talking to people, looking up articles, anything. Did you do anything to prepare for the judge that you were going to appear in front of?
Certainly not like looking up articles or anything like that. I mean, more so I would say just to see, I checked to see like the pace that he was, like if there was anything scheduled ahead of us that day or any conflicts or anything like that. But I was familiar with the courtroom.
Did you talk to Pat Muscat about Judge Morrow prior to the trial?
No, not in the sense of like information other than that I had a pending trial potentially.
So Mr. Muscat made no statements to you one way or the other about Judge Morrow in terms of how he was viewed either personally or by the Wayne County Prosecutor's Office?
No, he was not my direct report at the time. He would have been familiar with me having this case potentially, but the person I was dealing with most directly at the time would have been my supervisor, Kelly Gleason.
Thank you. Did you talk to Joseph Curley before the trial?
Yes.
And what did you talk to Mr. Curley about?
I don't remember specifically. I do know that we got some information from him just about, like what the next week, the week that we were supposed to start, what that docket would have looked like for the week.
And Mr. Curley was Judge Morrow's regular prosecutor?
Yes, at the time.
And is he currently his regular prosecutor, or is it somebody else, if you know?
I think it might have switched. They typically switch the courtroom prosecutor every 6 or so months, but I'm not sure.
Were you aware from Mr. Curley how often or how rare it was for Judge Morrow to come down from the bench and sit at the prosecutor's table or even at the defense table?
Not from Mr. Curley, but I have seen the judge off the bench before, not seated at the prosecutor table, but off of the bench.
Okay, and when he has been off of the bench, where has he been?
Anywhere in the courtroom.
Literally anywhere, right? For Judge Morrow, correct?
Correct.
All right. So how about Bob Donaldson? Did you talk to him before the trial about Judge Morrow or about the case?
No.
Who, in terms of your superiors, did you talk about the case to before it was tried?
Kelly Gleason, like I said, was my direct report at the time. So she was familiar with me having the case. My office neighbor at the time was LaDonna Logan. She's another prosecutor. I talked to her about the case. My office mate at the time was John Donaldson. I had talked to him about the case. They're not my supervisors. I sometimes call LaDonna my supervisor, but she's not technically, I guess. Athena Syringas was aware of the case.
The matter had actually been appealed prior to trial and after the 404B motion that you filed and argued, correct?
Correct.
And who handled that?
So Ms. Bickerstaff handled coordinating with appeals. You know, we would have gone to our supervisors after we would have gotten we probably had gone to, and I don't remember specifically, but I would say we likely went to Athena or Kelly after we had gotten the ruling. But as far as contacting appeals, dealing with appeals, that was Anna.
Who gave you the news that the Court of Appeals had issued an order in the case based on the appeal?
I don't recall if we got the email from appeals or if, I'm not certain. I don't remember.
You believe it was by email, though, not by a personal discussion?
I'm not sure. I don't recall. Typically, we get them through email, but I can't say for certain.
You've talked about the verdict being a big deal. Was this appeal a big deal?
I would say that any pretrial ruling that could have a significant impact on the outcome of a case would be important or significant, yes.
But that's not really my question. I asked about the ruling. I asked about the actual appeal, and I apologize if I wasn't clear. The appeal itself was important and significant to the case, right?
Only in the sense of what the outcome of it would have been.
Well, what were you trying to achieve in the appeal?
To potentially get in some other act evidence into the trial.
And other act evidence in this murder trial were evidences of other murders, correct?
Correct.
So the 404B motion was to bring in how many other murders?
I want to say that it was one other murder and a sexual assault.
Could it have been two other murders?
It could have, yes.
There was no charge of sexual assault in the case that went forward in People versus Matthews in June of 2019 that you tried, correct?
Not that I had, but another prosecutor did have a pending sexual assault case with him at that same time.
So, and I'm sorry, Ms. Chappone, this will go a lot easier if you could listen to my question. I said the case that you had. There
Yep.
was no other, correct?
No. Nope.
Not even a charge, correct?
Correct.
Had not been a charge at preliminary examination. The only charge in this case was murder, correct?
In a habitual notice, correct.
Had you had any discussions with anybody at the Wayne County Prosecutor's Office about how Judge Morrow conducted voir dire before you went in for the trial?
Yes.
Who did you talk to?
Possibly my office mate, John Donaldson, potentially John Casey, another prosecutor at the office.
Did you talk to them because they had more experience than you before Judge Morrow?
Just to see if they had any additional information about it.
So my other question then is, did they have more experience than you before Judge Morrow?
I don't know. John Casey likely did.
Did you get any advice?
No.
Were you told that Judge Morrow was tough on lawyers who, during their voir dire, in terms of not letting them do much? Let's start there.
Objection, hearsay.
It's not offered for the truth of the matter asserted.
What is it offered for?
It goes to this, well, can we go and do this as a offer of proof like we indicated at the beginning of the case?
Certainly. We will take time at this time to go into a separate room with counsel. And tell me, Mr. Campbell, who do you want to go into the room on your side?
I would say the usual suspects, Judge. Same folks that went the last time, please.
Ms. Weingarten.
Myself and Mr. Helen, please.
All right, I'm going to open the rooms. Mr. Campbell, you will go in first. All right, I believe that there we are. We are all present. To the objection that was made on the record, the objection is sustained. Please continue. And Mr. Campbell, you are muted.
Thank you, Your Honor. Give me one moment to get my stuff back in order here, coming out of the room.
Certainly.
Thank you. I'm ready to proceed if I may.
You may.
Thank you, Ms. Chappelle. We're going to come back and talk about the voir dire in some detail, but let me ask you, the accused was James Matthews, correct?
Yes.
And what did you know about James Matthews in terms of his background coming into this case?
His background in the sense of he was linked to several other violent homicides, sexual assaults.
Fair to say that you knew the details of the case that you were trying and the facts that you were going to rely on in order to convict Mr. Matthews, correct?
Correct.
You knew the strengths of your case, is that fair?
Yes.
You would agree that a lawyer trying a case, especially a criminal case, and maybe especially a murder case, needs to know that that case as well as possible before she tries the case, correct?
Needs to know what?
Needs to know the case as well as possible before she tries the case.
Yes.
By the way, an opening statement, no, I couldn't say it that way, right? Give me one moment. You would agree that a murder case is stressful on all the participants, correct?
Yes.
You would agree that it's high stakes, correct?
Correct.
It's particularly high stakes for the defendant, correct?
For all parties, correct.
Am I correct that you knew some parts of your case were not as strong as others?
I knew that we didn't have a witness that identified Mr. Matthews as the person who had actually committed the crime.
Am I correct there were a few other weaknesses in the case as well?
Are you referring to one specifically?
Well, here's what I gleaned from my review of the transcript. The age of the case was at least potentially a tough part of the case, correct?
Correct.
So this is a murder, certainly that occurs because Ms. Robinson is murdered in 2003, correct?
Correct.
This trial takes place in 2019, correct?
Yes.
So spanning or not having that time as a distraction to the jury was an effort that you wanted to make. Is that a fair statement?
Correct.
The background of Ms. Leak, that was also potentially an area that could be of concern to the prosecution in the presentation of the case, correct?
Correct.
You described her in your direct testimony here as somebody who was known to have used drugs in the past, correct?
Correct.
You knew that the facts were going to bring out that she had used drugs with Mr. Matthews that very night that Ms. Robinson died, correct?
Correct.
She would testify that she was clean from drugs for, I think she said, a decade or so, give or take, at the time of her testimony in 2019, correct?
Correct.
Judge, I'm going to object to this line of testimony of questioning. How is it relevant to the proceeding at issue?
Again, Judge, I'd have to ask to go back into the room to give the offer of proof. I think this should be obvious, Judge, but if you need the offer of proof, we need to go back in the room.
One moment, please. All right. We will go back into the room. And then I have another question for you while we're there also. One moment.
Thank you. Lori and Judge, please. Thank you. All right, we're unmuted.
Thank you. I think we are ready to continue to the objection. I did indicate that I would allow Mr. Campbell to ask a few questions in this area, but we're not expecting a lot.
Thank you. I'd ask the court reporter to please read the last question.
She would testify that she was clean from drugs for, I think she said, a decade or so, give or take, at the time of her testimony in 2009, correct?
Correct.
You knew that she had a prior criminal conviction, and maybe even a couple, correct?
Yes.
In fact, the statement that she gave that was helpful in this case to you was made while she was in custody in Oakland County, correct?
Correct. One of the statements she made.
Thank you. That was back in 2003, correct?
Yes.
Oakland County. Thank you.
I believe it was 2003, yes.
Yep. Mr. Matthews owned the house where the body was found, correct? Outside. It was outside in the front lawn, correct?
I don't really know the ownership, but I know that his mother was living there and he was living there with his mother at the time.
Thank you. You had a neighbor named Mr. Masterson who was going to come in and testify. Do you remember that?
He did come testify, correct?
Correct. And his testimony was essentially that he saw a body and then he went on to work, correct?
And that the defendant denied knowing the victim.
Correct. You had a DNA lab and the various experts that were needed for that, correct?
Correct.
Judge, I would like to renew my objection to the relevance of this whole line of questioning.
Mr. Campbell, do you have anything different than what we discussed in chambers?
Yes, I'm just going through the witnesses and the anticipation of what's going to come. I'm going to go through her opening statement and her presentation of these witnesses. So I'm just laying the foundation for who these folks are when she and I talk about them.
As I indicated when we were in chambers, I am going to restrict or limit your questions. So to the objection at this time, I am sustaining it. Continue, please.
Thank you. There was press involved in this case, correct?
Very early on, yes.
There was bad press for the Wayne County Prosecutor's Office, correct?
And the Detroit Police Department, yes.
Okay, so both of them. And the bad press dealt with the age of the case in part, correct?
I think exclusively with the age of the case, yes.
Thank you. So the bad press centered around who was responsible for losing track of the evidence in this case for 16 years.
Something to that effect, yes.
And the Wayne County Prosecutor's Office blamed the police department?
They did not weigh in, is my understanding.
I'm sorry, I'm going to have to ask the witness to repeat that question. I couldn't hear it all. Repeat the answer.
It was my understanding that the Wayne County Prosecutor's Office did not weigh in on the matter. I believe the bulk of the information was with regards to statements made by Chief Craig.
The situation, did you understand that the situation was the prosecutor's office had given the police department in response to a request for a warrant for Mr. Matthews, the task of gaining some additional evidence?
Correct.
And they did not come back with that additional evidence according to the Wayne County Prosecutor's Office, correct?
According to notes that I had in a file. So I don't know if it was like according to the Wayne County Prosecutor's Office, but according to notes within the file.
And that was back in 2003, 2004 timeframe, correct?
Correct.
How many cases had you handled before this that had press coverage?
Several.
How many that had bad press coverage?
A few. I mean, it depends on the case. Sometimes it's positive, sometimes it's negative.
Would you agree that one of the strengths of the case, at least going into the case, that you thought it was a strength, was the testimony of Emery Matthews?
Objection, relevance.
Response, Mr. Campbell, if any.
Judge, her understanding of her case is central to the presentation of the proofs here, and consistent with the opening statement made by the prosecutor here, that it's about circumstances and the situation. This is a foundational question. Either he was or he wasn't an important part of the case.
Anything further from the disciplinary council?
It's simply that I believe Your Honor has already ruled that it's not relevant.
No, I don't believe that's true.
Well, I did indicate in chambers that I would allow a few questions. I'm going to allow this question. There may be a future objection and I may rule differently. Continue.
Was the question whether or not Emery Matthews was significant? Was that your question?
Yeah, it was considered going into the case to be a strength in the case.
He was a wild card from the beginning, I think. He was the brother of the defendant, so it was unclear whether or not his testimony would comport with what his statements, multiple statements, were to police. He came the morning of trial and he was not in good spirits, I will say.
Did you tell the jury that he was a wild card?
No.
In fact, in your opening statements, you said the case would be bolstered significantly by the confession of James Matthews as related by his brother Emery, correct?
I don't believe I used those words. I think that I said that there was something significant to look for.
Give me a moment. Is it fair to say that as a prosecutor, where there are bad facts, you want to bring them out to the jury ahead of time, either in voir dire or in the opening statement, in order to minimize the impact of surprise from those facts?
If you know what those facts are in advance, yes, depending on your strategy.
How many times have you done voir dire for a jury?
I couldn't tell you. Several.
Do you know what Judge Morrow's reputation was for allowing or not allowing voir dire?
I was under the impression he did not allow voir dire.
When did you learn he was going to allow voir dire?
I don't remember.
Did you prepare a voir dire before the trial commenced in People versus Matthews?
Yes.
Do you recall Judge Morrow discussing with you and the other lawyers theories, or his theories at least, about asking questions prior to the potential jurors arriving? In other words, this is a conversation before the voir dire begins.
I don't understand your question.
There was well, let's go to the screen. This is in the transcript, and I forget what exhibit number that is. Ms. Weingarten, is that exhibit 2?
Hang on. No, exhibit 5.
Exhibit 5, thank you. So this is exhibit 5. This is, and I'm going to put it up on the screen, Ms. Chaffone. You, I think, actually have the exhibit book there with you, correct?
Not the exhibit book. I have a copy of the transcript. Is there any way to move it to the middle of the page?
Yeah, we're going to make it bigger. So we're going to call out, but I wanted to, for the record, this is page 6, lines 12 through 19 of exhibit 5. And all my references will be exhibit 5 unless or until I say otherwise, by page and by volume number. Okay?
Yes.
First of all, do you remember Mr. Noakes saying to the judge that he'd like to have the jury voir dired on issues related to publicity?
Yes.
And this was before the jury was in the room, correct?
It may have been, I'm not certain.
You likewise would have wanted them to be voir dired about publicity as well, correct?
Sure.
And the next screen, this is page 7 and leading into page 8. It's from line 15 on page 7 to line 15 on page 8. So they're broken into 2 screens here. But Judge Morrow said the following, and on the screens that I have here, Ms. Chaffone, I'll read Judge Morrow's words, and then what I'd like to do is, if there's statements by you, I'd have you read those off the transcript, and I'll play Mr. Noakes or any witnesses that come along, okay?
Sure.
So Judge Morrow says, and you know, ask questions that are relevant. Give you an example. Once upon a time, or that's once upon a time, people used to ask in voir dire, what stations do you have on your car radio? Now I understand it. You want to see if they're listening to country or urban, rap or gospel. I can understand. That's an interesting question. We used to ask, like, what kind of bumper stickers do you have on the back of your car? All of those things that could tell you something about it. But what I always found strange was that they never asked who set the radio stations on their car or who put the bumper stickers. They thought that they were asking something that was going to give them some insight. And I was like, no, you didn't ask the most important question, you know. And now, if it's a young person, they'll say, what radio? You mean you can set stations on the radio? I just listen on my phone or on my iPod. We're going to go to the next screen, but
Judge, at this time, I object to this line of testimony. It is not relevant.
Is there a response?
yes, number one, the transcripts are in evidence, Judge. If it's not relevant, why did they mark and admit the transcripts? It's entirely relevant. There's a conversation that occurs not in a back room with the door open, by the way. It's not just there. It is a conversation that spans not just days, but it goes back to the 404B. And I'm going to show that. The beginning discussion.
Let me hear further from Ms. Weingarten. Is there any response?
Well, does that mean he can read to you every single page of the transcript and every single page of every motion hearing held? It's got to be relevant to the judicial proceedings that were at bar.
All right. So at this point, I am going to allow the continued questioning on this particular document. It may come to a point, Mr. Campbell, where we'll have to talk again because I'm not finding relevance. Right now, I'm going to continue to give you that leeway. Continue, please.
Mr. Campbell, what was your last question?
I'm going to rephrase it. I'm going to put up the second part of the pages that I cited. I'm going to read this and then I'm going to ask my question, okay? So, but to me, if it's just interesting, it didn't give you any insight into Boo Bear. You know, people ask, are you a vegetarian? What are we serving for lunch? That's the only reason the question is relevant. So you get a variety of interesting questions, but it's like, kind of tell me what bearing that has on the ability to be fair and impartial, you know. Take me to the water trough. Do you remember Judge Morrow saying those words or words to those effect during the matter before the voir dire began?
Yes.
Okay. And with regard to that, did you understand what he was talking about?
Yes.
Did you try to plan your voir dire in a manner that would be relevant, that would be helpful to trying to figure out whether people could be fair and unbiased in determining an outcome to an important trial like the one you were about to try?
In my opinion, yes.
Okay. Your chair was the closest chair to the jury box, correct?
Yes.
Ms. Bickerstaff was next to you,
Yes.
correct? And Detective Griffin was, I think you said it's Lieutenant Griffin now, who was next to Ms. Bickerstaff, correct?
Correct.
You can put up page 34, in particular lines 10 through 14. Do you remember there being a discussion about bias when the jury was being instructed and voir dired by the judge?
I'm not sure it was a discussion. The judge was speaking. Yes.
Now, in the end, when you're back in chambers with Judge Morrow, with Mr. Noakes, with Ms. Bickerstaff, this issue of bias is again discussed between you and Judge Morrow, correct?
I don't know if it was a discussion. He raised the issue. Yes.
And you were there and you had conversation with him about this, right?
I don't know if it was a conversation. His points on bias were more statements.
The bias issue in the Matthews case begins during the 404B transcript that took place on May 15th, 2019, correct?
I haven't read that transcript.
This is exhibit, give me a moment, I have to find the exhibit number. You know, I think it's exhibit B from my exhibits. Let me check my list. Yep, no, it's not that. It's the, yeah, it's the circuit court file. It's the portion. So I believe this is exhibit B. And if we can, I'm sorry, it's exhibit C. You don't have that on there?
No.
Okay.
I didn't bring it with me.
You recall Judge Morrow discussing with the jurors about how they should be careful about having opinions about things to which they actually had no knowledge.
No.
So do you don't have this on the screen, so I'm not going to do that. We're going to back up. Do you recall Judge Morrow talking about the O.J. Simpson case? Do you recall he used that as a way to tell the jury about how he knew nothing about the case yet because he was a judge? Everybody was asking him for his opinion. And he stressed that when you don't know the facts, you should not form an opinion. Do you remember that?
Yep.
Do you remember Judge Morrow referring to himself as an asshole during that discussion about the OJ stuff?
I think he said, and excuse my language, I think he said people wanted to make me the asshole by commenting or something. I don't believe he called himself an asshole.
And do you remember right after that, he talked about how people don't like him using the term asshole, and yet he does it.
He, I believe, said the JTC specifically doesn't like that he uses the word asshole.
Or he said they might not like. Do you remember that?
Something along that lines. Yes. That's why he said that's why he gets in trouble by the JTC, because he uses words like asshole. And he hugs jurors or something, or shakes their hands, I believe is what he says in there.
Do you recall the gender makeup of the jury?
I don't. I think it was pretty even, if I remember. We may have had, I think it was pretty even.
You recall the racial makeup of the jury?
No.
Do you recall there being a video played to the jury during voir dire?
There were multiple videos played for the jury by the judge.
Do you recall doing your voir dire?
Yes.
Do you recall saying before you began that you were trying to prepare for everything? Do you remember that?
Your Honor, this time I'm going to object. It's the same objection I've made, relevance.
Your Honor, they
Is there a
present-
response?
Yes, I'd like to do it in the room, please. And I'd like my client to be able to attend.
I have no objection to Judge Morrow attending.
All right, we're going back into the room. All right, I think we are all back in, and there was an objection. I did sustain the objection. However, there is council's request to make a record with respect to the continued questioning in this area. Go ahead, Mr. Campbell.
Judge, before he begins, I believe we have to tell the court reporter to make this a separate record.
All right, Ms. Jorgensen, you're nodding your head. Are you able to do that at this point?
I am, Your Honor. Thank you.
Thank you very much. Let us know when you're ready, Ms. Jorgensen. She's ready now. All right, I think we're ready to proceed. Continue.
Thank you. Do you remember Judge Morrow, Mr. Fung, giving an example of his own bias to the jury as he was doing his voir dire and addressing them related to bias?
I don't offhand, but if you remind me, I probably would.
And you would agree, anything he said to the jury, you would have been in the courtroom, Ms. Bickerstaff would have been in the courtroom, and Mr. Noakes would have been in the courtroom.
I cannot say that for certain, no.
Okay. Were you there through the whole voir dire?
Yes.
I have to ask, well, that'll be part of the record that is on the record. So I'm going to start here. So I draw your attention, and you can look at the screen if you want. This is volume 1 of the trial, page 34. This is exhibit 5, page 34. I have lines 15 into page 35, line 7. And I don't know if that's big enough for you to read there. Can you read it? Not
a bit. I have to move around the screen.
Okay, I'm going to read it, and I'd like you to follow along, and then I have questions at the end of it, okay?
Okay.
Number 1, I'm not necessarily fond of dogs. Well, let me stop there and ask you, does that remind you of
Yes.
his story, of his bias?
I remember this. Yes.
And so continuing on with the reading, it's just not my thing. I'm 67 years old. The animal, the dog that I really don't like is a German Shepherd. Why? Guess what I used to watch on TV, chase little black kids and bite them. And I've never been bitten by a German Shepherd. One never has run up on me. That's secondary trauma. That makes me not like freaking German Shepherds. Continuing, I'm reading. I can't imagine a Jewish person would like German Shepherds either, but hasn't done anything to me. Never seen it. It biting anybody in real time. But having watched that, I got a bias. And it's not based on personal experience. It's secondary experience. And that's just something how bias works on us. If I had to buy a dog, it wouldn't be that one. You know, Bruce, why not? If I had to explain it, I'd just say, well, you know, if I didn't want to tell the truth, well, I don't think I like dogs that shed. You remember Judge Morrow giving that set of examples to the jury?
Yes.
You remember his purpose was to alert them when they heard testimony to consider the potential for first and secondary, call it primary and secondary bias.
I don't know his purpose.
Do you recall Judge Morrow speaking to the jurors about having opinions about things that they knew nothing about? That was a tendency in the modern age, especially with electronics. And
Are you talking about when he gave the O.J. Simpson example?
no, before the O.J. Simpson and leading up to it, and the reason he gave the O.J. Simpson example was he was telling the jurors that they needed to have something different, or they needed to be more rigorous concerning listening in court than they were in their regular lives. You remember that?
Yes.
Okay. If you could put up page 104, lines 11 through 15. Judge told the jurors, I wonder if you ever had this experience, something similar maybe, even the same experience. Have you ever made a decision about something that you absolutely knew nothing about? Have you ever been tried to be trapped into giving an opinion about something you knew nothing about? Okay. You remember that being the lead up to the O.J. Simpson discussion?
I don't know if it was the lead up, but I remember that being said.
Do you remember Judge Morrow talking about the JTC situation in light of the social media and the media in this case?
Just yes. Yes.
In other words, the reason he spoke about it here was to tell the jurors that he had been in the media before, that people could Google him, but that he didn't want them Googling anything about this case. You remember that? And then he tied that instruction to the idea that people need, on this jury, if they were picked, needed to make their decisions based on the facts. Do you recall that?
Yes.
I've reached the end of my portion. I have more questions to ask. They'll probably get new objections, but I'm ready to go back on the record.
All right, thank you. Ms. Jorgensen, let us know when you're ready for that.
I'm ready, Your Honor. Thank you.
All right, thank you. Continue, Mr. Campbell.
On direct examination, Ms. Chaffone, you said that you had the opportunity to look at the transcript. It sounded like fairly recently. Is that true?
The trial transcript, yes.
Okay. You're going to retry this case eventually when COVID restrictions are lifted, correct?
Yes.
You anticipate it to be one of the first cases that is tried after the COVID restrictions are lifted, correct?
No, I don't know.
Have you read the transcript in connection with the retrial, or have you done so in preparation for your testimony here?
Both.
You said on direct examination that you felt from your experience in the courtroom that Mr. Allen may not have recorded everything that went on in the courtroom. Do you recall testifying to that?
Yes.
Do you know the intricacies of Mr. Allen's recording device?
No.
Do you know whether he has an audio recording in addition to or as a backup to the mask speaking?
According to him, yes.
So when you say you saw instances where he was not speaking into his mask, you were aware that he'd have the backup audio recording?
No, that was after the fact. When we tried to get the transcript, there was some difficulty in having him transcribe the portions of the transcript that were not witness testimony. And it eventually came out that he had recordings of the proceedings.
You know Mr. Allen's ill, right?
I do.
So it is not your point that Mr. Allen failed to take down or record things as his job was during this trial. You're not suggesting he was somehow altering or attempting to not create a complete record.
I just telling you what I know.
Is there anything you found in the transcript that was inaccurate when you reviewed it?
No, there were things that I remembered that had occurred that were not in the transcript.
Have you ever shared with anybody what instances those are?
I'm not certain.
You're not certain whether you told somebody there was stuff missing from a transcript?
No, I don't know.
And so I'm clear, there's stuff that happened outside the presence of the jury that you think didn't make it onto a transcript?
Yes, actually, I did mention it. I have mentioned it. Yes.
Yeah, who'd you mention it to?
Potentially some people in passing, but I think maybe to Laura in the last day or so, because I just read the transcript recently. I had a motion hearing set for James Matthews earlier this week, as well as this proceeding. So I reviewed the transcript in preparation for both.
Did that proceeding with Mr. Matthews go forward this week?
It did not. We were there, but it did not. The case couldn't go forward. He had a medical appointment.
So before that, I had asked you the question, are you saying there were things that happened in the courtroom that were not in the transcript, but it was all things that happened outside the presence of the jury.
I don't know that all of it happened outside the presence of the jury. I can't say for certain.
As you sit here today, are you aware of anything that happened in the presence of the jury that was not taken down by the court recorder?
I believe that there was a discussion about one of the videos played by Judge Morrow that I didn't see any information about in the transcript itself.
How many videos did Judge Morrow play?
Several, at least 3, possibly
You know how long those or short those videos were?
a couple minutes.
You are aware that part of the transcript contains a reference to a video, correct?
Several points in the transcript at the section of jury selection contain portions of where video was played, yes. It's not the video that I don't see in there, it's the discussion of the video after.
Discussion with the jury? I'm sorry, somebody has their microphone open here. Or I think, Judge, it's you. I think you need to mute.
Yeah, I'm sorry, Mr. Campbell. I couldn't hear your last question.
I'll repeat. Tell me when you're muted, Judge. You're not muted. Give me a moment. Okay, I think we're ready to proceed. If I
Yes. Yes, you may.
may. I'm not hearing any feedback. Ms. Chaffone, are you?
No,
Thank you. I'm aware of one place in the transcript where there's a video being played and it lasts 1 minute. You're aware of others?
yes,
Okay. Do you have those citations, or is that not easy for you to?
not
tell
on
me?
hand. But I can tell you what the videos were, the ones that I remember.
Sure. What do you remember?
There was a video, and I don't know if it's like American Idol or America's Got Talent or something, that Judge Morrow plays with Susan Boyle. He shows the video and shows essentially how no one would think that such like a beautiful voice would come from a woman that looked like that. There is a video that he plays that is, there's 2 videos that are just music, I think. There is a video, and this was the one that I didn't see any information about in there, but there was a video he played with monkeys, where the monkeys dance on the like conference room table, and it shows this chart, and the chart shows like whatever it is going upwards. So the monkeys are like popping bottles on the conference room table celebrating, until someone walks in and like turns the chart and realizes that like the numbers have gone down on the chart.
Thank you. This is going to be volume 1, so exhibit 5, page 122, 21 to 25.
Is that page 4?
It's page 122, 21 to 25. It's on my page 14. Be just a moment. Do you remember during your voir dire asking or addressing with the jury issues related to media in the case?
Yes, it was in response to some questions or information posed by the jury, yes.
If you read lines 21 through 25 here, the judge, you say, can you read your portion here?
Sure. From me in line 21. Okay, so do you agree that the media, as the judge said, often sensationalizes information or represents information, or misreports information based on whatever reasons they may have? Prospective juror flees. Answer, I agree.
And this was after the judge had given his JTC example. And that's why your reference is that the media sometimes sensationalizes information, correct?
Objection relevance.
Mr.
I have
Campbell?
the same answer, Your Honor. If it's sustained, then I'll just go to a separate record if I may.
Anything else with respect to the specifics of the objection, Ms. Weingarten?
Just that, is she going to have to explain why she asked every question she asked of the jurors? That's not why we're here. It's not relevant.
I'd agree that's a different objection than relevance, because it might be relevant for all the questions. But I've asked about one, and I'm ready to move on to another aspect of the voir dire.
All right. I am going to allow that question. Continue, please.
Thank you. When you got the opportunity to engage in your full voir dire with the jury, do you remember the example that you used?
I used a couple, I think, but yes.
You did about 9 pages of voir dire. Is that a fair? I don't know if you remember one way or the other.
I can't tell you page numbers. I think I gave 2 examples.
Okay. One of the examples involved a dog.
Correct.
Okay, and the dog was kidnapped. Is that right? Or dog napped?
Yes.
And it was in a cage at one point. Is that correct?
Before it was taken, yes.
Okay, and then it was gone for some time, correct?
Yes.
And you had other aspects and other features in that example that you were asking questions of the jurors of, correct?
Correct.
Did you build that example off of the German Shepherd example of bias, or did you have that already prepared?
I had an idea of what I wanted to do with regards to trying to show a lead up of circumstantial evidence pointing to a certain individual having committed the crime, and that some time had passed from the time, that the crime was alleged to have occurred to the time in which this like unique looking dog was identified as being there. Sorry, what was your question? Sorry.
You've done a wonderful job answering it without knowing what the question was, but let me ask a new question, if I may, which is, did you feel that your voir dire achieved the things that you wanted to do?
I don't think that example did, no.
What did you want to do in your voir dire?
With this particular case, I wanted to flesh out specifically whether or not we were going to have an issue with jurors not having someone specifically point out that's the guy that did it, that they would be relying on circumstantial evidence in order to come to a decision. I wanted to determine whether or not that was going to be a problem. I wanted to determine whether or not the jurors were going to have a problem listening to a witness that had previously been a drug user, prostitute kind of woman that had like been on the streets a bit. And I wanted to know if there was going to be an issue with any jurors with regards to the delay in time of the case coming forward.
Thank you. At the conclusion, well, there's a point at which you asked the judge, can we put up, this is page 120, line 5 of volume 1 of the transcript, which is exhibit 5. There's a point where you asked the court, how did I do on time, Judge? Do you remember that?
Yes.
Again, you were cognizant that he didn't usually let lawyers, defense or prosecutors, do voir dire, but he did, in this case, permit the voir dire, correct?
Yes, correct. And he had given us, without telling us exactly how long, he had kind of suggested that we needed to restrict our time a bit.
In fact, at one point, he actually said, are you ready for your 6 questions? Do you remember that?
Yes.
Yeah, implying don't use a lot of time. You used more than 6 questions, and he didn't interrupt you during your voir dire, did he?
No, it was still very quick, though. But he did not.
Again, like all lawyers, you would have liked to have done more. Is that a fair statement?
Yes.
Okay. The next question, the next lines of the transcript, if we could put those up, the ones that follow, it's lines 6 and 7 of that same page 120. The judge asks you a question. Now, your question was about time, and he comes back and says, what one thing do you really want to know? You remember him asking you that at the conclusion of your voir dire?
I do.
And it's safe to say, when you asked the question about how'd I do on time, Judge, you thought you were done, correct?
Yes.
And in response to his question, am I correct that you continued on your voir dire, correct?
Based off of a response to his question, yes.
Am I correct that Judge Morrow was kind when he made that statement of what is it that you want to do?
I would say he was patient.
Will you agree with me? He was not mean.
I wouldn't characterize it as either one.
Will you agree that it was helpful?
Yes.
That his tone and his demeanor before the jury were appropriate and professional?
At this point in time?
Yes.
At that question?
Yes.
For that question, yes.
Do you agree with me that what he gave you in that question to you was advice?
It was, I thought, direction.
You thought the question was direction?
Yes.
Had you asked for the review at the end of the case before or after the voir dire?
I'm not certain. I can't remember.
I think it's possible you had asked for it before.
It's
right?
possible.
And he had told you he didn't think you were, was it tough enough or strong enough? I can't remember the phrase.
Tough enough.
Tough enough. Do you remember your body language in response to, you've talked about the words that you may have said in response, but do you remember what your body language was?
In response to what?
When the judge said, I don't know that you're tough enough, or I don't think you're tough enough. Do you remember what he said, first of all?
He said, I don't think you're tough enough for feedback.
Okay.
Or you're not tough enough for feedback.
Right. And you've testified in direct as to what you said in response. Do you remember what you were doing with your body in response?
Probably being like, Judge, I'm tough enough. I'm tough enough for feedback.
So what you've done to describe is to kind of turn your head to the side and not take an aggressive posture. Is that a fair statement?
Correct.
Is it possible that you took an aggressive stance, that you crossed your arms and said, Judge, I'm tough enough?
No.
What is it that you wanted to know? You remember that was his question. So my question to you now is, do you remember what you wanted to know then?
From the jurors or from the judge?
From the juror.
I believe that my follow-up question to them was, does anyone think that they are a bad fit for this case, to sit as a juror on this case? Because ultimately, that in my mind is the goal of jury selection, is to determine whether or not the people there are fit to be jurors for this case.
And so you boiled down the desire to know whether they were to be fair and impartial to the question directly. Can you be fair and impartial, correct?
Correct.
Let's go to page 128 to 13. Can you read that? This is the question that you asked. Can you read that, please?
Yes, question by me. Question. Does anyone here believe that they would be a bad fit based on the very limited information you heard about what the charges are in this case or this trial for any reason? Seeing no hands at this point, raise your hand if you do, and Mr. Fleas.
So it's fair to say that although you centered on this question immediately after Judge Morrow's statement, you continue, actually question to you, you continue to ask other questions in voir dire. Do you remember that?
I believe the jury responded to my question, and then so from there were some additional follow-up. Yes.
In fact, one of the points of follow-up was your question at page 122 about the press, where you echoed Judge Morrow. Do you remember that just a couple moments ago?
Judge, again, I object. Is he going to ask her every single question she asked on voir dire? It is not relevant to why we're here today.
This is the last question she asked in voir dire, so it's my last question about it. And I'm just asking her, isn't it true in terms of time frame, that question came after this, showing that she had more questions to ask?
One moment, Mr. Campbell,
Yes.
I don't quite understand your response. Are you saying that this is your last question in that line of questioning? Or are you? Go ahead.
Sorry, it's my last question about her voir dire.
I'm going to allow the question.
Do you
But was-
remember? Mr. Phone?
What was it, just that he let me ask that question? Another question?
It's that you had an additional question, and that was in fact the question about the publicity for the case, right?
I believe actually a juror raised some question, I think, with regards to when I had said something about anyone being a bad fit. I believe a juror responded back based on a personal experience he had. And I think that that kind of opened up me to ask a few more. So yes, the short answer of your question is, was I allowed to ask more questions? I was.
Thank you. Do you recall Mr. Noakes's voir dire?
Yes.
Do you remember Mr. Noakes quoting you in his voir dire?
Objection relevance.
Again, it goes to just the whole status of the case and the circumstances. So this is a two-question area, Judge.
All right, so I'm going to sustain the objection for relevance at this point. Mr. Campbell, is this something that you want to make a record of so that we need a separate transcription of this?
No, I'm ready to move on, Judge.
Thank you.
Ms. Chappone,
Yes.
do you believe that you addressed the issue of the duration of time between 2003 and 2019 for the jury in your voir dire?
Objection relevance.
Again, Judge, we've heard testimony from this witness that in the back, when they're talking, it's about the voir dire.
Your question again is what, Mr. Campbell?
I'm going to ask the court reporter to please read it back so it can be accurate.
A moment. Do you believe that you addressed the issue of the duration of time between 2013 and 2019 for the jury in your voir dire?
No, the 164. But put it up when I ask.
All right. Mr. Campbell, your response to the relevancy, because I'm not seeing the relevancy at this point.
This witness has talked about how in chambers there was a 2-hour discussion. And in parts of that 2-hour discussion, we haven't heard how much, but we know that it's one of 3 items that they've described. There was an argument about the voir dire.
All right. So at this point, I am going to sustain the objection. If you'd like to make a separate record, I'll ask Ms. Jorgensen if you would please open the different transcripts so that we can have that information.
I would. It's just that question, but I would like to have an answer. Thank you.
Okay, I'm ready, Your Honor.
Thank you. All right, Mr. Campbell, we're ready.
Thank you. And I'm sorry to do this, Ms. Jorgensen, but could you read the question?
Of course, just a moment. Do you believe that you addressed the issue of the duration of time between 2013 and 2019 for the jury in your voir dire?
Yes, but not adequately.
Thank you. I'm ready to go back onto the record, if we may.
Thank you. Ms. Jorgensen, are we ready?
I am ready, Your Honor. Thank you.
Thank you. Continue, please.
Thank you. A jury was selected, correct?
Correct.
Do you know how many of the jurors that gave estimates of time as to what some time meant. Remember, that was the issue with Mr. Noakes.
Yes,
Do you remember how many of those jurors ultimately made the final jury, the petit jury, I guess you would call it?
I don't. A good number of them, because I think we only went back and forth and only a few jurors were excused prior to us having a panel.
Thank you. In the reading of the, well, I should say, in the giving of the instructions to the jurors, you were there when Judge Morrow did that, correct?
At the end of the case or at the preliminary instructions?
Let's do the preliminary instructions.
Yes,
Okay. It's fair to say that Judge Morrow is unique in the way that he gives his instructions.
yes, he doesn't read from the CJIs.
Where was he when he gave the instructions physically?
The bench.
Have you seen him give instructions not from the bench?
No.
So among the things that he talked about were examples of bias that the jury needs to be careful to avoid. You remember that?
Yes.
One of the examples involved him confessing to how he used to set reservations when he was basically in high school and would go out on a date. Do you remember that?
Yes.
He would use, based on his brother's instruction, he would use the name Dr. Morrow at a restaurant. And do you remember that?
Yes.
And it would usually produce a much better place to eat in the restaurant because everybody thought he was a doctor because he had called himself a doctor. You remember that?
That's what he indicated. Yes.
He also gave an example of bias involving women and work. Do you remember that?
I do.
This is page 164, lines 5 through 19. I'm going to put it on the screen for you here, and I'm going to read Judge Morrow. I want to make this clear. Judge Morrow and I are both Detroiters. I'm from the Lower East Side, and he's from the West Side. That makes us the same people divided by a common language. So there may be some times where I need to pause, but I'm going to do my best here. Employers used to ask a woman one of the questions for employment: do you have children? Why are they interested? Do you have children? Because guess who stays at home when the kids get sick primarily? It would be the women. And the employers would be worried about paying absent time or absent leave, and who wouldn't be there, to do the work. And so they outlawed it. Can't ask that question. And so the question used to become, okay, well, we'll start at 8 o'clock. But if a couple of times during the week we had to start at 7, would that be a problem? And guess what the response was? Well, I might have to get somebody to take the children to school. Bam. Oh, they become quite gifted and skilled at being able to circumvent some stuff. Do you remember him describing that to the jury?
Yes.
You remember the credibility examples then going into the idea of what is a good day?
Judge, I object. Was this the separate record?
No.
This is not the separate record, then I object to relevance.
Thank you. Mr. Campbell, response.
Judge, this part in particular is important because, as the judge explains, having a good day, it's one thing to say to somebody, how was your day? It was a good day. It's another thing to find out all the aspects of what happened to the person that day and make the decision that it was a good day. It's our theory, in part, that the prosecution, Ms. Chaffone and Ms. Bickerstaff, had a very bad day. And it's our purpose to show that through examples. And
All right.
so the setup for that.
Thank you, Mr. Campbell. The objection is sustained. Mr. Campbell, would you like to make a separate record?
I would, please.
All right. Thank you, Ms. Jorgensen. Mr. Campbell will probably need you to read that last question, and then if you will, then be ready to go to the separate transcript.
I will, Your Honor, just a moment. I'm sorry. Remember the credibility examples, then going into the idea of what is a good day.
All right. And Ms. Jorgensen, you're ready for us to proceed? She's indicating.
Yeah, thank you.
Thank you. Mr. Campbell, go ahead.
Thank you, Your Honor. So I'm going to put up page 164. These are lines 5 through 19. Again, Exhibit 5. I think it might be, sorry, that's the wrong one. It's 160. You put up the right one. This is 164.20, line 20 through 165, line 16. It's divided into two different screens. And I'm going to read for Judge Morrow here. And I'm beginning that now. Like we talked about, some people ask conclusions with the question instead of asking for the information that you can make the conclusion. You know, you'll have to trust me if I tell you that yesterday I had a good day. But if I told you yesterday when I woke up that it was the smell of the food and it was the tray right next to the end of the table with a little rose in there. And then when I went to take a shower, I, for the first time in a while, had a fresh towel that wasn't damp, that the bar of soap hadn't been used. Continuing. And then I went to the car that was dirty the night before, and the car was clean. And there were 6 $1, $100 bills on the passenger seat with a little note that said, "Baby, have a good morning. I don't even have to tell you what kind of day I was having. I gave you the facts. You're like, Bruce is living a vida loca. And if I tell you I had a good day, you have to piece it together based on your bias. What did they look like? You as jurors can demand information so you can draw your own conclusions, and so you should." You remember that being discussed and stated by my client during the voir dire?
Yes.
Thank you. I want to move to the opening statement, and I would ask that we go back to the record.
I'm ready, Your Honor.
Thank you. Continue, Mr. Campbell.
Thank you. Ms. Chaffone, your opening statement goes from page 169 to 177 in the transcript. You described the anticipated testimony of Ms. Leak. You remember doing that?
Yes.
You described the anticipated testimony of Mr. Matheson. This is the neighbor. You remember that?
Masterson. Yes.
Masterson. I appreciate that. You covered the text and the blood from the house, both the deceased and Mr. James Matthews' blood, correct?
I don't know about his blood, but yes.
Were you aware of what James Matthews would ultimately give as an explanation for how her blood was in the house and how his blood was in the house?
Judge, I object. Again, this is not relevant to the judicial disciplinary proceedings.
Mr. Campbell?
I'll
Any
withdraw the question and I will ask another if I may.
You certainly may.
Thank you. You also covered the anticipated testimony of Emery Matthews. Do you remember that?
Yes.
You remember telling the jury that Emery Matthews would come in and testify that James Matthews admitted to a killing in 2002 and 2003. May have been or. 2 killings.
Correct.
Several admissions. Do you remember that?
Yes.
Judge, I object to this line of questioning. It is not relevant.
Mr. Campbell?
For the
Response.
reasons that I have already stated back in our meetings, I believe it is extremely relevant and necessary. So I would move to a separate record if the master does not agree with my assessment on the relevancy.
Yes, we'll go to a separate record at this time. The objection is sustained. Ms. Jorgensen, if you would read that last question.
Yes, one moment.
Can you put up on the screen 175? Thank you.
You are coming in off.
Yeah.
Do you remember telling the jury that Emery Matthews would come in and testify that James Matthews admitted to a killing in 2002 and 2003? I'm sorry, 2003.
I do.
In fact, here's the transcript of your opening. Tell me if you recognize it as such, and if you could read it, please.
Yes, I don't know which portion of this. It looks like it's from 170, page 175, lines 9 through 16.
That's correct.
It says, "You will also hear from Mr. Emery Matthews." Now, Mr. Matthews is the brother of the defendant. He's going to be here to testify, and he's going to tell you that he had several admissions from his brother. He's going to tell you that his brother admitted to killing 2 different women in the summer of 2002 or 2003, and that he did so because the women had stolen money from him that he was using to buy drugs.
Had you met Emery Matthews prior to the trial?
The morning he arrived, I did not personally talk to him. My officer in charge did. So, no, I don't believe so. No.
Did anybody alert you that Emery Matthews would not testify that his brother had made admissions to him?
No.
You just testified earlier in this proceeding that he was, I don't know if the words were shaky or flaky.
I think I said wild card.
Yeah.
Yes.
Why did you use that term if you hadn't had anybody tell you that he would be a wild card?
Because he was the brother of the defendant. He had never made a statement to police or anyone about his brother's involvement with his brother present, the defendant. So anytime you have a sibling in a situation like this or family member, I think it's kind of a wild card. You never know if they're going to show up and be truthful, if they're going to show up and go south on you.
Did you avoid talking to him because he was a wild card?
No, I wish I would have gotten to talk to him, but we were moving very quickly. And so by the time he arrived, we were already getting started.
If he had told you before testifying that he was not going to testify consistent with the police reports, would you have put him on the stand?
Objection, speculation.
It's a separate record.
We are in the separate record.
I can't say. I would have definitely probably not referenced it in my opening. I would have probably still put him on because the officer who took his statement ultimately testified to impeach him with regards to his written signed statement that he had made previously. So I would have put him on, but I don't know that I would have referenced anything about it in my opening. And I surely would not have represented it the way that I did in my opening had I realized that he was going to try to recant.
You believe, as you sit here today, that you could have put him on even if you knew that he was going to refute what was in the police reports?
He didn't refute the entirety of the police reports even when he testified. He admitted to making the reports. So yes, given the fact that he admitted to making those police reports, yes.
You agree with me, he refuted the entirety of the portions of the report that said that his brother had made admissions to him.
The portions of the report in which implicated, which he said that his brother killed someone, yes. Other portions of the report that were still significant with regards to what the testimony and the evidence in the case was, he didn't disown or disavow all of it, no.
I will leave the separate record and I have some additional questions. This will be page 176, lines 22 through 3 on the following page.
Thank you. Are we back on the main record, Ms. Jorgensen?
We are, Your Honor. Thank you.
All right, proceed.
You told the jury that they would hear evidence that Ms. Leak was a drug user in 2003 and that she had been 10 years sober, correct?
Correct.
And you actually ranked that third as you were describing issues that would come up in the case. You had given the first 2 and this was the third. Do you remember that?
I don't remember the order, but that's possible, yes. Sure.
Thank you. And number 2 that you ranked, and this is page 176, lines through 16 to 21, was that there was no eyewitness.
Correct.
So this is in ascending order as I'm presenting it to you, but it was descending order at the time of the trial. And the third item, which really, actually, I should say it, the first was the issue of the time.
Correct.
And you called it you said that it was a matter that had been there for years. The case had sat, it grew colder.
Correct.
Do you believe that's an accurate description?
Objection relevance.
Response.
Again, Judge, this case is about a discussion that occurs, at least her testimony is about a discussion that occurs in chambers, and that discussion involves aspects including the opening statement.
Thank you, Mr. Campbell. The objection is sustained. We'll go to a separate record again. Ms. Jorgensen,
I'm ready, Your Honor. Thank you.
would you please read that last question?
I'm sorry, Your Honor. I had to shift my screen.
Certainly.
So this is good, and the next one's going to be 177.
Do you believe that's an accurate description?
All right, Mr. Campbell, you're ready to continue?
Yeah, well, that's my question. I think.
I believe, yes, that's an accurate description. As the shelved rape kit sat on the shelf untested, the case grew colder.
But this wasn't a rape case, was it?
That's still how the suspect was identified. And just because CSC was not charged does not mean there's no sexual assault that occurred.
But do you think you could bring in evidence of a sexual assault where you have not pled it?
Yes, if the facts and circumstances surrounding are relevant to the actual crime or homicide charged, yes.
You don't.
I didn't allege that it was a sexual assault.
You don't think you would need a 404B motion for that?
If it's all part of the same incident, I didn't allege that it was a sexual assault in my case.
Okay. Remember that you didn't allege it, because we're going to go back on the big record in a moment. But the reality is, this case was based as much on the admission that was given to Emery Matthews as anything, correct?
No.
So you're saying that it didn't have an admission. Okay. The admission, though, was from 2005. Is that correct?
I'm not certain on the date. But sometime later, definitely sometime later than the homicide. I don't have the date handy.
Well, let's see if you talked about it in your, you didn't mention it in your opening. We'll get to it. I'm ready to go off this record and go back into the main record.
All right, Ms. Jorgensen, let us know when you're ready.
I'm ready, Your Honor. Thank you.
Continue, Mr. Campbell.
When you finished your list of 3, what you did is you began to address issues that you wanted the jury to be aware of that the defense would raise. Do you remember that?
No.
We have 177, page 177, lines 4 through 7. Could you read that, please, Ms. Chaffone?
Yep. As you listen to the evidence in this case, beware of what they call red herrings. A red herring is something that's meant to distract you from where the evidence is.
First of all, do you know what a red herring means in terms of what it's an allusion to?
Objection relevance.
Mr. Campbell, response.
There was no objection to her reading this, and she used the term red herring. I'm asking her what she meant when she said it.
Further objection, if any, from disciplinary counsel?
It's not relevant.
All right. The objection did not come earlier. I'm going to allow the question. Go ahead.
Thank you. Do you remember the question, Ms. Chaffone?
Well, no, what was the question?
I'm going to have the court reporter read it back just to make sure we get it accurately.
Yes, just a moment, please.
Oh, I remember what my definition of red herring is.
Let's wait for Ms. Jorgensen to be ready, and then we can proceed.
Do you know what a red herring is in terms of what it's an allusion to?
And my response is the same as what I had described in my opening, just that it's something meant to distract, to keep an eye out for something that's meant to distract them.
It's actually a fraudulent act. It's the act of dragging a fish across a fox's path so that the dogs are led in a different direction on purpose. Did you know that that's where that came from?
No,
Were you accusing the defense of being fraudulent? Was that your intention?
Objection, relevance.
Oh, boy, if there's no more-
I'm going to allow the answer. Go ahead and answer.
no,
Do you remember what happened after you made the statement that we just had up on the screen about the red herring? Do you remember what happened?
the judge stopped me and said that I could not do that.
Have you made that same statement or one similar to it in a opening statement previously?
I'm not certain.
Have other judges let you make that statement without it being noted or objected to or corrected?
Well, I don't even remember if I've made it before, so I don't remember if the judge has stopped me.
And you were the mentor for Ms. Bickerstaff, correct?
I saw her as someone that I was mentoring. I don't know how she saw me.
Let's go to page 177 in Exhibit 5, lines 8 through 11. I believe this is Judge Morrow, and I'll read it here. It says he's interposing. Excuse me, I love you for that. But as to what the evidence will show, not anticipating what might be used, trying to rebut that. As to what your case will show, please. You remember Judge Morrow saying that?
Yes,
First of all, did you react in any way that was negative when he said, excuse me, I love you for that?
no,
Do you believe that he meant that in the kindest way possible?
I don't know how he meant it.
How did you take it?
I took it as move on.
Can we put
From
that
that-
back up? I think my administrative assistant heard the move on and we moved off the thing, so let me get that back up. Do you recall how Judge Morrow referred to men and women who came before him as witnesses, if he didn't know their names or maybe even if he knew their names?
Objection, relevance.
Any
Well, I gotta-
response?
I got to start leading all my questions, Judge. I'm going to withdraw it and ask another.
Go
So-
ahead. You're going to withdraw and ask another.
Yes.
Go ahead.
Do you recall that Judge Morrow referred even to the jurors as young ladies and young men?
Yes,
Objection, relevance, and hearsay. I'm sorry, leading. Relevance and leading.
It's definitely leading, but this is cross-examination.
Objection is overruled. Continue.
Thank you. It does make me, because I know Ms. Weingarten is a very good lawyer and she knows that. It does make me ask, I guess at this point, Judge, it's 10 after 1. I have a considerable amount of testimony yet to take from this witness. I'm happy to continue, but I think Ms. Weingarten's objection may indicate we probably all could do with a little bit of food. So I leave it to you. I'll continue if you like.
I don't know what her objection meant with respect to food, but I do know that we discussed earlier that we would decide on the hearing day when it would be a good time to stop. So counsel, if you'd like to respond to that suggestion, Ms. Weingarten, that's perfectly fine. I don't have any problem. I do know that we said we were going to take about an hour lunch break. So we can do that now. Ms. Weingarten, any comments?
Yes, Judge, I don't need to eat right now, but I would like to inquire of Ms. Chaffone whether she needs to eat.
no, I'm good to keep going.
I'm happy to keep going.
I'm happy to keep going. If the court reporter is happy to keep going, Your Honor, And you are, we have a quorum.
Ms. Jorgensen.
I'm fine, Your Honor. Thank you.
Let's continue then. Thank you.
Thank you. You would agree with me, Ms. Chaffone, that your statement in opening was not proper for an opening.
Objection, relevance.
Mr. Campbell, any response before I rule?
So the witness testified on direct that the judge made a statement about how she was not a proper mentor. She overheard him saying that because he said it loudly enough to Ms. Bickerstaff. So the JTC, the disciplinary council, brought that into this case.
All right. As goes for relevance, I am going to overrule the objection. You may continue.
Thank you. Do you remember the question, Ms. Chaffone?
Something along the lines of, was my opening statement not proper?
Yeah, I'll restate it. Do you agree with me that your opening statement was not proper in that section that you read where you talked about a red herring?
I wouldn't say it was not proper. I would say, had I gone further, it could have turned argumentative.
Would you agree with me that the judge was correct to stop you when he did?
Probably, yes.
Would you agree with me the judge was polite when he stopped you?
I wouldn't characterize it.
Why would you not characterize it?
Because he said, I love you for that, but I'm not going to allow that. That's not a response to an objection or to I don't know if I would say that was kind. I would say that it is what it is. I think it's moderately inappropriate.
What did you think was inappropriate about it?
He's saying, I love you for that in the middle of a jury trial, in the middle of an opening statement on a first-degree murder case where the allegation is that he strangled a woman, dragged her out of the home, and left her dead on the front lawn. So I don't think it was really appropriate given the context of what we were there dealing with. I think you could have easily just said, I'm going to stop you. Don't get into that. Let's keep going.
You think that the abruptness is somehow more professional than being kind to somebody by saying, in a nice way, don't do that.
Well, kind is your characterization of it.
And I want to get back. You said you're not overly sensitive when you testified on direct, correct?
I'm not, which is why I didn't say anything about it. I didn't even reference it in my affidavit.
Okay, so you would agree, though, it would be overly sensitive to make a point out of this, love you for that, lead in to an instructive moment in terms of telling you that you had gone too far in your opening statement.
I don't know that it would be sensitive when you are evaluating the rest of what occurred during this trial. I would say that it was on par with a lot of the inappropriate comments that were to follow.
Would you have filed a judicial tenure complaint based on that?
I would not.
Mr. Masterson testified, do you remember that?
He did, yes.
Do you remember leading Mr. Masterson through most of the direct examination?
I'm not sure.
Do you remember where Mr. Masterson did ID Mr. Matthews?
I do know he did identify him, yes.
Do you remember that when he did so, it was a little bit on the weak side? He said, yeah, I think that's him.
I think, yes, I do remember that. I wouldn't characterize it as on the weak side. I think that you would have had to see the witness, Mr. Masterson, in his demeanor to understand that he was a very nervous, he was a different type of a witness, I would say.
What do you mean by that?
He was extremely nervous. He had a bit of what I believe was a speech impediment. He was insecure, I would say, when he was responding to things. He would kind of waffle a bit. But Mr. Matthews was his neighbor for half a decade, I want to say, or more. So I was confident that in his identification. So I wouldn't characterize it as shaky, no.
The issue in the case was not whether Mr. Masterson knew Mr. Matthews, right?
No,
It was whether he had seen Mr. Matthews with the decedent, correct?
and Mr. Matthews' statements to Mr. Masterson the next day when the woman was dead on the lawn saying, "I don't know her."
So you can lead, and you know this, right? You can lead a witness sometimes on direct,
If they're a hostile witness, in certain circumstances, yes.
and you can lead on preliminary questions even, right?
For background information and other specific issues, yes.
It's also a way to control a witness who's being difficult, fair to say.
If you can qualify them as hostile, yes.
Do you have to, in Michigan, qualify somebody for hostile anymore?
Objection relevance.
It goes to, again, the mentor role here. She's not right on that, so I think I should be able to make my record.
Objection is sustained. You may make your record, Ms. Jorgensen, if you would repeat the last question, and if we could go to the separate record, please.
Just a moment, Your Honor.
Certainly.
Do you have to in Michigan qualify somebody for hostile anymore? And I'm ready for the separate record.
Thank you.
My understanding is yes.
So you probably can't tell on Zoom, I look probably much younger than I appear, but I think even before I was born, you weren't aware that they changed the law, that it's really not a proper objection when somebody is hostile to say, judge, declare them a hostile witness because of the effect that may have on the jury that now changes the way they hear this because this person was called a hostile witness. You don't know any of that?
Objection relevance.
Again,
We're on the
it's
separate record. Continue.
It's not that I don't know it, that it wouldn't do that. I wouldn't have done it while he's seated in his seat. We would have approached, I would have talked to the judge about it. We would have gone back and forth outside the presence of the jury. And then the judge would have made a ruling saying that the witness was a hostile witness, that I was given permission to lead the witness based on that. And then the jury would come back in and then we would question the witness as though they were hostile. That is my understanding.
Thank you, Ms. Chaffone. I don't mean to cut you off, and I apologize if I did. What I'm trying to get out is, do you know that if you are asking leading questions to somebody who is in fact hostile, that it would be improper for the other side to object to you based on the fact that you were asking leading questions? Were you aware of that concept at all?
I'm not sure.
Thank you. You understand the theory behind that, right? Because it would turn the witness if all of a sudden they were termed hostile. It might turn either the court or, more importantly, a jury. It would change the way that testimony is coming out. It's an improper objection. You understand the theory behind that, right?
Objection relevance.
Again, separate record.
That's true.
I'm clear on the theory.
Thank you. I think we can go out of the separate record, and I'm ready to continue.
All right. We'll wait for Ms. Jorgensen's okay on that.
I'm fine, Your Honor. Thank you.
Thank you. Mr. Campbell, continue.
Thank you. Do you remember that Mr. Masterson? Masterson. I do appreciate those corrections. Thank you. Do you recall that Mr. Masterson could not recall the date of January 9th, 2003 when you asked him about that?
Yes.
You remember that you followed up nicely with questions about, did you recall a time where there was a body on the front lawn?
Yes.
I got to ask, in that opening statement that we read about before, where you talked about several admissions and 2 killings, remember that in the opening?
Yes.
Why did you mention 2 killings in a case about 1 killing?
It was based off of the statement made by the brother.
Was the other killing one of those that had been suppressed under the 404B motion?
My position would be yes. But I believe the testimony of Mr. Emery Matthews was something that was fleshed out in advance of trial, if I recall.
You think there's an order somewhere that allows you to talk about 2 killings through Mr. Emery Matthews?
Not in order, no.
Objection, Your Honor. This has nothing to do with the disciplinary proceeding.
It has everything to do with the issue of being a mentor and the comment by the judge that was elicited. And it's not in any affidavit, Judge. It's not in any report, no memo. It's not in the prosecutor's big report that they did. It's not in the request for investigations that my client was served with. It's not in the answers that we've done. It's not in the formal complaint. They came in here. They talked about this issue of whether or not she was a good mentor, whether
Thank
or not
you.
that's something that she should follow.
Thank you, Mr. Campbell. The objection is sustained. We'll go to the separate record. Please read back the last question.
One moment, please.
Certainly.
Oops. Do you think there's an order somewhere that allows you to talk about 2 killings through Mr. Emery Matthews? And I'm ready for the separate record.
Go ahead. You may answer.
Thank you, Judge. No order.
It's an old one that we did already. I apologize, Ms. Chaffone. I did not hear your response. I'm going to ask you if you could please repeat it.
Yep, I said that there was no order. It wasn't like an order issued. I believe it was mentioned, if I'm correct, and I could be wrong, but if I'm correct, I believe it was mentioned at the motion hearing that there would be testimony from the brother. And I believe that the judge's response to that was if he was going to come in here and say A, B, and C, that would be allowed, if I'm correct. And it was not in the trial transcript. It would have been at some earlier pretrial date, but I'm not certain.
Did you try to talk to Mr. Emery Matthews before the trial?
I don't recall.
If he were to come in here and testify that you did try to talk to him and he did tell you he was going to tell you no, if you asked him about admissions, would he be accurate?
Are you asking me to comment on if he came and said that I talked, if he came and said what? Was that?
The court reporter to read it back, and if it's unclear, I'll certainly correct it.
Just a moment. If he were to come in here and testify that you did try to talk to him and he did tell you that he was going to tell you no when you asked him about admissions, would that be accurate? Would he be accurate? I apologize.
I don't have any recollection of that.
So you're saying it's possible?
I don't know.
So you're saying it's possible?
I'm saying I don't know. I'm saying anything is possible. I don't recall that though. No. I'm not saying I never spoke in life to him before the date of the trial, but the fact that he was coming at the trial and that it wasn't going to pan out how, I wouldn't have said it in my opening if I didn't think that that was the testimony that we were going to get.
Have you ever been part of a trial where the defense makes the argument at either in opening or in closing that the prosecutor's opening statement is like a check? And I want you, as in the kind of thing you cash, and I want you to hold the prosecutor to that and see if it cashes at the end of this case. Have you ever heard anybody make that argument?
Judge, I'm not sure if we're in the separate record or not because I can't
We are.
keep track. Okay.
We are.
Do you remember the question? If not, I can repeat it.
No, I do. At any point, like any trial?
Yeah.
Yeah. Yes.
So to the extent that you had written a check, in this case, you had said that Emery Matthews was going to tell the jury that James Matthews admitted to killing somebody in and around the time that the deceased was killed, and that there were 2 killings and that there were several admissions, right?
What was your question?
My question is,
Are you
that
saying
would be
I didn't cash that check? Like I
Yeah.
failed to deliver on that point?
correct.
To some degree. I think that the officer that came to testify, who in fact said he didn't know Mr. Emery Matthews and that these were his statements and that was his signature, I thought that while I may not have delivered on the words that came out of his mouth, that ultimately there was some question about whether or not it was said. So to an extent, yes.
Do you believe that your opening statement comported with the ruling on the 404B issue that had occurred in May of 2019 and that had been affirmed by the Court of Appeals?
Yes,
Why?
Should we be on the record?
because I thought it was proper.
Why did you think it was proper to talk about a killing that had been suppressed under the 404B?
Again, based off of what I believe had occurred previously, I thought it was proper.
But what had occurred previously is you had an order that said you can't bring in the 404B evidence. And what had occurred previously is that the Court of Appeals had affirmed that.
So what I was talking about is I believe that there's a discussion like I had indicated, I believe that there was some discussion about if he came and testified, he could testify to that.
And you don't know when that was.
I don't have a copy of any of the motion hearing transcripts, no.
And you believe there was a motion hearing in front of my client, Judge Morrow, about a guy who ultimately came in and said, no, I never said those things.
Not specifically a motion hearing dedicated to that. I believe it came up during, I'm not certain. I'm honestly not certain. I do believe that regardless, I believe that my opening was proper.
Well, now let's be clear. Is it proper because you thought this other hearing had taken place, or is it proper no matter what?
I think that my opening is proper.
You think it was proper even if there's no other hearing and there's no other statement about what Mr. Emery Matthews can or cannot testify to?
I thought my opening was proper.
In light of the 404B, you still think that was proper?
I think that my opening was proper. Yes.
You didn't make a mistake when you made that opening. That was purposeful, and it's not something now you would look back at and say, oh, that was wrong.
I think that my opening was proper.
Thank you. I'm ready to go back on the main record.
All right.
I'm ready, Your Honor.
Thank you. Proceed.
Thank you. Do you think your opening was proper, ma'am?
As I indicated several times just now, I do believe it was proper, yes.
Okay, we did a separate record, so I want to make sure it's on the main record. You believe that your opening statement did not violate the 404B, correct?
I believe that my opening statement was proper, correct?
And irregardless, I don't think that's a word, regardless of any other hearings, you're not relying on anything else. You believe if all there is in this world is the 404B decision by Judge Morrow, the Court of Appeals decision that followed, and your opening statement, you believe that talking about two killings in your opening statement was appropriate.
I believe that my opening was proper.
Is that something you would train somebody to do?
What?
Take that approach on these facts. You would encourage a mentee to give an opening statement that included a second killing in light of the 404B decision that you knew was out there.
I would encourage someone that I was supervising to do an opening statement that was reflective of what the facts and evidence were in the case.
Facts and evidence, irregardless of court rulings?
I would have them base it off of the facts and evidence of the case and the restrictions of whatever the law or the rules were.
Were you trying to sneak something by the defense and also by the judge when you talked about two killings in your opening statement?
Objection, relevance.
Response, Mr. Campbell, if any?
Goes to the mentoring, and it is the red herring.
The objection is sustained, and we will go off the record if you want to.
No, I will move forward. I appreciate that.
All
Let
right.
me just a moment to find myself in my notes.
When I said we will go off the record, I meant to say we will go off the official transcript to the additional transcript that we were using. Go ahead,
Right.
Mr. Campbell.
Yeah, I want to stay on the main one. I'm going to withdraw my question that was objected to, and I would like to proceed, if I may, with questioning the witness.
You may continue.
Thank you. So there's a time where Mr. Masterson was asked about whether or not he saw Mr. Matthews. Do you remember that?
Yes.
You remember that he told you originally that he did not remember seeing Mr. Matthews.
I think that was his initial response, correct?
And it was not, can't remember, but it was a no. Do you remember that?
Yes.
And what you did in response to Mr. Masterson was to pick up a prior transcript of a statement under oath that he had provided during the investigation, and you had him read it and agree with it. Is that a fair statement?
I do know that I confronted him with his statement. Yes. I don't know if I confronted him with it for that question, because my understanding is that I had asked him, so you never, I think I had continued on the questioning at that point. I don't know that I showed him a transcript then.
Do you remember, well, let me ask you this. You would agree with me if a witness answers no to a question that it's not proper to refresh recollection at that point?
I would need more background. I need more context. In what way?
You ask the question to a witness, did you see Mr. Matthews on January 9, 2003? And the witness says no.
It would have been more proper to impeach him.
But you would agree that it's not refreshing recollection?
If he does not say that he didn't remember, correct?
Thank you. Do you recall leading Mr. Masterson for 2.5 pages of his testimony from the point where he said no, and you handed him the transcript and said, well, read this, read this, read this. Do you remember that?
I do remember going over some things with him in the transcript. I don't remember if I led him for X amount of pages or not, but.
Appreciate that. If we could go to page 190 of the first volume of Exhibit 5, lines 16 to 24. Do you remember why you stopped leading him?
Well, you just put a transcript up on the screen and it looks as though the judge stopped me from what you put up on the screen.
That is correct. I wondered if you remembered him stopping you.
No.
Thank you. I'm going to read it, and then there is a line for you at the end at line 24 when we get there, because that's you. You ready? Interposing. And you know what interposing means, right?
Sorry, what did you say?
Ms. Chaffone, you know what the word interposing means on a transcript, correct?
Yes.
It means he's interrupting you. Is that a fair statement?
I agree.
If I might, please. You're not refreshing his memory because you haven't asked him a question about what did he tell the police. You're just reading stuff right now. You can ask him questions about what he remembered the police. There's an SIC there in brackets. You can refresh his memory with that. This is an aside here. Maybe Mr. Allen, likewise, an East Sider like me. If you now back into reading, if you'd like, but you just can't read it. That's not the proper way to have that information introduced. You see that?
I do.
And what was your response at line 24?
Thank you.
Does this refresh your memory of what the conversation was between you and Judge Morrow at that point?
I remembered the conversation. I just didn't know if it came right after that point in time.
How about the way that he interposed or interrupted, where he said, what was the phrase, please? Can you put that back up? I'm sorry.
Are you asking if I remember that?
I'm asking if you do remember him saying, if I might please, as his introduction.
I didn't remember that exact verbiage, but now looking at it, yes.
Do you remember his interruption being done in a kind manner?
Again, I don't know if I would characterize it as kind. I think that he was trying to stop me, which he did. I didn't take that offensively.
Thank you. You agree with me that in addition to whether one can lead or can't lead, there are substantive concerns on a record that is made with all leading questions in terms of ineffective assistance of counsel, for example.
Am I aware that could be a problem?
Yeah.
Yes. I don't know about ineffective assistance of counsel. I would say, I don't know if with that regard, but I do know that there's a rule to govern that.
You would agree that Judge Morrow's job, because he's the judge, is to ensure a fair trial, correct?
Yes, that's the judge's role.
You don't dispute where he did interpose here in the exhibit at page 190, line 16 through 24. You don't think he was being unfair, do you?
No.
Did you mean the thank you that you gave at line 24?
Mean it in which way?
Did you mean thank you, or did you mean something else, but we're just being polite?
I meant thank you, as far as thank you, I'll continue on. Not like a thank you so much for that information, more so of a like polite thank you, and I'll continue on with that.
Do you know what you did next after the thank you?
I'm not sure.
I don't want you to guess, but you don't know as you sit here right now, correct?
Correct.
Can we put up page 190, line 25?
Judge,
Goes to page 190.
before they do that, I have an objection.
What's the objection?
The objection is that we did not raise the issue in our opening statement that Judge Morrow was wrong in criticizing Ms. Chiffone or telling Ms. Bickerstaff she should find a different mentor. We only raised it to show that he was willing to criticize her harshly and publicly in court, in contrast to telling Ms. Bickerstaff that he wanted to talk to her privately to criticize her. The substance of the criticism of Ms. Chiffone has nothing to do with this case. And that's what Mr. Campbell is spending his time on.
So
Judge,
your objection then is your objection to relevance, and you're just giving more explanation of
Yeah.
it, or is it a different objection?
No, it's relevance with an explanation.
Thank you. Mr. Campbell, response?
again, I think it's relevant. It's in the same area of the conversation for the previous transcripts that I put up. In addition to that, the suggestion has been that Judge Morrow did not treat her well on the record. This is the record of how he treated her. We have testimony about things that we don't have a record for. You're going to have to judge the credibility of that. And part of that comes in how she answers now about the record we have in front of her. And I am concentrating on those times when they have the interpersonal communications from the transcript. That's what I'm pulling out.
May I
Thank you.
respond, Your Honor?
Yes, you may.
Ms. Chiffone did not testify that Judge Morrow mistreated her on the record. She said that much of what happened didn't make it on the record and that he publicly in the courtroom was critical of her. She did not say it was in front of the jury. She did not say it was on the record.
She has declined to say that he's treated her nice at any stage here. I'm suggesting that the master can take a look at this, the JTC can take a look at this and see how kindly he does, and that her opinion of what is mean on the record or off the record is of no value in this case, or a little value in this
All right.
case.
Thank you, counsel. The objection is sustained. Would you like to make a separate record, Mr. Campbell?
Thank you.
All right, thank you. Ms. Jorgensen, please, if you would take us through the routine for that.
Yes, just a moment. You would like the previous question read?
Yes, please.
Just a moment, Your Honor.
190, 25.
I'm sorry. Last question was, I don't want you to guess, but you don't know as you sit here right now, correct? Correct. And then it was going on to, can you put up page 190?
May I proceed?
I'm ready for a separate record.
Certainly.
Ms. Chaffone, you've probably seen me take a couple of sips of water while I've been talking, and please, if you need anything, let me know. And I'm happy to accommodate that. I'm sure the master, and that's not going to be a problem. But I'd like to proceed now, and I need, it's not that, it's line 25 through on 191, line 4. This is what she did, and then we have the thank you, and then I wanted to show what she did next. That's where I'm taking you, is to the next lines in the transcript. So you can read there, Ms. Chaffone, if you would, the question. I'll read the answer if you can read the next question.
Question, do you remember making a statement to police back then?
And the answer is yes, and then you begin.
Question, do you remember telling the police that, quote, back on January?
You would agree with me that's a leading question, correct?
I would say that it is the beginning of a possible impeachment.
Let's pull up the next screen. And by the way, this is Mr. Masterson. This is Mr. Masterson that you're impeaching?
Correct.
What did he said that was false?
I believe that, I think you pointed out a couple of things, and I don't know if I would say it was false, but I think he indicated that I think you had brought up the point that he indicated he didn't see the defendant, and another point that he, I think it was not having seen the defendant. I'm not certain.
So if you impeach somebody, can you use that as substantive evidence?
Yes, if it's sworn testimony under oath, which his was.
So that's why you would use the impeachment of Mr. Masterson, if in fact you did it. But Mr. Masterson was not a hostile witness, was he?
No, he was a difficult witness.
Okay, and when you say difficult, you don't mean he was a personally difficult person. It was difficult to get him to testify in open court in a manner that he was comfortable. Is that a fair statement?
Yes, correct.
Okay, and so the next screen I think we have up now is the very next interplay between you and Judge Morrow. And the judge, I'll read, and if you can read you. No, no, no. See, now you're telling him what he did. So, excuse me, I'm going to start again. See, now you're telling him what did he remember telling them. You ask him, what did he tell him? See that?
I do.
And what was your answer?
It's under question, but it should have been answer. Okay, what did you tell the police back on January?
And you would agree with me, that is not a leading question.
Yes.
Give me a moment. Do you recall Mr. Noakes's cross-examination? Oh, I'm going to back up. We can go to page. Oh, I think I've done what I wanted to do. So,
Judge, may I interject for a moment? Are we in a separate record?
We are at this point.
yeah,
Then
I'm
I'll
going to go
wait.
back into the record, please. Thank you.
Are we back on the main record?
We are now. Ms. Jorgensen, is that correct?
We
Okay.
are.
Yes.
May I make an objection, Your Honor?
What's
Nope.
your objection?
Mr. Campbell is doing little more than pointing out instances in a transcript that the master or the commission can review without Ms. Chaffone's testimony. I think both sides have agreed to the admission of the trial transcript, which is Exhibit 5, I believe. The record is what it is, and it's in evidence already. So I think that this testimony is cumulative.
That's not the way evidence works, Judge, in any other type of proceeding, and I doubt that it should work that way here. When evidence is admitted, it means you can use it. You can address it with folks. What counsel is suggesting is that members of the Judicial Tenure Commission and even yourself are going to read every page of the document. And by the way, you wouldn't be helped in any way, shape, or form by my questions. Don't answer that. But the reality is that this is what lawyers do. They take evidence, they present it to people who were there, and they ask them what happened in addition to the words that are on the page. And they set that scene by showing them the words on the page. We are 190 pages into this transcript, and I think I have referenced, I'm going to say 20, and it probably isn't that.
All right, thank you. Anything further, Ms. Weingarten?
No.
All right. Your objection, I believe, was to cumulative testimony. That objection is overruled. Continue, Mr. Campbell.
Thank you. Ms. Chaffone, Mr. Noakes did a cross-examination of Mr. Masterson, correct?
Yes.
One of the things he keyed on was the fact that Mr. Masterson didn't seem to be answering any of the questions directly, but only seemed to be parroting information that you were giving him. Do you remember that?
Yes, I think so.
Camille Leak was the next witness. Do you remember her?
Yes.
She had given a statement in 2003. We've talked about that briefly, correct?
Yes.
You remember asking leading questions of Ms. Leak.
I could have, yes.
Was she a difficult witness in any way at all?
She liked to kind of, I would say maybe run on a bit.
Okay. So certainly, again, not personally, if you will, a difficult witness. That's
Yes.
fair.
Yes.
And as not as difficult as Mr. Masterson in terms of speaking to and addressing testimony to a jury. That's a fair statement.
Yeah, fair.
Thank you. I think it's, by the way, Ms. Leak is day 2 of the trial, correct?
Yes.
So Mr. Masterson is the first witness called and the last witness on the first day.
Yes. The only witness, I think, on the first day.
Thank you. And Ms. Leak is the first witness on the second day. Fair
Yeah.
statement?
Yep.
We have volume 2 of Exhibit 5, page 22. I believe it's lines, by starting there and going on to page 23 at line 7. I'm going to pull this up. And I believe it's going to be Judge Morrow. And so I'll read that, and where you're identified, if you could read, please.
Okay.
You ready?
Yeah.
Starting at line 22. You know what? You're not intending to, but all of those questions are leading, because you're not asking her, what did you tell him? Or did you tell him anything about? You're asking specifically, did you tell him where he lives? Yes. Did you tell him? Those are leading questions.
Response, okay.
Judge Morrow continuing, as opposed to open-ended questions.
Response, thank you, Judge. I'll be cautious of that. Thank you.
You would agree with me that this is advice, correct?
Yes, I would say it was more of, I don't know about advice, but it was direction. It was a ruling. I took it as a ruling.
It certainly was a ruling, and as ruling, can you put it back up for a moment, please? Was there anything that you were offended by in this direction that you received, in this ruling that you received from the court?
Did you say offended? Was that the word? No.
Offended, yes. Thank you. We'll go, I want to show the preceding page so it's in the record. And this is page 22, lines 4 to 21. I'm going to ask, well, you see it, line 4, it begins with a question from you. Do you see that?
Yes.
Can you read that, please?
Question. Okay, and did you tell them the individual that you had?
And the judge interposing says, how about what did you tell them? You see that?
Yes.
So this is the judge, essentially a page earlier from the last, pointing out that you were asking leading questions, correct?
Yes.
And it's fair to say that the rest of the page is filled with some leading questions, leading to his next interposing. Is that fair? The one
Well,
that
I
you
wouldn't characterize them all as leading. A leading question in my mind suggests the answer. So just because you contain information within the question doesn't necessarily make it a leading question. So I don't agree with the characterization that several of them were leading. I think some of them were maybe not as open-ended of questions as the judge would like, but what ultimately matters is the judge's interpretation of it, and he found them to be leading. So I tried to adjust that.
I believe my question was some, it was not all, but I appreciate that. Can we put up page 39? This is a volume 2 on exhibit 5, lines 22 to 40. Sorry, and then continuing on page 40, line 8. Do you remember Mr. Noakes asking Ms. Leek what was on her shirt?
I do.
What did it say on his shirt, on her shirt? Do you remember, as it shows here at line 24, the court interposing, that's not relevant?
Yes.
Did you make an objection?
No.
Did you agree?
Not that I'm aware of, no.
Thank you. Did you agree with the court?
I didn't hear that last answer. I apologize.
Sorry.
No, I did not.
Now my next question, same as my last. Did you agree with the court that it was not relevant?
Yes.
Do you remember what was written on her shirt?
I don't.
Did you get the impression that Judge Morrow was protecting the witness from unneeded embarrassment?
No.
Was there a time in the trial that Judge Morrow, on the record, cautioned the defendant, Mr. James Matthews?
Yes.
Put up the next screen, please. What do you remember about that?
I remember that the defendant was talking or making gestures and just kind of acting disruptive at points during the trial. And the judge commented and said that it needed to stop.
Did you or Ms. Bickerstaff raise the issue of the antics of Mr. Matthews at any time to the judge to alert him to things that were concerning you?
No, it was pretty clear. He was doing it in the open.
Do you agree that Judge Morrow was acting properly as a judge when he told Mr. Matthews and his counsel that Mr. Matthews' antics must stop?
Yes.
Objection, Your Honor. I don't, it's the same objection relevance. What does this have to do with the disciplinary proceeding?
All right, thank you. Objections overruled. Continue, please.
Did there come a time, not long after Judge Morrow cautioned the defendant, that Judge Morrow also commented to both counsel, or all counsel, if you will, about the progress of the case so far?
Yes.
We can put up page 43 of volume 2 of the transcript. This is exhibit E, and these are lines 6 through 16.
I remember it.
Thank you. I'm going to read it. Judge Morrow stated, quote, "And I know this stuff gets good to you, but you all, if you don't focus, you're going to make me try to have to get more involved. I don't care what the shirt says." I'm going to take a break here. It was Mr. Noakes who had asked the shirt question, right?
Yes.
Come on. I'm continuing, sorry. Come on. And asking people to repeat testimony, there's a period here. Do you know what he was talking about when he said asking people to repeat testimony?
Yes.
What was he talking about?
He had stopped myself and I believe Ms. Bickerstaff. I don't know if at this point if he had stopped Ms. Bickerstaff. He had stopped myself and I believe Mr. Noakes potentially because he believed that we were repeating the testimony.
In other words, having witnesses say the same thing twice or 3 times.
Yes.
Another way to say, no, I'm not going to do that. Continuing with the reading. Well, you can say that again. When they speak clearly without stammering or stuttering, if you're not going to listen, then you don't deserve to be in this courtroom. So if you all don't tighten it up, you know, I seriously would not like to be as involved as you all are, making me be involved. So focus and act more like lawyers. I've read that relatively accurately, correct?
Yes,
Am I correct that Judge Morrow was talking to you and Mr. Noakes at least? I
Yes.
don't believe that Ms. Bickerstaff had taken any testimony at this point.
yes, I believe it was directed at Mr. Noakes and I.
And you would agree with me that those words are considerably more direct and stronger than the interruptions and interposings that we had seen to that moment in this transcript that I've shown you, at least, correct?
Yes,
You agree with me, this statement was made when the jury was out of the room.
I can't be sure. I don't know.
We can,
I mean, if you said it happened, you don't need to pull it up. If you said it happened when the jury was out of the room, I believe you.
okay, thanks. I'm going to say it again. You would believe me if I said this happened while the jury was out of the room, correct? Thank you. Do you think that Judge Morrow's admonishments were fair at that point in the trial?
The ones that you've covered with me?
The one that was on the last page, we can put it up again if you want, about asking people to repeat testimony, at least as far as Mr. Noakes asking about the shirt, those things.
I don't believe that it was fair to say that we don't deserve to be there. I understand that if he was frustrated that he may want to raise those points, but I think it was unfair to say that we didn't deserve to be there.
You do remember what he said is if you're not going to listen,
Yes.
right? There's a conditional to that. So he wasn't saying that either you or Mr. Noakes didn't belong there, but that if you were not going to listen, then that wouldn't be the place for you. Did you understand that any different? Or
I understood.
okay, somebody should object to that question, but okay. Emery Matthews was the very next witness, correct?
I'm not certain, but it's
Okay.
possible, yes.
You will not doubt me if I say Emery Matthews was the next witness, correct?
Correct.
His relation to James Matthews is his brother?
Yes.
And let's pull up page 45, lines 4 through 9. Again, this is volume 2. It was not long after he began testifying that you got to the meat of what you anticipated his testimony to be. True?
Yes.
And if you'll read your part, I'll read the part of Mr. Emery Matthews.
Okay. Question. Now, Mr. Matthews, I want to take you back to what I believe is the summer of 2003. Correct me if I'm wrong. Did you have a conversation with your brother, James Matthews, regarding some admissions?
And the answer is no. Let's go to the next, which is lines 10 through 13 of the same page. So it's continuing on. Go ahead.
Question. Question. Okay. At any point, did you have any conversation with your brother, James Matthews, regarding some admissions that he had made, that had been made? I'm sorry.
Thank you. Answer, no. Is it your testimony here today that the first time you learned of these no answers to your questions was on the record taking the testimony of Emery Matthews?
I don't recall. I think so, yes. I can say the reason I'm saying that, I don't have any direct memory, to be honest with you. The reason I'm saying that is because I would have not included that his statements were going to be A, B, and C if I knew well before any of that his statements were not going to be that. I would not have represented that in my opening.
We talked about at the beginning, and you agreed, that a lawyer who's going to be trying a murder case has the responsibility, and I think you probably would agree with me, the duty, to know their facts of that case in order to present it to a jury as prosecutor, correct?
The best they can, yes. There's always going to be stuff that you don't.
Please say that again. I'm not sure the court reporter got it.
I said, yes, the best you can. I said that there's always facts and information and evidence and stuff that, can kind of come in differently or play out a little bit differently at trial than you anticipate. That's not uncommon.
Knowing in hindsight what happened, you testified quite a bit about hindsight on your direct examination. knowing in hindsight what happened, would you agree you did not have control of the facts and the circumstances of your case when you called Emery Matthews?
I would disagree. I don't know that it had to do with my control.
Do you recall your immediate physical reaction when Mr. Emery Matthews testified, as we've just seen on those 2 pages?
No.
Would you agree that any physical reaction you had, you would not be the best witness for that? It'd be somebody who was watching you, correct?
No, if I had a memory of it, I think that I'd be in an equal position to say.
Since you don't, thank you. Since you don't have a memory of it, you would agree with me on that date, at that time, the best evidence of what your physical reaction was would come from somebody else.
It would
Correct.
depend on their memory. I don't know. I can't say.
Thank you. What did you decide to do when you heard that testimony from Mr. Matthews?
To try and impeach him with his statements.
And is impeachment substantive evidence?
If it's sworn testimony, otherwise it's not substantive. And in this case, it was not sworn testimony by Mr. Emery Matthews, so it would not have been substantive.
In your closing argument, and so the record is clear, in a criminal case, the prosecutor argues first, correct?
Correct.
The defense argues second, correct?
Yes.
And the prosecutor, and only the prosecutor, is permitted to have rebuttal, correct?
Yes.
And that's because it is your burden. That's the reason why you get the rebuttal. When I say you, I'm referring to the prosecutor, correct?
Yes.
And the burden is beyond a reasonable doubt in a criminal matter, correct?
Yes.
This was a criminal matter, correct?
Yes.
And so your burden here was beyond a reasonable doubt, correct?
Correct.
Do you know, well, I'll leave that aside. So I'd like volume 3, page 38, lines 4 to 10. In the third volume, among the other things that happened that day was the closing argument. Do you remember that? It would be June 12th.
12th. Okay. Yes.
And this is a portion of your closing argument. Could you, and again, there's a cutoff at line 4, but beginning with, do you believe that, question mark, can you read those lines through line 10?
Yep. Do you believe that, or do you believe police officer Stopchinski that Mr. Matthews, Emery Matthews, contacted him, came in voluntarily and told him information, told him that Mr. Emery Matthews came in and said to him that his brother James Matthews told him that he could kill a bitch quick, and that the last one he killed stole $50 from him?
Do you remember, as you sit here today, giving that closing argument, that portion of the closing argument?
Yes.
Do you recognize that as being arguing substantive evidence from Officer Stopczynski?
No.
Let's go to page 58, line 16 to 21. You did a rebuttal, correct?
Yes.
Do you remember in the rebuttal? Well, can you read line 16 through 21? This is from page 58 of the rebuttal.
Yep. Now, where else do you hear about the $50? That's very important. Mr. Emery Matthews. Now, while Mr. Emery Matthews wasn't willing to come here and say what happened or what he told police back then, he told them back then that his brother admitted to him that he killed this girl over $50 she had stolen from him.
You understand that if it's impeachment, you can argue that Mr. Emery Matthews had lied when he testified, correct?
You mean just if it's impeachment, or if at any, are you saying any point, or?
Impeachment evidence would be evidence that somebody lied or said something different on a different date, correct?
Yes.
But it does not prove what was said on the prior date unless, as you say, it was under oath, correct?
The content of it, correct.
Okay. And so this is the content of it that you are presenting to the jury in your final rebuttal, correct?
I would say that I'm not sure how it fits with the rest of the contacts. It's possible. But I would say that I don't know what came just before, but if it's with regards to what police officer Stopchinski was saying, then my goal was to show that he had made two different statements and that not one of those statements was incorrect. And my argument was that the incorrect statement was what he made in court based on his brother being there.
Does that mean you were arguing that the first statement was correct?
I arguing the first statement made to police was correct?
Yes.
I think I was arguing that it was made. I'm not sure. I'm not certain.
You agree with me and you recognize, as we're talking here, that's an important point, correct?
With regards to the hearing that we're here for?
No.
I personally,
this trial. So it's important that you not argue substantively impeachment in a closing argument to a jury, correct?
it's important for me to not argue impeachment evidence in front of a jury. Is that what you said?
No, you missed a word and I'll repeat it. I apologize if I didn't say it right. It's important to not use impeachment evidence as substantive evidence of guilt when arguing a case at the close of a prosecution.
It's important to use the evidence properly.
And you would agree that the proper use of impeachment is not to claim that it's substantive evidence.
It depends on the type of impeachment.
The type of impeachment that you had for Mr. Emery Matthews is the type of impeachment that you could not properly use as substantive evidence in your closing argument, correct?
Correct.
Let's page 58, lines 23 into 59, line 4. Can you read that? This is a continuation of your closing, your rebuttal.
Yes. Not from police officer Stopchinski, who didn't know anything about this investigation. The only person that could have given Mr. Matthews, Emery Matthews, that information about the $50 is James Matthews himself, his own brother, out of his own mouth. That's where he gets that. People that are involved or people that have firsthand knowledge from admissions of James Matthews.
You would agree with me, Ms. Chaffone, that's substantive evidence. You're arguing that the jury should believe what Officer Stopchinski said Emery Matthews said.
Not the content of what he's saying, not that the guy actually in fact had $50. The fact that Officer Stopchinski even had that information, whether it was true or not true, was significant because that information can only have been provided by someone with intimate knowledge of what had occurred. So not the fact that in fact $50 was passed over, but the fact that that was a statement and a statement he had from this individual, I thought in itself was significant, not the truth of the statement itself.
You're attributing the statement to James Matthews that James Matthews never said in court, and there was no evidence of him having said that was substantive, correct? You're saying out of his own mouth.
No, I'm saying that for that, I don't know if I'm following actually.
Well, that's a different answer. I'm going to ask the court reporter if she can reread that question and see if that's helpful.
One moment.
Going back to volume 2, page 58. Lines 5 through 10.
You are attributing the statement to James Matthews, but James Matthews never said in court, and there was no evidence of him having said that was substantive, correct? You're saying out of his own mouth.
I still don't understand the question. Are you asking me if James Matthews ever said during the trial that about the $50? Are you asking if, I don't know. I don't understand the question.
Let's put up the last screen. I apologize. Was this one, voluntary told him, came in, said his own brother told him. Nope, it's the one after this. There it is. No, I think it's the one we had. It's page 58, line 16 to 21. This is it. So this is your statement. You spoke these words to the jury, correct?
Yes.
You say out of his own mouth. Whose mouth are you referring to there? Do I have the right?
No, I don't have anything that
I'm
says.
sorry. Let me get you the right screen. There it is. Do you see it, line 2? James Matthews, starting at line 1. James Matthews himself, his own brother, out of his own mouth.
Yes,
Whose mouth are you referring to?
I have James Matthews' own now.
Thank you. Have you ever heard the adage from a prosecutor that it's their job to win the case and it's the appeal's job to save it?
No,
Were you intentionally creating a record in closing argument that you thought would get you a conviction without regard to whether it would survive appeal?
no,
Now, if we could go to volume 2, page 58, lines 5 through 10. This is exhibit 5. It's your testimony here today that Mr. Emery Matthews's testimony was unanticipated and not what you thought it would be before he testified. Is that a fair statement?
based on the statements the written statements we had, it was not consistent with his written statements.
And the written statements, if I have this right, were written by the police officers, but signed by him, correct?
Yes,
So you didn't have his handwriting. You had a piece of paper that he signed that had information on it that somebody else had put there, presumably before he signed it, but
yes,
okay. Immediately after Mr. Emery Matthews left the witness stand, there was a logistics issue in terms of witnesses and proceeding in the trial, correct?
yes, I believe so.
And so it's fair to say that this is I'm trying to find the words from the opening statement. Give me a moment. In a case that is stressful and high stakes.
Are you saying those are my words?
No, these were in opening statement before you came on the Zoom. But you agreed with me that the murder cases are stressful and that murder cases are high stakes. If you remember, we talked about that. And
You asked
said
if it's
it's for everybody, right?
Stakes, but it is high stake. I would agree.
You would agree at this point in the proceedings, in these particular proceedings, it was the low point in the presentation because of the way Emery Matthews had changed from what you thought he was going to testify to what he did testify to.
No,
What was the low point of the case?
the hung jury.
Well, to that point in the case, it was the low point. Is that fair?
I don't know if I would say that, because I would say that sometimes when witnesses come in like that and recant, that sometimes that ends up being more powerful testimony when you put on an officer with their statement, especially given the fact that it was his brother. So I would say that it was, I don't know that I would qualify that as the low point.
How many other, let me ask you this. Am I right that in no other case in your 10-year career and however many years as a full-time prosecutor, you've never had a situation where you got up and said to a jury, man's going to come in here and tell you about 2 killings, multiple admissions from his own brother. Oh, and he didn't do that. You'd agree with me that's happened one time in your career.
If I've given an opening statement and if a witness has testified inconsistently with that.
No, told you there were 2 murders. You told the jury, this witness is going to come in and talk about 2 murders his brother did and told him about not once, but more than once. That's what you said in your opening statement.
I've never had a case with this.
Once. You've never had that occur again, right?
Excuse me?
That never happened again since June of 2019, correct?
I've never had a case with these factual circumstances to even bring that up in an opening statement.
So do we have page 58, lines 5 through 10? Were you stressed at the end of Emery Matthews's testimony?
Objection relevant.
I'll withdraw and ask another. May I proceed?
Judge, I think you're muted.
Yes, you may proceed.
What was the logistical problem that you just testified to that occurred right after Emery Matthews had testified?
We had a lack of witnesses available.
Were you aware before you came to try this case of Judge Morrow's protocols and procedures, approach, whatever word you want to use, towards having the next witness ready?
Yes, but he had also made it clear on his position on leaving witnesses waiting in the waiting room due to concerns he had about unnecessary payouts on overtime. So I was trying to be conscious of that as well.
Understood. But you knew that you had to balance those 2 issues, those 2 items, correct?
Yes.
So with regard to the timing element, by the way, in this case, how many defense witnesses were there?
I think just Mr. Matthews, I believe.
And he was there, ready to testify when it came time for him to testify, correct?
He being Mr. Matthews?
Yes.
Yes.
It's fair in this case, there never could have been a logistics problem for the defense witnesses, right?
I can't speak on that. I don't know.
Well, there's only one witness and he's right there. You would agree with me, there's no logistical problem with that really can arise.
In that circumstance, yes, Mr. Noakes had indicated in the record, I believe, that he had another or more witnesses potentially. So that witness being present already, there was not a logistical issue with it.
Thank you. Have you ever seen with your own eyes a circumstance where Judge Morrow was faced with defense witnesses that were not ready?
No.
So I'm sorry, if we could put back up page 58, lines 5 through 10. This is you, Ms. Chiffone, so I'd ask you if you could read that.
Yep. At this time, we're supposed to have an evidence technician present in the witness room, and she is not here. We have a little bit of a slowdown with our witnesses right now. Would the court just allow maybe 5 minutes for us to maybe make some phone calls?
There's then a back and forth on pages 58 and 59. I believe it's with the jury present. Do you remember that?
They were present, yes, because he being the judge, Judge Morrow posed questions to them about whether or not I should be allowed to have some more time.
You know that jurors these days, well, let me ask you, you started 10 years ago trying cases, correct?
Correct.
You know that the rules have changed about how involved jurors can be with a number of things, correct?
Yes.
Compared to 10 years ago. You know, even still, that Judge Morrow's jurors are told that they have considerably greater autonomy than most jurors? I think that's a safe way to ask that question.
Yes.
Okay. You were there when he told the jury, hey, if you need to get up and go to the bathroom, go ahead, get up and go to the bathroom.
Yes.
The judge doesn't have to tell you where he's going, so you don't have to tell us where you're going. And we'll wait for you if that's what it takes, correct?
Correct.
That's just an example, and there's probably a lot of them in terms of what they could do. By the way, you remember in voir dire, there was a discussion about menstruation?
I don't know if it was a discussion. I think it was a comment by a juror or something.
Correct. There was a comment by a juror, and the judge then followed it with a discussion about that, right?
He may have, yes.
Okay.
I don't remember.
Safe to say, the voir dire was different from any voir dire circumstance you had ever had. It had no similarity to anything else that you had done as a prosecutor.
Certainly.
Doesn't make it wrong, but it was different, correct?
Certainly different. Yes.
So, I'm sorry, can you read, in fact, kept you without food and water. I'm going to read it for you, and you tell me if I get it wrong. Ms. Chaffone at line 5, at this time, we're supposed to have an evidence type. Oh, I think you already read this.
I read that. Yep.
That must be my snickerless approach now. Sorry. Let's go forward. Kirk DeLue. Am I
Yes.
saying that name correctly?
You are.
He is with the Michigan State Police forensic biologist,
Yes.
and he was, it turns out, the next witness, correct?
Yes.
I think there was some confusion about calling somebody, and then they decided it worked out best that Kirk DeLue was available, and he came in and he testified, correct?
Yes.
Can we get volume 2, page 72, lines 9 and 11? And you've said this already in your direct testimony, and I'm not sure you hear yourself when you say it, but you referred in the trial to a rape kit twice, correct?
That's correct.
There was no rape allegation in the charges, correct?
I want to say, just to clarify, I want to say that Kirk DeLue supplied that language. That's what he said that they were called. And then I believe I followed up with that language.
I just want to be careful that I understand you here. Are you saying pre-testimony, pre-trial, he gave you something that told you this is what it should be referred to? Or are you saying he testified to it being a rape kit first?
He testified to it, I believe. I believe that was his testimony, like his wording. In his testimony, I think he said the word rape kit.
Well, if that's true, why are you asking the question at line 9 on the page that I put before you? It's just, again, volume 2 of the trial, exhibit 5, it's page 72. Now, are you familiar with the rape kit project? I guess I'm asking, does that refresh your recollection that you were actually the first one to mention it?
It doesn't refresh my memory that I was the first one. I do see that I mentioned it there. I do believe that he brought it up earlier in his testimony. I could be wrong, but that was my recollection, is that he brought it up earlier in his testimony.
Well, let's go with the idea that he did say it earlier for purposes of our next set of questions.
Okay.
You agree with me if a juror says something, if a witness says something that is not proper, the prosecution or the defense attorney should not double down or continue to do so. They should find a different path and do it the correct way. You would agree with that, right?
Yes.
Was the use of rape kit project twice in the sentence on page 72, lines 9 and 10, was that intentional on your part to ring a bell with the jury about rape?
No. Even Kirk DeLue, I believe, goes on to qualify. I think we asked some questions some further down, and he said that it doesn't always have to do with a sexual assault situation. I think he qualifies it later. or even before, I'm not certain.
But once a bell is rung, it can't be unrung. I'm going to withdraw that question. I apologize. You had a discussion with Kirk DeLu about the rape kit project after he acknowledged that he knew what it was, and you described a 15-year backlog, correct?
He does or I do.
I believe it came from you. You asked him if he was aware of the 15-year backlog.
Correct. He explained what I think that meant and what that was.
In the end, when you're in chambers with Judge Morrow, he's critical of your admission of any of the DNA evidence when you have your discussion with him, correct?
Correct.
Was he critical, among other things, that you were using the 15-year backlog to hide the fact that between the police and the prosecutors, they had simply dropped this case and it got lost between 2003 and 2018?
That was nothing he ever said, no.
You recall the meeting in the judge's chambers, judge's chambers, to be about 2 hours long, maybe a little more, maybe a little less. Is that fair?
Yeah. Yes.
Do you recall the door was open?
I don't remember.
Do you recall that Judge Morrow always has his door open?
I'm not sure.
Would Joe Curley know well the judge's habits in that regard?
Objection, speculation.
Only if she knows.
I wouldn't know.
How would,
Okay. I'll withdraw the question then. Sorensen Labs, do you know what that is?
I do.
They had a role to play in this case, correct?
Yes.
And that's the lab. There's a lab in Texas to which the samples were sent.
I'm not sure if it was a lab in Texas. No, I think it was. I'm not sure where Sorensen was located, but my understanding is that I don't know that it was in Texas.
Do you remember Mr. DeLu confirming that it was the Texas lab that was involved in this case?
objection, relevance.
Response, Mr. Campbell.
Yes, it's a lead-in to 2 points. Number one, when the judge is critical of the DNA evidence, one of the reasons he's critical, I'm getting to offer a proof I can say it, is because of the fact that the Sorensen lab had received a letter basically saying that they had done poor work, and I forget all the specifics of it, and that there was untrustworthy results. That came before the jury. And Mr. DeLu did testify that it came from the same lab that had gotten the letter that was shared in Michigan about the results out of that lab. And so I'm going to follow it up with what did she know about that before she actually presented this testimony? And it goes to the question of whether, again, their conversation in the back about her performance, his comments to Ms. Bickerstaff were proper or appropriate regarding the mentorship, things like that.
Ms. Weingarten, any continued objection?
Yes, we've had no testimony from Ms. Chaffone that judge mentioned anything about the lab being uncertified or not reliable. That wasn't the topic of their conversation in chambers. So I don't think it's relevant.
Anything further, Mr. Campbell, before I rule?
Yes, my recollection on direct is she mentioned that he was critical of the DNA evidence. I know that's in her reports and affidavits, but I can bring it in that way if I have to. But my recollection, she did say that.
Well, it was why she introduced DNA evidence that he took issue with, not the fact that the DNA evidence was defective in any way.
Well, again, the reason he's critical of her using it is multifaceted, but one of the reasons is because the DNA evidence had its problems that a jury could get easily confused from. That was something he brought up.
I'm going to sustain the objection. If you'd like to make your record, we will do that at this point.
I'm not going to need that right now. I'm going to ask another question. Might get the same objection. We might end up there anyway. did you know that there was a quality control issue that came up in the case? With the-
Objection. Sorry, I didn't mean to cut you off, Mr. Campbell.
Mr. Campbell,
Yeah, I'm going to need my separate record, I think. I'm sorry.
all right, thank you. The objection is sustained. Ms. Jorgensen, if you would get us to the point of repeating the question and then let us know when we're on the separate transcript.
Yes, Your Honor. The last question I have is, did you know that there was a quality control issue that had come up in the case with, and then there's the cutoff? And now we're in a separate record.
Thank you.
I can restate my question if you'd like, Your Honor.
Certainly.
Thank you. Sorensen Lab in Texas had a quality control issue, and that was something that was addressed in the trial, correct?
I don't know that it was in Texas. The issue with it that Mr. Noakes made me aware of was that it was a case it was a testing done on a Texas case. I don't know that Sorensen was in Texas, but it wasn't a quality control issue with Sorensen as a whole, was my understanding. It was with this one particular instance in this one particular case out of a different state. And that did come up during trial raised by Mr. Noakes.
Mr. Noakes showed Mr. DeLue a letter.
Correct.
From Sorensen Labs issued to the state of Michigan. Do you remember that?
Correct.
When did you become aware of that letter?
Just before Mr. Noakes introduced it.
Did you ask Mr. DeLue any questions about that letter when you had a chance at redirect?
Yes.
I'm ready to go back on the regular record, please.
Thank you.
I'm ready, Your Honor.
Thank you. Continue, Mr. Campbell.
I believe this is Exhibit 5, Volume 2, page 87, lines 11 to 23. I'll wait for that to load. I'll take that. On page 87?
No.
I got it. Page 87, 11 to 23. You don't have it?
551.
No problem. I have other questions I'll ask while that's being set up. Did you do a redirect of Mr. DeLue?
Yes.
What are the rules of redirect examination? Well, let me ask you, do you know the rules of redirect examination?
It depends.
I'm sorry, we're in the separate record. I forgot.
Yes.
I believe we're in the main record.
They go back
You're right.
in the main record.
Oh, if we're in the main record, then I object.
What's the objection?
Relevance. Whether she knows the rules of redirect or not is not relevant to whether Judge Morrow committed the acts charged in the complaint.
So
Mr. Campbell, response.
yes, what it is relevant to is the judge gives a warning. Ms. Chiffone doesn't follow the rules of redirect. And so he has to stop her, or he does stop her, and they have an interaction that I want to ask about.
The objection is sustained. We'll go to the separate record. Ms. Jorgensen, please.
One moment.
Go ahead, throw it up there, please.
What are the rules of redirect examination? Well, let me ask you, do you know the rules of redirect examination? And now we're in the separate record. Actually, give me 1 second. We're in the separate record.
Thank you. continue.
Ms. Chaffone, you heard the question?
Yes. So I would say it depends on the judge's courtroom you're in with how much latitude they give you on redirect. Some judges don't even allow it at all. But typically the rule is you want to stay within the scope of whatever was asked, unless you have a reason to go beyond that has been discussed maybe further before that.
Thank you. You see the transcript that's now on the screen. It's page 87 of volume 2 of exhibit 5, lines 11 to 23. You can read the questions and those parts that are attributed to you, and I'll read the court and Mr. Noakes. Go ahead.
Okay, now I want to ask you to take a look at the Sorensen report. Were there any samples untested by Sorensen?
Court, I'm sorry.
Any untested samples?
Court, that goes beyond the scope. And then there's Mr. Noakes interposing objection, relevance. Then Judge Morrow goes beyond the scope of cross-examination. Go ahead. There's one more line, Ms. Chaffone.
Oh, I have no other questions.
You recognize the question that you were going to ask about the other samples was beyond the scope of cross-examination, correct?
It wasn't in my opinion, but I understand that the judge definitely thought so.
Did you take offense to his ruling?
No,
Did you take offense to the manner in which he made his ruling?
no,
Would you agree he was professional and judicial in the way that he ruled?
yes,
Officer Deborah Stinson testified, correct?
yes,
That was Ms. Bickerstaff's witness,
correct,
correct? She
yes,
actually had 2 other witnesses that she talked to before Officer Stinson, but Officer Stinson is the 3rd witness that she did the testimony for, correct?
I'm not sure. I don't remember.
You said that you've read the transcript. Have you read the parts that Ms. Bickerstaff took the examination
Yes,
of the witnesses? Okay.
yes,
You would agree that Ms. Bickerstaff began asking most of her questions with an and?
throughout the transcript, I would say at points, yes.
Can we put up page 89, lines 13 to 25? This is the first page. I've highlighted the ands. There were 4 questions asked. And other than the, would you state your name for the record, all the other 3 begin with an and, correct?
Yes,
You remember my example that I pulled from the voir dire where Judge Morrow talked about how you could say you're having a good day or you could have evidence of a good day. You remember that?
yes,
So let's look at the evidence further about Ms. Bickerstaff and her use of and.
Objection, relevance.
I believe we're in the alternate record at this point, transcript at this point.
I don't think so. No,
Okay, I apologize.
I believe we're on the main record, but I could be wrong. We should ask the court report.
Let me find out from Ms. Jorgensen.
Let me check. I have to scroll back. I believe it's the separate record, but let me verify.
Yes.
Shame on me.
We are in the separate record.
Thank you for that clarification. I would ask to go into the main record.
All right.
Okay, we're in the main record.
I'm going to repeat some questions here that are on the separate record. Ms. Chaffone, I apologize for having to do that, but I'll be quick. Officer Deborah Stinson testified, correct?
yes,
Ms. Bickerstaff took her testimony during the trial, correct?
correct,
She was the 3rd witness that Ms. Bickerstaff took testimony from during the trial. Is that correct?
I don't know.
There was a 4th witness, Dr. Galita, who would testify after Officer Stinson, correct?
I don't recall, but if that's the way that the transcript reads, then yes.
Ms. Bickerstaff began asking most of her questions with the word "and." Is that correct?
I wasn't actually present for all of her questions, but from the review of the transcript, yes.
You recall Judge Morrow's example to the jury that I covered with you earlier about what is a good day. You could ask somebody,
Yes.
they could say good day, or you could get evidence of what is a good day.
Yes.
So
Objection asked and answered.
that's in the separate record, Ms.
Oh.
Weingart.
Correct. Continue.
I remember. Yes.
I counted that there were 49 questions posed by Ms. Bickerstaff of Officer Stinson, and that 36 began with either an "and" or an "okay and." That do you quarrel with that?
I have no idea on the number, but
Thank you.
there were several times where I saw it.
Did you know that the decedent's sister, Ms. Robinson, testified?
Did I what? Sorry, you had cut out a little bit.
Did you know that the decedent's sister, also known as Ms. Robinson, testified?
Certainly, yes.
I believe her name is Camille Robinson. Does that sound right?
It may have been.
And so,
I don't know that it was.
thank you.
I think it
I'll
was
have to double
Taylor
check that.
Robinson.
There's a little over speaking.
Oh, sorry, Ms. Irvin.
There are two Ms. Robinsons involved in the trial. One is the deceased, the other is her sister who testified, correct?
Correct.
And so I'm going to talk to you about that because it is Ms. Bickerstaff who took Ms. Robinson's testimony, correct?
Yes, and just so you're aware, I wasn't present for any of that.
Thank
In
you.
the
But you have you read the transcript where she asked
I did.
9 of 14 questions, if you exclude the first one, about what's your name, that started with an "and"?
I don't know the count, but I do know there were several. Reading the transcript, I know.
And then a Dion Denard testified, correct?
Correct.
And Dion Denard no longer works for the Detroit Police Officers Association, Detroit Police Force, but did at the time of the murder, correct?
I don't remember that specifically, but it's possible, yes.
Were you there for Dion Denard's testimony?
I don't believe that I was actually. I mean, I wasn't out of the building, but I was trying to secure witnesses that would go next.
In your review of the transcript, did you see that 9 of her 11 questions began with the word "and"?
I don't know the number.
Objection relevance to how many times Ms. Bickerstaff used those words.
We
I'm-
have, through this witness, heard that Anna Bickerstaff is going to say that the judge talked to her about using and that was the first piece of advice that she got. And again, you can hear her say, boy, I said "and" a lot, or I can prove she said "and" a lot.
Judge, it's in the transcript. The transcript's going to be admitted. Whoever reads the transcript can count how many times if they care to.
The objection is sustained. Would you like to make a separate record or a separate transcript, alternate transcript, Mr. Campbell? At this point,
I would proceed.
all right, thank you. Continue.
You would agree with me that if you ask 74 questions and 72% of those begin with "and," that's too many when you're taking testimony from a witness or witnesses.
No, I'm not following you necessarily on the percentage, but yes, if you use it too much, it's not good.
Do you know whether Ms. Bickerstaff scripted her questions?
Objection relevance.
Has to go with the mentorship. In addition to the other arguments that I've made, it has to go to the mentorship aspect of it, Your Honor.
The
Well, what-
mentorship is not on trial here.
You have made that, or if I may, the disciplinary council they're the ones who elicited the testimony.
Mr. Campbell, I'm going to overrule the objection. Continue.
I will need the court reporter to please read that back.
Of course, one moment. Do you know whether Ms. Bickerstaff scripted her questions?
I'm not certain if she did for all of the witnesses, but I do know that she scripted some of them. Yes.
There were two witnesses who testified between Officer Stinson, who Ms. Bickerstaff took the testimony of, and Dr. Galita, who she also took the testimony of, correct?
I'm not sure if there were two, but I believe you if you say that there were.
Thank you. Officer Stinson's testimony ended at 11:53. Take my word for that. There was a break from noon to 1 for lunch, and then a Kath Carr testified. Do you remember that?
Kathy Carr, yes.
And then there's a Jennifer Dillon who testified. Do you remember that?
I do.
And you did both of those witnesses, correct?
I did.
Can we go to volume 2, page 128, lines 7 to 15? I'm going to read this and then I'm going to have a question for you, okay?
Okay.
There's a statement, which I believe is yours. Okay, in fact, and then there's an ellipse. The next line 8, it says the court. You're about to testify. Line 10, your name, and then it says, I'll strike it in advance. You already testified to your findings. I have no other questions. Line 13, the court says, time to eat that candy. Thank you. And then the witness is excused on the next line at 1:38 p.m. You see that? I read that correctly?
I do.
This is another instance where the court is correcting you or giving you direction relative to your questions to a witness, correct?
Yes.
Do you recall this? Not just see it on the page, but do you actually have a present sense impression of that moment in this trial?
No. Like, are you asking if independent of reading this, do I remember that specific encounter where do I remember this like off from memory?
Correct.
This particular thing? No, I don't.
Can you tell the master what folks did when it was time to eat that candy?
I don't, excuse me?
Line 13. Judge Morrow says, time to eat that candy. You know what he was referring to, right?
Like the candy he gives out?
Does he give out candy?
Sometimes, yes.
Yeah. Who does he give out the candy to?
Witnesses, attorneys,
Jurors?
I don't know, jurors.
Isn't there a bowl of candy that they can help themselves to even?
There may be. A lot of judges do that. I'm not sure.
Do you know who started that?
I don't.
Thank you. Then we get to Dr. Galita. Were you in the court or out of the court at the time that Dr. Galita testified?
I came back into the courtroom at the tail end of his testimony.
I want to shift a little bit of the focus here. You had been asking for advice during the trial, correct?
Just one.
No?
Just one time.
Just the one time. Do you recall Anna Bickerstaff reporting that you had twice asked for advice?
Excuse me?
Do you recall Anna Bickerstaff saying that you had twice asked for advice?
Objection, hearsay.
Any response, Mr. Campbell?
I'll withdraw the question.
Thank you.
You had, you would agree, received some direction during the trial without even prompting Judge Morrow for it, correct?
Direction and rulings, yes.
With regard to the first discussion that is charged in the formal complaint, the first conversation that occurs between Judge Morrow and Ms. Bickerstaff, how much of that were you present for before you left the courtroom?
Just the part about, oh, before I left the courtroom? None.
Yes. So you did not see Ms. Bickerstaff say anything to Judge Morrow?
No.
You did not see, let me ask about did you see Judge Morrow give her advice relative to the use of the word and?
No,
Do you know when that advice was given?
I don't. I don't have personal knowledge. I know from what
It
Anna,
was given before Dr. Galita testified, right?
I have no idea. I don't know. And it didn't reflect, I didn't see anything. I don't know.
Am I correct that you cannot testify whether Ms. Bickerstaff blushed when she was told about her use and excessive use of the word and?
I wasn't present for that.
Do you know how many times Ms. Bickerstaff used the word and during her examination of Dr. Galita?
Objection, relevance.
Response.
I'd like to do this one off the immediate record and provide a offer of proof.
Just before we do that, Ms. Chiffon just testified she wasn't in the courtroom. So if she knows the answer, it's hearsay, but it's still not relevant. And it's in the transcript, which is going to be an exhibit that's admitted.
If you said that she's read, this we could do out in the open, but if she said she's read the transcript, she may recall exactly how many times. If not, I'm ready to prompt her with some numbers and see if she agrees.
The objection to relevance is sustained, and we can go for that alternate transcript if you're ready for that, Mr. Campbell.
I think I needed an offer of proof before you ruled on the full relevance.
I thought you said that you were just arguing it in the open courtroom or in the open session. So I thought you changed your mind. Now you want to go in for an offer of proof?
If I may, to give a full
Certainly.
response. Here's what
Certainly.
I think just happened. There was an objection, and I asked to make that on a separate record. There was a secondary objection that I did not mind responding to on the open record, but I still, on the first objection, would like to make my record on that relevancy.
All right.
The second one wasn't really relevancy. It seemed to be a cumulative testimony.
I didn't hear the objection on cumulative testimony, but at this point, Mr. Campbell, you are saying that you want to go into the breakout room to have a discussion with respect to an offer of proof. Is that correct?
That is correct.
All right. Thank you.
Your Honor, may I take a short break while they're in the breakout room, please? This is the court reporter.
You certainly may.
Thank you.
All right. Let us say, as far as the time, if we come back before 3 o'clock, we'll just wait for you to get back. All right.
Thank you, Your Honor.
Let's go into the breakout room now.
Everybody else is back. There she is. There she is.
All right, I think
I'll be ready.
everyone is back, certainly.
Yes, and I'm ready, Your Honor. Thank you.
Thank you, Ms. Jorgensen. To the objection, I have sustained the objection, and I believe at this time, Mr. Campbell, you would like to go to the alternate transcript. Is that correct?
That is correct, Your Honor. Thank you.
All right, thank you, Ms. Jorgensen. If you would repeat that last question when you have that, and then let us know when we're on that alternate transcript.
Yes, Your Honor. Do you know how many times Ms. Bickerstaff used the word "and" during her examination of Dr. Galita?
My answer is no.
One moment. Ms. Jorgensen, I think you went mute before you told us. Are we now on the alternate transcript?
I'm sorry, I'm switching screens and I have to get to that spot.
All
Just, I apologize.
Not a problem.
We're on the separate record.
All right, thank you. If you would answer the question again, please, Ms. Chiffon.
Thank you. My answer is no. I don't recall.
Ms. Chiffon, you would not, isn't it true that Anna Bickerstaff asked 57 questions and received and began 34 of those with the word "and"?
Objection relevance. Oh, is
We're in
this
the
record?
we're in
I'm sorry.
this alternate transcript, yes.
I just know she said it several times. If that's the number you gave, then I accept that representation.
Thank you. And that doesn't count 5 okays that began her other questions, but I appreciate that. Her examination began on page 155 of the transcript and went until page 166. And she elicited testimony on the cause and manner of death at page 162. You don't dispute that, right?
I don't.
Why was Dr. Galita called to testify?
He was the medical examiner.
So you didn't call any medical examiner though, right? That you called a particular medical examiner because he could testify to the cause and manner of death of this person who was the subject of the trial, correct?
Correct.
Do you remember what the cause of death was?
Manual strangulation. Or I'm sorry, the cause of death was homicide.
Thank you. And what was the manner?
Manual strangulation.
And that is the testimony. If you got nothing else from Dr. Galita, that's the testimony you wanted and needed from him to prove an element of this case, correct?
At minimum, yes.
Thank you. Did you know that, were you there for Mr. Noakes's cross-examination of Dr. Galita?
I wasn't, no.
Because you said you had come in at the end of Dr. Galita, but you left again?
I think there may have been some redirect. I'm not certain. I think she being Miss Bickerstaff may have asked some additional follow-up questions on redirect. And I think I came in at the tail end of that.
Thank you. Did you know that Mr. Noakes began 8 of his 16 questions with the word "and"?
No, I think everyone in the trial was using "and" and "okay," probably more than they should have.
I was just going to say, you'd agree with me, it can be contagious.
Yes. Yes.
Thank you. I have no further questions on the separate record. I am ready to proceed on the main record, if that's okay.
Right.
Give me one moment to mark it. Oops.
Certainly.
Your Honor, I have a question for you concerning timing that's been raised by my paralegal, and that is, how late will we go today?
It actually is going to depend on where we are in the questioning. We had talked about this initially in one of our pre-conference discussions, and I believe that we also were thinking of taking a lunch break earlier, but that's not where the break in the testimony is. So we probably are looking at 5 or 5:30.
Uh,
10 minutes.
Can we go on a separate record for a moment, please, Your Honor?
You want a separate transcript?
No.
What is it that you're requesting, Mr. Campbell?
I'm asking that we go into a room, me, you, my client, Ms. Jacobs, Mr. Helen, and Ms. Weingarten.
We will go back into the breakout room, yes.
Thank you.
One moment.
Your Honor, it does look like I am in the breakout room as well. This is the court reporter.
I'm going to change that.
All right. Just wanted to alert you, Your Honor.
Thank you. All right, I opened up a third room that I think I'm going to take us into this time. One moment. We're going into room 6. So, Mr. Campbell.
I am here. May I proceed?
No, not yet.
Thank you. I don't mind if Ms. Jorgensen's in, Judge. It's a point of personal privilege more than anything else.
Thank you. One moment.
I'm in too, just so that the court knows.
Oh, I don't even mind if Ms. Chiffon's in.
All right, just give me a moment. I've got several rooms open, but I need to make sure that you're in the right one. So I'll be with you in just a moment.
Judge, I have to say, it's far simpler than that.
Mr. Campbell, would you please hold on for a moment?
I will.
Thank you. Thank you. We are going to break for half an hour, and we will come back at about 3:45. So please, at 3:45, if you could make your way back. I'm not going to close this room, but if you don't leave your station, be sure to put yourself on mute, and you can stop your video also. All right.
Thank you, Judge.
Thank you.
Thank you.
Thank you.
Judge, are we also allowed to sign off and come back on? Or would you prefer us to leave it open?
You may sign off and come back into the waiting room because I will be expecting you there, so that's not a problem.
Okay, thank you.
Thank you. It looks as if everyone is back. I saw Mr. Campbell. There you are. Yes, thank you. Mr. Campbell, I think you are muted at this time.
I believe I have unmuted.
Yes. All right. Thank you. Council, are we ready to continue? Ms. Chiffon, you are muted. Mr. Campbell, are you ready to resume? I'm going to remind the witness that she is still under oath, but are you ready to resume?
Yes, I am.
All right, Ms. Weingarten, are you ready?
Yes.
All right, Ms. Chiffon, you are still under oath.
Thank you.
Ms. Jorgensen, are we ready to go?
I am ready to go, Your Honor. Thank you.
All right, thank you very much. Everyone, I hope, was able to get some refreshment and take a break for about 30 minutes. And I think we're ready to continue.
Thank you, Your Honor. If I may proceed?
Yes, you may.
Thank you, Ms. Chiffon. It's fair to say that everything you are aware of that occurred between Anna Bickerstaff and Judge Bruce Morrow after the testimony of Dr. Galita, you learned from Anna Bickerstaff.
No. You said all the statements made by Judge Morrow after the medical examiner I found out about from Anna?
That's what I'm saying. That's what I'm asking. So you're saying that you heard a little bit of the conversation when you sat down, right?
Yes.
Did you learn from any other source about any of the content, without giving us the content, of the conversation between Anna Bickerstaff and Judge Morrow, other than what you heard yourself?
Yes, from Anna.
Okay. So, for example, you wrote previously in a memo that you made for the Wayne County Prosecutor's Office that Ms. Bickerstaff told you, quote, she said the judge told her that she did better and that he wanted to give her a piece of advice that might make her blush. You remember that?
Yes, I remember her telling me that. Yes.
And have you, in your memo, did you record it in the manner that you heard it from Ms. Bickerstaff?
Yes, as best as I could remember.
And you repeated it again in your affidavit when you did your affidavit, correct?
Correct. That same sentiment.
Your affidavit is dated, I think, June 27, 2019. Were you aware of that?
Can I take a look at it just to be sure?
Sure. Yeah.
I'm referring to Exhibit 9. Yes, June 27th, 2019.
Do you know when Ms. Bickerstaff's affidavit was signed?
I don't.
If I was to tell you it was November of 2019, would you know why there's such a gap between when your affidavit was done and when hers was?
I don't.
Do you know what your affidavit was used for?
In general?
At all?
Just, I assume to send up the chain to my bosses and then for whatever investigation was conducted afterwards.
Why would your bosses need an affidavit from you?
I don't know.
Did you ever ask anybody why you were making an affidavit?
It may have been with regards to like a more formal type of a complaint, but I'm not certain. I don't remember.
And you don't remember asking anybody why you were making an affidavit?
No, I mean, I assumed so that there was some sworn document to summarize the events that had occurred.
You recall in your memo describing the conversation in chambers with Judge Morrow at the end of the case and using the statement making the statement that the judge raised his voice a little bit?
Yes.
Do you recall in your affidavit saying that the judge raised his voice a bit?
Yes.
Did you use your memo as, because I think I heard you say on direct that you wrote your affidavit, correct?
Yes.
And you wrote your memo, correct?
Correct.
Did you use your memo as the template for your affidavit?
I may have, to some degree, yes.
I mean, it only makes sense, right, that you cut and paste what you had written in the memo, and then you made adjustments to the affidavit, right?
I may have added some things to the affidavit that weren't included in the memo.
Okay. This would be an example of something you eliminated or took out of the, you took out from the memo when you made the affidavit, the word little. It went from little bit to a bit,
Yes.
right? I want to go through, I think, the rest of the trial, and then we'll return to matters in the chambers. Give me a moment. Am I correct that you never moved to admit the 404B evidence in your case in chief?
I believe we renewed our motion at the end of the trial.
Now, Mr. Fone, you know the words I just used, and you know the words you just used. Are you saying that you raised the 404B motion in the case in chief that you had?
Not in the case in chief. I believe that it may have come up at I don't know at what point it was raised, but no, we didn't renew it during our case in chief.
Okay. So, you know that the 404B motion would have to be raised in your case in chief, right?
Not, I don't know. I'm not sure.
You don't know because you aren't educated on that? You don't know because you can't remember?
I don't know because I don't know, based on the Court of Appeals ruling, whether or not we needed to wait until the close of all of the proofs to renew our motion, or if it required us to wait until the close of our proofs. So I'm not entirely certain.
Thank you. We talked about substantive evidence. We talked about impeachment evidence earlier, correct?
Yes.
What goes in at rebuttal? Impeachment or substantive evidence?
I don't understand your question.
There was your case in chief. You closed your case in chief, correct?
Yes.
You closed it without moving for the 404B, correct?
I believe so, correct?
The defense then put on their case, correct?
Correct.
You then had an opportunity to call rebuttal witnesses, correct?
Correct.
You called a rebuttal witness, correct?
Yes.
You did not call any rebuttal witness related to the 404B, correct?
I had to get a ruling to allow that in first, but correct.
What could somebody have testified to that would have been rebuttal of what the defendant testified to in his case?
Objection relevance.
If I may?
Response, Mr. Campbell.
Thank you. The suggestion has been made that the upset and the concern of the assistant prosecutors, in particular this witness, has centered on the fact that they had to explain what happened with the judge, and that's moved them to all sorts of circumstances. It is my theory that it was the failure to raise the 404B that was really the big issue for these prosecutors and for Ms. Chaffone in particular. They'd gone to the Court of Appeals. They had failed to get it admitted. They were told by the Court of Appeals to move after their evidence was in. They didn't do it. They did finally at rebuttal, and I wanted to show that that was a desperation act at that time, and that they knew that it shouldn't come in, and they knew that it was fruitless, but they didn't want to tell their superiors that they had not moved for the 404B evidence. And so going back to the office, the story they tell is about anything other
All right,
than.
Counselor, I'm going to stop you right there, and I will overrule the objection. Continue, please.
Thank you. Do you recall the question, Ms. Chaffone? If not, we can.
No, I don't.
Ms. Chaffone, Ms. Jorgensen, could you please read my last question to the witness?
Yes, I can. Just one moment, please. What could somebody have testified to that would have been rebuttal of what the defendant testified to in his case?
I don't understand your question.
Rebuttal testimony has to rebut something, right?
Yes,
So the only witness called by the defense was the defendant, correct?
correct.
So in order to present rebuttal testimony on 404B, you would have to present testimony that rebuts something the defendant said, correct?
Correct. Or correct. Evidence that came out, not necessarily during, correct.
And the defendant was never asked about any homicide other than the homicide that was the subject of the trial when he testified, correct?
I'm not aware. I can't recall, but I don't believe so.
In other words, you believe that he was not asked about any homicide other than the homicide that was the subject of the case, correct?
I believe so.
So if he did not say anything about other murders, there is no rebuttal that could be brought in on the issue of other murders in your case in June of 2019, correct?
Correct.
You did move for admission of the 404B evidence on the last day of the trial, correct?
Correct.
Or, yeah, and that the judge allowed you to raise that issue, correct?
I don't know if he allowed me. I raised the issue and he ruled on it.
And he denied it, correct?
Correct.
He asked you, do you remember if he asked you about whether you were asking for reconsideration of his prior order?
I do.
And you remember saying initially yes?
Yes, and then I changed I changed that, but yes, initially, yes.
And why did you change that?
Because we were going off of the Court of Appeals order. I must have misspoken inadvertently.
You know that the judge who currently has the case is Judge Michael Hathaway, correct? This is the James Matthews prosecution that you handled in June that ended in a hung jury has now been assigned to Judge Michael Hathaway in the Wayne County Circuit Court Criminal Division, correct?
Correct.
You know that Michael Hathaway is a visiting judge in Wayne County, correct?
A retired judge that's back. I'm not exactly sure if they call him visiting in that situation, if they're from the same county, but something like that.
You know that in Wayne County in the Criminal Division, judges have alternates for their cases for the most part, correct?
Yes, I don't know about for cases, but I know if it's like a search warrant day and that judge is busy, then you would go to the alternate to present them with a search warrant. I'm not sure about like if alternates handle your cases though. I don't know.
Do you know who the alternate is for Judge Morrow?
No.
Do you know who Judge Shannon Walker is?
Yes.
Okay. But you do not know that she's the alternate for Judge Morrow?
No.
Did you know that the alternate judges are the usual place where disqualifications or recusals are sent?
No,
Not to the main, it's to the alternate. Are you aware of the blind draw system in Wayne County for the selection of judges in matters where there has been a disqualification or a recusal?
no, I don't know the process for that. No,
Did you know, so you did not know that the cases are supposed to be blindly assigned?
no. Well, do you mean like at the time that the case is bound over from an exam, or on a case where you you were talking about disqualification and then just, are you talking in general or in disqualification cases?
You know that there's a blind draw after an examination, correct?
Correct.
And there's
Unless-
also a blind
Unless
draw.
the defendant, if it's a capital case and the defendant's on probation to a particular judge, and then in which case there is no blind draw, it goes directly to the judge.
Thank you. There is also a blind draw where there is a disqualification or a recusal, correct?
I have no idea. I don't know.
Were you aware that Michael Hathaway, as a visiting judge, would not get a blind draw?
I don't know.
But he is your judge today, correct?
Correct.
You moved on behalf of the people for admission of 404B evidence in front of Judge Michael Hathaway after Judge Morrow was no longer on the case, correct?
Yes, correct.
Do you know why Judge Morrow was no longer on the case?
When it got moved,
Yes.
because at that point we had filed, or we had made our bosses aware of the incident that occurred, and the case was being moved.
Do you know how the case got moved?
It was my understanding administratively.
Was there a motion for disqualification filed?
Yes,
Have you ever seen that motion?
I have.
Is your affidavit attached to that motion?
Not that I'm aware of.
Are you aware under 2.003 of the Michigan Court Rules that an affidavit is required when you are seeking to disqualify a judge?
No,
You didn't know that?
no, I did not. I've never moved to disqualify a judge in any of my cases before.
So you did not move to disqualify Judge Morrow from the Matthews case?
I don't recall. It may have been by my supervisor, Athena Syringas, is my recollection.
You've never seen an affidavit from her, correct?
No.
We have the motion, the front page of the motion. If you could find that and let me know when you do. How long is the motion that you saw for disqualification?
I'm not sure. I can't remember.
When did you last see it?
I don't know.
I've seen a motion to permit a motion to be filed under seal. Have you seen that motion?
At some point, I'm sure, yes.
Did you see a subsequent motion filed under seal?
If it's not the motion that we've been talking about with regards to disqualification, then I don't know.
So you don't know what, I'm going to put up the front page of the document, which is my exhibit. Give me a moment. I'll try and figure out which exhibit it is. Yes, please. Which exhibit, what number is it, do you know?
Could it be I?
It's it's from the court record. I think it's B. Yes, it's my exhibit B. Is there a stipulation for the admission of?
Yes, yes, it's part of the court file, which is Exhibit B.
Thank you. You see there, people's motion to disqualify Judge Bruce Morrow.
Yep.
You see the names of the folks representing the prosecutor's office.
My three bosses, yes.
Your name does not appear, correct?
Correct.
Do you have the full motion? I have the front page there for you, but do you have the full motion?
No.
I want to go back into the trial. By the way, so Judge Hathaway granted, in part, your motion for the 404B evidence, correct?
Correct.
Was it the same or was it different evidence than you had presented to Judge Morrow?
It was some was the same, and I believe there was some additional information that some new, not new in the sense of being new as an age, but new as in had not been raised in the last motion with Judge Morrow. I believe there was some additional evidence.
You told Judge Hathaway that the brother, Emery Matthews, had walked back some of his testimony. Do you remember that?
I don't remember, no. I definitely could have. That sounds like a word I would use, but I don't know.
James Matthews has a sister, as well as having a brother named Emery. He has a sister too, correct?
Correct. He had a few sisters, and several of them were deceased.
Okay. Did any of the sisters talk to you about whether they would give testimony concerning admissions made by James Matthews?
Not that I recall, no.
Did you have one or more of the sisters endorsed originally on the information that prior to the prosecution in June?
We may have, yes.
Isn't it true that you did not call some of the family members, including the sisters, one or more, because they told you they would not agree that they had ever told the police about any admissions made by James Matthews?
I think there was only one sister still alive. And that sister, I don't know that I personally spoke to her. I want to say that maybe Sergeant Griffin or Lieutenant Griffin may have, and she may have expressed that to him, but I don't remember.
Do you recall what you told Judge Michael Hathaway about how you were going to get around the fact that Elmore Matthews was no longer available to testify to the admissions?
That who?
Emery Matthews. Does that help, or do you need me to repeat the question? Would you like me to repeat the question?
Yes, please.
Did you tell Judge Michael Hathaway, what did you tell Judge Michael Hathaway concerning whether or not you had anybody to come in and testify about admissions by James Matthews instead of Emery Matthews?
I don't really recall. I do know that we have 2 EMTs that have admissions from James Matthews, but I don't recall what I told Michael Hathaway.
You have 2 EMTs that have admissions by James Matthews of this murder, the murder that you tried in June?
I don't know if it's this murder, but it's he admits to murdering some women to them. Not to them, they overhear him in a cell. Admit.
In front of Judge Hathaway, can you pull that one up?
Is it the one?
That's Exhibit I.
Yeah.
Let me know when it's ready. We'll come back to the 404B information, but I want to ask you about, at the close of proofs. Oh, okay, it's ready. We're going to show you now the transcript from the hearing in front of Judge Michael Hathaway. This would have been September of 2019. Does that sound right in terms of the time frame?
Excuse me?
On the new 404B motion?
You said when?
September 2019.
If that's the date you have on the transcript, I don't disagree.
And Judge Hathaway called you out and asked, he said, isn't it true that one of the brothers had recanted? And here's what you said at page 14, line 14 on page 17 and continuing. Now, one family member we called at trial, the defendant's brother. He, I would say, backed away. I wouldn't say entirely discredited his witness statement, but he backed away from the statement and said that his brother never admitted to killing someone to him. Do you remember saying that?
I don't remember it, but reading the transcript, that sounds accurate, yes.
And
I
you
have
would-
not reviewed this transcript.
You believe that that met your duty of candor to Judge Michael Hathaway about the testimony that Emery Matthews gave?
Yes, and he had the trial transcript himself as well. And Mr. Noakes was there to refute any information I may have given that was not accurate.
But you agree with me, you can't rely on the judge knowing what's accurate and what's not accurate. You have to be accurate in the things that you say, right? That's your duty.
And I believe I was accurate in that statement.
Thank you. Next one. The court goes on to say, all right, as long as you understand, and I'm sure you do, you can't just use prior incriminating statements the witnesses gave. And you know, if they are unsworn statements, then of course they don't have substantive evidentiary value either. Do you see that?
I do.
And you responded, yep, correct?
Correct.
Did you understand that was the court saying, in essence, it had read the transcript, it understood how you used or attempt to use Officer Stupczynski the first time, and he wasn't going to put up with it another time?
I took it to mean exactly what he said there. I didn't read anything else into it.
Do you believe that you used unsworn incriminating statements as substantive evidence during the first trial?
No, I don't know.
Really? Okay.
Are you saying substantively in my argument, in my closing, or?
In your argument and in your rebuttal? Yes.
I don't know.
You had a police report where Mr. James Matthews said that he had not had sex with the decedent within the immediate time before she died. You remember that?
No.
Well, in direct examination, you mentioned it. You said that he had changed his story over time. He first said to folks that he had not had sex with her, or there was no questioning her originally. And then later in 2018, he said that he had not had sex with her.
It was in his interview, not a police report.
Okay. And there was a police officer who conducted that interview, correct?
Correct.
And that was in 2018, correct?
No. Well, there was a statement taken from him in 2018, but there were two additional statements in addition to those two. Or in addition to that one, there were two additional.
Okay. And when was that taken, if you know, that particular one?
I'm not sure.
Your Honor, I want to object to this line of questioning. It's not relevant.
There was testimony on direct examination about the non-traditional sex. This is where that comes in because there's a claim that he didn't tell the police that earlier, and he explains in his testimony what he meant, and he uses the not normal. So I'm just laying the foundation to get to that.
Any continuing objection, Ms. Weingarten?
No, no.
All right, thank you. You may continue, Mr. Campbell.
Thank you. And I'll try and lead you through this as quickly as I can, but as correctly as I can. James Matthews at some point told somebody he did not have sex with the decedent. That was your understanding, correct?
That he didn't know her.
Well, that was in 2003, you claim that's what he said. And then in 2000, sometime later than that, there may have been a statement that he didn't know her, but I want to focus on the time he said he did know her, but he didn't have sex with her because she was pregnant.
I don't know that. I don't know if I know what you're talking about, where you're talking about.
Do you remember when you cross-examined James Matthews while he was testifying about a statement that he had given where he said that he didn't have sex with her because she was pregnant?
I think I asked him about a statement he had made where he said that there was, he had not penetrated her or something along those lines. Yes.
Well, do you recall actually cross-examining him on the statement that he did not have sex with her? And his answer was, I never said that. I said I did not have normal sex with her.
Okay.
That sound familiar to how the case went?
I'm not certain, but it's something along whatever the scenario was. He ultimately denied that.
Right. You never asked him what normal sex was, right?
I don't recall. I don't think so. No.
Okay. And you never called a police officer to perfect, either for impeachment or for substantive purposes, that testimony. Nobody came in as a police officer and said, Mr. Matthews told me that he did not have sex with the victim.
We had investigator Special Agent Barbara Simon that came in, and she read the statements that he made previously back closer to the time of the homicide.
She read a statement from 2003, correct?
I don't remember the dates offhand, but for some time closer to the homicide, she read the statements she was present for.
Exactly. She was not present for the statement about whether or not he had sex, correct?
I don't know. That would have been in 2003. So I would say, yes, I thought she had.
If she was there, then is it that you failed to get that testimony from her in her testimony on rebuttal, or is it that she never heard those statements so could not testify to that?
I don't know that I don't think I'm following you. I don't know if I know what exactly you're asking me. I'm not following the question.
I'm asking you, why did you not produce a witness to testify that the defendant said the things you claimed he said during your examination?
I
You
believe that I
challenged
did.
him and said, isn't it true that you said you didn't have sex with her? He denied that. He said, no, I said I didn't have normal sex. But there's never a police officer or anybody else who comes in and says, I sat in the same room with James Matthews and he claimed that.
It was my position that we did, because she said that she, being a Special Agent Barbara Simon, indicated that they didn't know each other, I believe was the testimony. So I believe I did, is my response.
Were you surprised by the defendant's testimony when he testified?
No.
Were you not surprised because he would say anything to get out of murder, or were you not surprised because you knew what he was going to say?
I was not surprised because he got up there and gave a very confusing story that was moderately consistent with a mixture of his statements that he had made throughout the years. So I expected whatever he got up there to say to not make much sense.
Do we have volume 2, page 196, 19 to 22? Do you remember asking this questions at lines 19 through 21? Okay, now, Mr. Matthews, did you and Ms. Robinson have sexual intercourse on January the 9th or January the 10th?
Yes.
And he responded, yes, we did.
I remember that, yes.
We have the next one to show the following lines 23 and 25 on the same page.
I remember this line of questioning with him.
Thank you. Can you read that question that you asked him?
Question. Okay. Do you remember telling the police when you were interviewed on the 14th that Ms. Robinson wasn't able to have sex because she was pregnant?
So this is a time where you're asking him about statements to the police concerning not having sex, correct?
Yes.
And what is his response? If you can put that up, please. This is page 197 of volume 2, 1 through 3. Go ahead.
You want me to read it?
Yeah, I'll read it actually. It's his answer. She was pregnant. She couldn't have sex like we normally do because we didn't want her to abort the baby, which is why she had the miscarriage the other time. And so you were using the prior statement, one, to impeach his statement that he had previously said. It was a prior inconsistent statement to say that he had not had sex with her and was now testifying that he had sex with her, right?
Yes.
And you also, because he was a defendant and because as an admission, it would be admissible against him substantively, you wanted to use the information in the police report against him, correct?
The written interview statement. Correct.
Correct. In order to perfect that, to use it as substantive evidence, you would need one of the officers who was in that interview to come in and testify. I heard the defendant say those words.
Yes.
Correct? Your testimony as you sit here today, you think that's Officer Barbara Stinson?
Deborah Stinson was the evidence technician. My testimony is that it would be Special Agent Barbara Simon who took the interview statements. And I'm not certain that that's a verbatim excerpt from the statement she took, but that was the sentiment that I had gotten from the statement that I was cross-examining him on.
Do you remember being admonished by Judge Morrow when you tried to examine Mr. Matthews concerning his presence during the trial? You know what I mean by that?
Yes, I do recall.
Do you remember in your closing argument having an objection during your rebuttal?
Yes.
It was Mr. Noakes who made the objection, correct?
Correct.
And he objected because you were pointing at Mr. James Matthews while you were doing your closing, correct?
Or gesturing at him, yes.
And do you recall he specifically said that you were pointing at him like he was a thing? Do you remember that?
Yes.
And Judge Morrow sustained the objection, correct?
I think he said just be cautious of that or something like that.
One of the things that you talked about in chambers after the proofs were in and the jury was deliberating was Judge Morrow's approach and attitude towards things like pointing at a defendant in a case, right?
No.
Did he talk to you about how he does not allow, or prefers not, to have defendants referred to as defendants and rather by their name?
At some point. I don't know if it was in chambers.
Did he talk about the same thing with victims, that victims' names should be used and not just the word victim?
I don't recall him doing that for the victims, no. But it's possible.
Give me just a moment. I'm skipping over some areas. I'm happy to announce. Were you asked on June 12th, when you went back to the office, how the trial was going by anybody?
On June 12th, yes.
Who asked that?
David Champagne, I remember for sure.
Did anybody else?
Probably. That's typical of being in trial and cases. Prosecutors will ask you how things are going.
Did you tell him anything about the 404B motion?
Who?
David Champagne.
Not that I recall, no.
Did you tell him at all about Emery Matthews?
No. My conversation with David prior to that had been primarily focused on the DNA. So anything he was really asking was focused, kind of pointed towards the DNA.
Did you talk to him about the Sorensen lab letter that had been admitted?
There wasn't a chance to actually talk to David about content of the trial when we had seen him.
Did you talk to David Champagne about the fact that the defendant had admitted to having sex, which basically either confirmed the DNA in the best case, but in the DNA testing, but in the other case made it superfluous?
The only thing we talked to David about is when Anna told him what happened with the case. That's the only information we got on the 12th out, or the 11th, whichever day that was, the 12th. The only information we got out, he asked how it went. Anna told him what had happened.
You have mentioned in your direct that there was a time where you were interviewed by the commander, Detective Kinney, right?
Yes,
When she interviewed you, am I correct from what you said on direct that both you and Ms. Bickerstaff were in the same room being interviewed?
incorrect.
You talk, am I correct that you described on direct talking to Ms. Bickerstaff after the interview?
No, because
That's
we weren't
correct.
interviewed. No, we weren't interviewed together. The time that I think you're referring to is when Joanne Kinney called us back there to let us know she finished the investigation and then let us each read our paragraphs that she had drafted. We
Were you-
never interviewed by her together ever.
Thank you. Were you in the same room when you read your separate paragraphs together?
Yes, they
What-
weren't read out loud to my knowledge, though.
What room is this?
This is Joanne Kinney's office.
And how big is Joanne Kinney's office?
Oh, I don't know. It's a one person office. There's one desk in there
An
and some chairs.
office at the Frank Murphy Hall of
Excuse me?
Justice? A standard office at the Frank Murphy Hall of Justice?
A standard single person office, I would say. Yeah.
Okay. And is there room enough for a desk and a main chair for somebody to sit behind the desk and two chairs on the other side of the desk?
Yes.
So when you went in, were you in one chair and Ms. Bickerstaff was in the other chair?
Yes.
You were next to each other?
Yes.
How long were you in that room reviewing your statement?
Not long. I'm not sure. Less than 30 minutes.
Fair, 30 minutes for the paragraph?
I said less than.
Okay. How much? So it was more than 20 minutes
No, I'm saying I probably less than 15
for the paragraph?
for the paragraph. Yes.
And was Ms. Bickerstaff there sort of at the same time for the same period of time as you, coextensive? Or was she there before? How'd that happen?
We were both there at the same time.
And as the progression goes here, we know that your affidavit is signed on the 27th of June. We know that your memo is dated the 13th of June, correct?
Correct.
This interview took place between the two dates, correct?
No, incorrect. I want to say it was after.
After the affidavit?
I believe so. Yes.
Thank you. We know the date of the report is July 8th, 2019. So the interview took place sometime before July 8th, correct?
Correct.
And the time that you're in the office with Ms. Bickerstaff reviewing the draft, that is sometime before July 8th, correct?
Correct.
You know how much before or how close to July 8th it was?
I don't.
When you leave Detective Kinney's office, it's you and Ms. Bickerstaff together, correct?
Correct.
And what is Ms. Bickerstaff's comportment or demeanor at that moment?
She was concerned.
Could you tell she was concerned while in the office?
No.
What led you to believe, what did you see, or what did you perceive that led you to believe she was concerned?
It was only things that I heard. I can repeat the statements, but it's only things that I heard her say that made me know that she was worried or nervous. I can tell you the statements.
I'm sorry. What did she say that made you believe that she was concerned?
She said, I'm worried. Some of the stuff that Joanne put in here wasn't correct.
Did she tell you what stuff that was put in that wasn't correct?
She may have at the time, but I don't remember. I don't think she did. I'm not sure.
Has Anna Bickerstaff ever told you that she corrected to somebody other than you the statement that was in Detective Kinney's report?
We've never spoken about it since.
Did Anna Bickerstaff tell you that Detective Kinney had added a line that Ms. Bickerstaff felt Judge Morrow was trying to hit on her?
Objection, hearsay.
Response.
Yes. The council knows this is something that they gave to me as exculpatory information. So Ms. Bickerstaff now says that this part of the report was false. I'm asking this witness if it refreshes her recollection from the last question where she said she didn't know or maybe couldn't remember what it was that Ms. Bickerstaff had said when they walked outside the door. I'm trying to figure out if this is the line or if there's something else at the time that she recognized was also false.
Continued objection, Ms. Weingarten.
Yes, it's hearsay, regardless of what the statement was.
If I may, it's not offered for the truth of the matter. It's again, we'll have to recall Ms. Chiffone if in fact Ms. Bickerstaff ends up testifying contrary or different. And to me, the cleanest way here, we could do it on a separate record if you want, but I think it goes in the main record.
All right. So the objection is sustained.
We could go to a separate record.
All right, alternate transcript.
Okay, with the last question as well, Your Honor?
Yes, please.
Okay. Did Anna Bickerstaff tell you that Detective Kinney had added a line that Miss Bickerstaff felt Judge Morrow was trying to hit on her? Now let me get to the transcript. Just a moment. We're in the separate record.
Thank you.
May I answer?
Yes.
Okay. I don't remember. She may have said that specifically, but I can't recall. I just know that something in there or some things in there, something in there was not right, is what she said. That's all I know.
I'm ready to go back on the main record.
All right. Ms. Jorgensen.
Yes, just a moment, Judge. Okay, we're back on the main record.
Did you understand that whatever it was that Ms. Bickerstaff felt was not right in the report was important to be corrected?
I didn't have any understanding of it, but I thought if something was wrong, she should tell someone.
Did you give that advice to Ms. Bickerstaff?
Yes.
What did she say in response?
Objection, hearsay.
Again, doesn't go to prove the truth of the matter asserted.
Then why is he asking the question?
Because I want to move to the next element, but it depends on the answer to move to the next element of the questioning.
Objection is sustained. If you'd like to move to the alternate transcript. Actually, yes, because we just moved back to the main. So back to the alternate, please, Ms. Jorgensen.
One moment. Let me get the record and then I'll read the question.
Certainly, thank you.
What did she say in response? And we're in the separate record.
Thank you.
May I respond, Judge?
Yes.
She said she was nervous.
Did you follow up with any, well, we'll go, I guess we'll follow the separate record. Did you follow up with any questions about why she was nervous?
No.
Did you understand in your own mind why she was nervous?
Did I understand why Anna was nervous?
Yes.
Yes.
She was nervous to go back and correct a false statement by an investigator or detective from the Wayne County Prosecutor's Office, correct?
Objection, speculation.
Again, separate record, I believe.
We are on separate record.
I believe she found Joanne Kinney to be slightly intimidating. I don't know if you know investigator or detective Joanne Kinney. She's a very serious woman, and she's an older woman. And so I think Anna was nervous just because she is a little bit intimidating, I would say. If I had to guess why Anna might have been nervous to tell her.
That report went to your superiors, or at least the higher ups at the Wayne County Prosecutor's Office, correct?
Yes,
And you know, as you sit here today, it was not corrected, right?
I have no idea. Like I answered before, I don't know what Anna did or did not do after we had that conversation outside Joanne Kinney's office.
Did you feel any obligation to speak to any of your superiors in order to make sure Anna Bickerstaff did the right thing and corrected the false report?
Sir, I was trying to just get through it myself, to be quite honest with you. So no, I did not.
So you were willing to let false information go on so long as it didn't have any more impact on you?
No, what I'm saying to you is that Anna is an adult. She's also an attorney. If I give her a piece of advice, which is go back and fix whatever the situation is, I am not her caretaker. So after that point, when I have made my suggestion to her, I kept going. To be quite honest with you, I was going through a lot of stuff on my own with my own situation with this whole case. So making sure and following up with Anna that she followed through on things she was supposed to do on her end, no, I did not.
Did your situation with this whole case include the fact that your superiors were questioning why you had a hung jury as opposed to a guilty verdict?
No, my bosses were extraordinarily supportive and are extraordinarily supportive on cases in this unit, whether or not you get a guilty verdict, a hung jury, or otherwise.
I'd like to go back on the main record.
All right.
One moment, please.
Thank you.
We're back on the main record.
You may proceed.
Ms. Bickerstaff, did you believe that you had any responsibility, moral responsibility, to make sure that the superiors at the Wayne County Prosecutor's Office got accurate information?
I'm Ms. Chaffone, and I believe that it was my responsibility to make sure that I represented the information that I gave to my supervisors accurately, which I did.
Is it your position that you could allow somebody else to give false information and not have any responsibility for that if you knew the information was false?
Again, it's my position that I don't know what the situation is with Anna and that piece of information. I believe that everything that I needed to do with regards to my involvement that I had done at that point.
You did not alert any of your supervisors that Anna Bickerstaff may have kept truthful information from the report?
That was not my understanding of what had occurred. It was that there was inaccurate information provided by Joanne Kinney, not that Anna Bickerstaff provided untruthful, inaccurate information to somebody else. So I would say what you're asking is not entirely accurate.
Had you known that Anna Bickerstaff had not corrected the information with Detective Kinney, would you have acted?
Objection, speculation.
Response, Mr. Campbell.
I think it's a fair cross-examination question.
Objection is sustained.
Did you know, let me say it this way, you knew that the information that Anna Bickerstaff had that she should have given to Detective Kinney involved my client?
Certainly.
And you
Not
knew...
excuse me. Not that she should have given. I knew that whatever information that we were giving to Joanne Kinney was with regards to Judge Morrow. I don't know the other stuff that you said, I don't agree with. No.
So it stands to reason, right, that the information that Ms. Kinney got wrong, that Ms. Bickerstaff alerted you to, involved my client.
I'm not going to speculate. I don't know.
Do you remember the jury asking for certain testimony to be reread?
I don't remember. I wasn't present. Judge Morrow dealt with that without us being there. I was made aware of that after the fact, though, yes.
Let's be clear here. You may not have been aware of the note that came out, but you were aware before the testimony was replayed for the jury, right?
I personally was not, no. There was a prosecutor, I'm told, that was present, but I was not there, no.
And do you know which testimony the jury asked to be replayed?
I don't.
Did you talk to any of the jurors at the end of the case?
We did.
Who's
Myself,
we?
Mr. Noakes, and Anna Bickerstaff talked to the jury at the end.
Where did you talk to the jury when you talked to them?
There was a few different places. I want to say that Mr. Noakes talked to them somewhere in the hall, maybe. I think Ms. Bickerstaff talked to some of them in the hall, and I talked to a few ladies in the jury room or in the witness room.
What was the purpose for which you made your original memo? The June 13th memo.
To document what had occurred.
Did you do that on your own, or did somebody direct you to do that?
We were directed to do it.
Who directed you to do it?
Athena Syringas, my boss at the time, to make sure that we didn't forget anything that had happened, and told us to summarize the events.
When you're later interviewed, you've already done the memo, you've already done the affidavit, correct?
By Joanne Kinney?
Yes.
Yes. I don't know. I can't say. I want to say yes. I think that the affidavit and the memo were prepared in advance of any interview by her, but I can't say that for certain.
When Ms. Kinney interviewed you, Detective Kinney interviewed you, did she tell you why she was interviewing you?
Yes, I don't know if she told me then, but I had an understanding of why I was there.
What was your understanding?
That our office was investigating the claims that we had made to substantiate or disprove them.
And who gave you that? Where did you get that understanding?
I'm not sure.
Were you aware when you were interviewed of the efforts to disqualify Judge Morrow?
I think that I think that the interview came somewhat later. So I can't say. I don't know. Because I don't know when it all fell time-wise. But I was aware that there was going to be a motion to disqualify him.
Hold on a moment. I'm looking for the date on the motion to disqualify. The date of the motion to disqualify is June 26, 2019. Does that help you recall whether or not at the time of your interview the motion had been filed?
I don't know the date of the interview, so no.
According to the report, which is also an exhibit if you want to take a look at it to refresh your memory, it says that you were interviewed on June 17th.
Okay, if that's what Joanne Kinney's report or notes say, that was the date she interviewed me, then I believe that Joanne Kinney would have put the correct date.
So you understood at the time of the interview that this was part of the disqualification process that was going through at the Wayne County Prosecutor's Office, correct?
No, incorrect.
You thought it was separate and distinct?
I thought that this was our office, just like I had said. I thought this was our office investigating the memo or report made by Ms. Bickerstaff and I to determine its validity.
So your office ordered you to make the memo and then it investigated the validity of the memo?
They didn't order me, no.
Didn't you say that Ms. Syringas is the one who ordered you to make the memo?
I wouldn't say ordered. She said that I think you should all write a memo. She didn't say, go back to your office, write a memo now. That would have felt like ordered to me.
Is that memo that has been turned over to the JTC, is that the first draft of that memo?
Yeah, it was the only draft.
Did you show that memo to anybody else before giving it to your superiors at Wayne County?
No, not that I recall.
In your memo, you do not use much of the language that Ms. Bickerstaff does. Do you remember that difference between the two memos?
I've never seen her memo, so I couldn't tell you.
At the time that you are in the courtroom where Judge Morrow originally states what he thinks your height is, you remember that?
Yes,
Where are you standing?
near the prosecution table,
On which side of the prosecution table?
closer to the jury box, towards like the front of the prosecutor table.
And where is Ms. Bickerstaff?
I want to say that she was either at the seat where she had been sitting throughout the trial, but standing behind this chair, or at the seat where I had been sitting, but standing behind the chair. She was packing stuff up. So we were right in that area.
And where was Judge Morrow?
He was, I believe, kind of on the, like near where like the witness stand would be, but like out front on the floor, the main floor, near where we were.
You're aware of the charges in this case being that Judge Morrow overtly eyed you and Ms. Bickerstaff. That's the phrase that is used by the prosecution, overtly eyed. Have you read that before in their complaint?
I'm not sure. I've read the complaint, but I don't know if I remember that language. I know I don't know that that's not language I've used.
Do you think that's an accurate description?
Overtly in the sense of purposefully, do you mean, or how so?
Improperly.
I think that the whole encounter with regards to the height and the weight situation was entirely improper. And you can
But you
toss
don't-
in how he looked with his eyes as part of that whole thing.
But you've never said to anybody, he overtly eyed me, correct?
No, I've never used the word overtly eyed or the phrase overtly eyed.
You've met Laura Weingarten?
Yes,
In fact, she used to work at the Wayne County Prosecutor's Office, correct?
yes, correct.
And she's now the prosecutor, the disciplinary counsel here, correct?
Correct.
Have you ever texted with Laura?
Yes.
Okay, when's the last time you texted with her?
This morning when she told me to wait for a phone call to know when to log on.
And when's the last time before that?
I asked her if I was allowed to keep my resume out because I was worried about messing up my dates with my employment.
In terms of how often do you, or how frequently do you text Ms. Weingarten?
Very infrequently.
Did you talk to Ms. Weingarten between the time that the request for investigation was filed and when the formal complaint was filed in this matter?
I'm not even sure I know what that is, but I didn't talk to Laura until like way down the road. So I don't know like the process or anything once it went past my office.
Fair to say you didn't talk to her until approximately September of this year.
I honestly couldn't even tell you, but later, much later.
Laura Weingarten never asked you whether or not you would agree with the term overtly eyed, correct?
No, we never talked about that.
Any moment. You've read the transcript in connection with preparing for the new trial and in connection with the fact that you're testifying in this proceeding, correct?
Correct.
Did you identify any part in the transcript where you believe Judge Morrow treated you improperly?
I don't know that I went through it looking for that specifically, so I I couldn't say.
So you do not have any place that you could point us to in the transcript where Judge Morrow treated you improperly?
At this today, right now, no, I don't have anything I can pull up. I don't have the transcript to pull up and show you anything. But I will say that most of the improper conduct that I observed occurred outside of the record.
Who else was a witness to that conduct?
Anna Bickerstaff, William Noakes, the defense attorney. I don't know what other people in his courtroom may have overheard with the situation with Ms. Bickerstaff when he came to sit at the prosecutor table. I don't know what, if any, people in the courtroom overheard any of the conversations with me being tough enough, with me not being like a good enough person to work with. I don't know who heard any of that. I couldn't say.
You think it was improper for Judge Morrow to say that he didn't think you were tough enough to take his assessment?
I think that it was in line with the rest of the conduct of Judge Morrow.
I don't understand that in light of my question. So I'm going to ask that that response be stricken and that the question be reread.
One moment. Do you think it was improper for Judge Morrow to say that he didn't think you were tough enough to take his assessment?
May I answer, Judge?
Yes, please.
Yes, given the rest of the circumstances that occurred with him, yeah, I do.
You described in your direct examination that when you returned from the lavatory after the testimony of Dr. Galita, that, excuse me, I think it's after the testimony of Dr. Galita, that there was chatting and talking going on between Judge Morrow and Ms. Bickerstaff. Do you remember that?
I don't know. I'm not sure the wording I used. I can take a look at my statement. I don't remember qualifying it as chatting and talking, but I can, you want me to look?
No, that's, again, you have your testimony from this proceeding, because that's the one I'm talking about.
The testimony from today?
Yeah.
No, I have no testimony from today.
You don't remember saying chatting and talking, referring to your returning from the bathroom and sitting on the bench a foot or so away from the conversation that was going on between Ms. Bickerstaff and my client. You don't remember saying?
I recall that my statement was, I came up and I believe it was either your question or Ms. Weingarten's question about what did I think was going on, or what did I think, or something like that. And I said, I walked up initially and I thought to myself, before I overheard anything, like, what's going on with like the chatting and talking? Like, we're moving through this, like what's going on? Then I sat down. So I wouldn't say that I walked over and they were jovially chatting, talking casually. That is not what I observed. So that's not accurate.
So if you said it, you weren't accurate when you said it earlier.
If I said it with regards to what was going on between Judge Morrow and Anna at the point in time when I got back from the bathroom and sat on the bench and observed what was happening, that was not chatting and talking. So if I did say that, then that was absolutely incorrect.
Thank you. I'm going to ask just to be careful here. We're on the main record, correct?
Yes, we are.
Thank you. I want to talk to you about Rule 6.419.
Okay,
That is entitled in the court rules, motion for directed verdict of acquittal.
correct.
That's the motion you mentioned in your direct testimony, correct?
That was the one that I went back there and Judge Morrow had two books open and handed it to Mr. Noakes and I. Yes.
Mr. Noakes made a directed motion for acquittal, correct?
Yes, he made a motion for a directed verdict.
And you argued to the judge that the standard he should decide the case on was whether or not, taking the evidence in the light most favorable to the people, whether or not the case should be dismissed, right?
Whether there was sufficient evidence to take the case to trial, if it should be dismissed, correct.
Wait a minute. So you're saying, I think we're saying the same thing, that the people get the benefit of any doubt and all the evidence has to be viewed in their light, the light that's most favorable to the people, when the judge decides whether or not there's going to be a directed verdict of acquittal, right?
Correct.
As you sit here today, do you know that that's not the standard?
No, I still believe that that is the standard. I am not familiar with what Judge Morrow referenced in his office, which was that a trial judge can dismiss your case at any time, even after the jury's rendered their verdict. I was not familiar with that.
So are you familiar with 6.419?
I am now. I wasn't prior to Judge Morrow showing that to me.
So you answered a motion that you didn't know the basis of that motion. Is that fair?
No. When are you talking about?
There was a motion for directed verdict of acquittal made by Mr. Noakes.
Yes, and I was aware of what the standard was. So no, would be my answer.
And the standard you thought was the evidence needed to be taken in the light most favorable to the people, right?
I believe that is the standard. I believe what the judge was showing me was what the judge has discretion to do with the directed verdict motion. So I believe the standard was still proper. I believe what he was showing me was what he had the power to still do with my case, which was, as he made very clear, dismiss it.
The rule reads, after the prosecutor has rested the prosecution's case in chief, or after the close of all the evidence, the court on the defendant's motion must direct a verdict of acquittal on any charged offense for which the evidence is insufficient to sustain a conviction. You understand those words, right?
Yes.
And in order to sustain a conviction, you must prove all of the elements of a case beyond a reasonable doubt, correct?
That's what that standard says, correct? Or that's what that rule that you just read in says, correct?
So if the motion is for directed verdict of acquittal, it is the wrong standard to say that the evidence must be viewed in the light most favorable to the people.
I would
Because it has to
disagree.
be viewed, if I may finish the question, it has to be viewed as whether it is sufficient or insufficient to sustain a conviction. Correct?
I would say, I would still say that the standard is to view the evidence in a light most favorable to the non-moving party. My understanding of what you're reading now is that that is the judge's, that says that that's what the judge's discretion is. That's my understanding.
Do you believe, or let me say this, am I correct? Judge Morrow correctly stated the standard that a judge needs to apply when considering a motion for directed verdict of acquittal.
I don't know. I know that he presented me with that rule.
Right, and he not only presented it to you, he asked you to read it, right?
Yes,
And you did read it.
yes.
And then you had a conversation with him about what those words meant and
It wasn't
why.
Conversation, no,
You're saying that was not a conversation.
correct.
That was
It
not
wasn't.
not what you were arguing about with Judge Morrow.
There was no argument. It wasn't an argument. I walked in and the book was open to a particular page and he said, I want you to take a look at that. He handed it to Mr. Noakes. He handed me a book. I read that. He said, do you know what that means? And I stared at him. And he said, that means I can dismiss your case at any time. There wasn't a dispute. There wasn't an argument about it. It was what he said right when I walked in the door. That he said, this is why I called you in here. So to me, I took that to mean he called me in there to tell me that he could dismiss my case at any time.
That was your understanding of him trying to educate you on a court rule that you didn't know.
That was my understanding, yes.
And on an error that you made answering to a defense motion.
Is that a question?
Yes.
I don't believe that he was trying to educate me. It felt like he was trying to tell me he could dismiss my case at any point. It didn't seem like do you understand how this rule is wrong, or this rule that you stated doesn't apply because of X, Y, Z. That it wasn't a conversation. It was a statement made. And the message that I got from the statement was what I just told you, which was that he could dismiss my case at any time.
The jury was deliberating at this time, right?
Yes,
You have told your story now in writing. You have told your story in a memo and in an affidavit. You came in here and you testified. I haven't heard you say once, except for this circumstance here on showing you this rule, that Judge Morrow ever, for a second time or again, threatened to dismiss the case in any way, shape, or form. Am I right that other than showing you this rule and your interpretation of what he was doing, he never said, I will dismiss this because you're arguing with me, for example?
he said I could dismiss your case at any time.
Right, he said that once, right?
In chambers, yes.
Okay, you were there for 2 hours, right?
Correct.
In the whole remainder of the time, he never said, I could dismiss your case for anything.
No, he didn't.
But that's what you focused on, right?
That's what I got out of that initial portion. Yes.
Oh, and you said that's what made you stay in that room, right? It was the fear that he was going to dismiss your case if you got up and walked out.
That was one of the things.
Well, how big a deal was that? I'm trying to understand how it is that you're claiming that the reason you stayed is because you were at a court rule and he said something to you, and that made you stay in a place you didn't want to be?
There were several things that made me stay, but yes, that was one of them.
Part of the reason you stayed was to argue with him on other issues, right?
Not right. No.
You didn't argue with him that your voir dire was good?
No.
You didn't argue with him that your questions were good to the witnesses?
No.
You didn't argue with him that the DNA evidence was necessary or important?
I did. I wouldn't say argue, but we got into back and forth. Kind of, he said one thing, I kind of countered it. The rest of that stuff, though, other than that, that was the only back and forth conversation. The rest of it wasn't an engaging conversation, a response. It was him talking.
For 2 hours?
Yes.
Without you putting in a word edgewise?
Very little. After the back and forth about the DNA, very little.
You would agree that Mr. Matthews, no matter how many other potential cases existed, as you testified in direct examination, that in every case that exists, he's entitled to due process.
Correct.
And he's entitled to a fair judgment based on proper evidence.
Correct.
And your job is not to win the case, it's to try the case properly. Correct?
Correct.
You did your memo. You remember that you didn't say in the memo how you felt
About what?
about anything.
That's probably true.
You did the affidavit, right?
Yes.
And you didn't say anything in the affidavit about how you felt.
I think I characterized his conduct as inappropriate.
You think you did that in the affidavit?
Yep. On page 2, I said that he made several inappropriate sexual comments.
We read in the transcript where Judge Morrow during voir dire told you that you should ask the question that you intend to want to know the answer to. Do you remember that when you were done with your voir dire and said, how did I do on time?
Yes.
And you then followed up with a question that was directed to a point that you wanted to know, correct?
Correct.
The example he gave in chambers of if you want to know whether somebody will sleep with you and you on a date or whatever the example was, the question to ask is, will you or have you slept with somebody on a first date? That was essentially the hypothetical, correct?
That was one of the points he made in that hypothetical.
It is the same point that he made in front of the jury when he asked you, have you asked the question that you want to know the answer to? Right?
Wrong. I would disagree.
Give me a moment. Judge, can I have, I think Ms. Weingarten got 10 minutes, or maybe it was 5, I can't remember what it was, to check with Mr. Helland if I could have the same courtesy of however many minutes with Ms. Jacobs.
Certainly, and Ms. Jacobs is there in the room with you, correct? So you don't need to be put in another room. You just need to go mute.
That's correct.
All
We'll
right.
probably step out, Judge, of this room here, and we'll be right back in. Is 10 minutes okay, or should I make it 5?
No, 10 minutes would be fine. It's 5:07, so can you be back by about 5:15?
Yes, Your Honor.
All right, thank you.
Thank you.
I thought I checked the 419. So now I'm gonna read it here.
Yeah, I got it.
You got it right there, I'm gonna look at it. Because everybody seems to not. Don't you bother, you already know what it is. I'm figuring out what I did with my glasses.
Thank you. It looks as if everyone is back. Mr. Campbell, additional questions on cross-examination?
Yes, if I may.
Yes, go ahead.
I sent you an email on November 6th, 2020 at 3:36 p.m. I indicated that I represented Judge Morrow. Do you remember that?
Yes.
I asked you for the opportunity to interview you prior to the hearing set for Friday, correct?
Yes.
I told you, although I had a preference for doing it in person, I would be available to talk via Zoom or by phone, correct?
Correct.
You responded to me about, well, at 5:09 on the same evening, correct?
Yes.
And you said, based on my conversation with Laura Weingarten, it is my understanding you have been provided with documentation related to statements made by me in this matter. I anticipate my testimony being substantially similar. Is that correct?
Correct.
Had you prepared your testimony with Ms. Weingarten prior to sending this email?
She had called me and told me what to expect and talked to me about what was going on. So yes, to some degree.
Okay. You'll agree in all of the documents that I got. Let me ask you this. Are you aware of any documents that talk about how you were treated off the record or on the record by Judge Morrow, other than those 3 conversations, 2 of which, or 1 of which you weren't even a party to? Are you aware of anything else? Because you've talked about a lot of off the record things were not proper, but I have never seen that written down anywhere. Have
I'm
you?
not following you. I'm not sure what you're.
You recall testifying that my client didn't treat you well off the record.
Today.
Today you testified to that, correct?
Are you saying today? I'm not understanding your question. I'm trying to follow.
Oh, wait a minute, wait. Have you seen my client today off the record?
No.
Okay, so no, I'm not asking about today off the record.
But I'm asking, are you asking me about if I said that today? That's what I'm asking. Did I say that today?
Yes, you did. Yes, that's what I'm saying. You don't remember saying that? We just had a whole conversation about any place on the record where he mistreated you. And you said, I don't know of any. And then I said, and then you said you offered, it was all off the record. And I thought you meant things beyond the 2 conversations that you were involved in that are charged in the complaint. Is that all you're talking about, is those 2 conversations?
Are you asking if I ever had any other inappropriate contact with Judge Morrow prior to this?
I'm asking if you've testified to any inappropriate contact with Judge Morrow other than those 2 conversations.
I have not testified about that today. No.
Okay.
If you're asking me if I had other contact with Judge Morrow that was inappropriate, that's a different question though.
That's not a question that I've asked you. That's not a field that I've gone to ask any questions about.
Okay.
I am asking you, however, that when you spoke to Ms. Weingarten, was it between 3:36 p.m. and 5:09 p.m. on November 6, 2020?
We may have spoken in between. Actually, we did speak in between. Yes.
Yes, you did. Right. What did Ms. Weingarten say?
When?
Between 3:36 p.m. and 5:09 p.m. on November 6, 2020.
I called her.
Wait, hold on. For the record, Judge, this is hearsay, but in the interest of fairness, I do not object to it.
Thank you, Ms. Weingarten. I appreciate it.
Thank you.
I called Ms. Weingarten after receiving your email at the end of the day on Friday.
Hold on. As a counter, I think it's a party admission, so I'm not so sure that it's hearsay, but go ahead and answer the question.
So I received your email very late on Friday afternoon last week. I contacted Ms. Weingarten and indicated to her that I was extremely busy the next week, that I didn't feel comfortable talking to you, and was I obligated to do so? And she indicated that she couldn't tell me one way or another, that it was my decision to make, that if I wanted to talk to you, I could. If I didn't, that was my choice to make, but that she would leave whatever it was to me, and that just to let you know.
Is there a reason you called Ms. Weingarten?
Yes, because I needed to know if I had an obligation to respond back or meet with you, I guess I would say.
You told me in your email that you were concerned or you wanted to prevent anything from being misconstrued. You remember
Correct.
that?
Yes.
Or there being any misapprehensions, correct?
Correct.
You know that anything we talked about or conversed could have been easily recorded, correct?
It could have, sure.
You said you were only comfortable having contact with me on the record with all parties present, correct?
Correct.
When you say you were only comfortable with me, it's not because of me personally, I assume, correct?
No, I didn't know you or don't know you.
Right. And so when you say you were not comfortable having contact, what is it that would make you uncomfortable about speaking to a lawyer in a case that's pending where you're a witness?
Because we do this, I do this a lot for my job. And a lot of times when witnesses say things that aren't in the presence of all of the parties, it can be, just like I said in my email, misconstrued. There can be misapprehensions about it. And I just preferred that any contact that you and I have to prevent that from occurring happen here as it is now.
Are you aware that Judge Morrow has acknowledged that he had a conversation with Anna Bickerstaff between or after the testimony of Dr. Galita?
I have no idea what Judge Morrow has admitted to. It seemed like from his response that he admitted to most of what he said.
In light of that, do you agree that your concerns about it being your word against the judges was misplaced?
His response, I would say, came out a couple of months ago. So my concerns back in June of 2019, I think were still legitimate. And I still think that it would be legitimate.
You were concerned that the concept of a person as a judge might lie and thereby get some sort of advantage over any claims that were made by you or by Ms. Bickerstaff, correct?
That the judge might what? Sorry, I couldn't hear that word.
A judge might lie, and by virtue of being a judge would get some sort of credibility greater than either you or Ms. Bickerstaff, correct?
Well, I wasn't worried about a judge. I was worried about Judge Morrow specifically, but yes.
To your knowledge, he's not lied at all relative to any of the incidents or circumstances or conversations that took place, correct?
I have no idea what Judge Morrow has done. From the portions of the complaint I read, he seemed to admit all the conversations that I alleged he had in chambers. And it appeared as though he was admitting to what Ms. Bickerstaff said as well.
Thank you. I have no further questions for the witness at this time. Thank you, Your Honor.
All right, thank you. Ms. Weingarten?
I only have about 10 minutes, Judge, and then we're done. Ms. Chiffon, did you ever talk to Judge Morrow's court reporter about the fact that he wasn't recording everything that was taking place?
No.
You said earlier that you had some difficulty in getting the transcript of the trial. Is that right?
Yes, not me specifically. I didn't really head that up, but Anna would know more about that, and Anna was kind of the one requesting that. But yes, there was some pushback on getting the transcript.
Okay, we'll save that question for Anna then. When I was an assistant prosecutor, were you and I friends?
No.
Were we just simply former co-workers?
Yes, and I don't even know that we had much contact at all, even then.
Right. In the homicide unit, how closely supervised were you?
They supervise us in the sense of charging decisions. You have to get your charging decisions approved. Otherwise, they give you a lot of latitude. They supervise you so as to not, make sure that you're not going, if you have issues that you're not kind of going off on your own or anything like that. But I guess they give you a lot of discretion. I mean, it's the homicide unit. So by that point, you've made it through several units, and they, I think, give you the benefit of the doubt in knowing that you can exercise your discretion.
Do your supervisors know all the facts of all your cases?
Yes, mine, yes.
Do you get into trouble if you lose a case?
No,
Do
No.
you get a raise or a promotion if you win a case?
no,
Does anybody keep track of your wins and losses?
no,
Do you ever feel like you have to hide your mistakes from your supervisors?
no.
Now, after this was reported, you said that Athena Syringas filed a motion to recuse Judge Morrow,
Yes,
and you said it was administratively granted or the case was transferred out of Judge Morrow's courtroom.
yes.
Who did that?
It was my understanding that Judge Kenny had the case administratively moved.
Who is Judge? I'm sorry, go ahead.
Two cases, this James Matthews case, and then I had a 2-defendant murder case that was also pending in front of Judge Morrow at the time.
Who
And I
is
believe
Judge?
that, oh, sorry.
Oh, go ahead.
I
Sorry.
believe that was moved also.
Okay. Who is Judge Kenny?
The Chief Judge of Third Circuit Court.
And is he's the highest ranking judge of the Third Circuit Court?
Yes.
Have you ever had a conversation with Judge Kenny about what transpired with Judge Morrow?
Not in any details, no.
Have you had any kind of conversation with him about it?
Yes, just in the fact that the case.
Any contents to the conversation, that would be hearsay.
I'm just asking, did she have a conversation, not what was said?
She answered that part. She said yes, but then she began to relate, I believe, parts of the conversation, and that's what I'm objecting to.
Okay, if that's the case, I agree. Do you know the date Judge Kenny transferred the case from Judge Morrow's courtroom?
I think I have the order. I could look at it. I could take a
Also,
look.
can you stipulate just to save time?
What's the date?
July 19th, 2019.
Yes,
I'm sorry, July 12th. July 12th, 2019.
yes.
Okay. And did you have any say in which judge the case was reassigned to?
No,
When you went to Judge Michael Hathaway's courtroom for the first time, did you discuss whether or not you can file a 404B notice in front of him?
it wasn't specifically with regards to a 404B notice. I believe Judge Michael Hathaway had asked, were either parties going to file any trial motions?
And
Yes.
were you aware that this issue of the 404B could be relitigated before a new trial judge?
I was not aware at that time, no.
How did you learn that?
Someone had commented that
Object to the hearsay?
Well, okay, let me say it this way. Whose idea was it that you refile in front of Michael Hathaway?
I'm going to object to the hearsay.
Response, Ms. Weingarten.
I don't think I have a response, Your Honor.
Objection is sustained.
Did you eventually file the 404B in front of Michael Hathaway?
yes,
And was it granted?
it was. It was, but I believe he kept out. He kept a couple of things out.
Okay, so have you seen 2 orders signed by Judge Michael Hathaway relating to your 404B notice?
Yes,
And counsel, can we stipulate just to save time?
Yes,
Okay, is there one order dated September 23rd, 2019?
yes,
Okay, where Judge Michael Hathaway allowed the 404B evidence as to the New York City, denied it, I'm sorry, denied the 404B evidence as to the New York City CSC case?
yes,
Mr.
Okay.
Gamble, you stipulate to that?
I'll stipulate to that.
And is there another order dated September 23rd, 2019, where Judge Michael Hathaway granted as to 2 homicide cases, one in Michigan and one in New York City?
yes.
I'll stipulate to that too.
Okay. Have I ever talked with you about whether or not Judge Morrow looked your bodies up and down as he was discussing your height and weight?
Yes.
And you said earlier you didn't use the words overtly eyeing. What words did you use?
I don't remember, but I can tell you that the sentiment was overtly eyeing.
Are you familiar with a case that describes what the standard is for to argue against a motion for directed verdict?
Yes.
What is the name of the case?
Oh, no, I don't know the case offhand.
But you know the standard.
Yes.
Thank you. I have no other questions.
Thank you, Mr. Campbell.
Thank you. Briefly, if I may, as
Yes.
a recross, what does overtly eyeing mean to you?
Improperly eyeing.
What
Like,
does improperly eyeing mean?
I would say that anytime a judge is looking you up and down for any reason, I would say that that would be improper. So that's
Any
what it means to me.
reason to look at somebody up and down is improper in your view?
Not anytime, this particular situation.
Okay, what about this particular situation? Yeah, let me withdraw that and ask another question. When he guessed your height, he wasn't right, correct?
Correct.
He made you taller than you actually were, correct?
Correct.
So do you think in overtly eyeing you, he's just so bad at height that he would get that wrong?
I think that there was no reason to bring that up at the point in time that he did. So I don't really know.
Okay, but if somebody's overtly eyeing you, you think that they would be able to get closer than Judge Morrow did on just how, pardon the expression, short you are, right?
No, I'm not very good at height either. So I could overtly eye someone, which I would not, but I could overtly eye someone and still get it terribly wrong.
I know you could, but you think Judge Morrow would get so far off?
I can't say. I
Then-
don't know.
Ms. Bickerstaff, when he makes the, no, I'm asking a question. When Judge Morrow incorrectly and almost ridiculously picks a height for you, then Ms. Bickerstaff says what?
She says her height for context. She says
So-
I'm 5'3" for context or something like that.
And did you look at her and say, Anna, don't do that? Why are you talking to this man about height?
No,
Did you think it was improper for Anna to talk about her own height?
no. I thought it was unnecessary, but
I have no further questions. Thank you.
All right, thank you. Council, do we need to have a discussion with respect to our next day before we finish, before I let you go today?
I
I
have
don't
nothing to say.
Have a conversation now, no.
All right. Well, we know then that we are done with this witness, and the next witness will be called on the 23rd of November. We plan to start at 9 o'clock. I would ask council to come in by 8:30 as we did today. And I think that is it right now. I need to send you the link for the 23rd, and I will do that. Right? Is there any? Yes, go ahead.
Is Ms. Chiffon still on this Zoom call?
I am.
Okay.
I can get off though. I just wasn't-
No, I just want to stress that you're still under the sequestration order in case either party needs to recall you.
Yes.
All right,
Thank
thank you. Is there anything else from either council? Mr. Campbell?
No,
Anything
thank
else?
you, Judge. Thank you, Ms. Chappone. Thank you, Elsa.
All right. Thank you, Ms. Jorgensen. Appreciate that. And we are done for today then. Thank you so much.
Thank you.
Your Honor.
All right.